Yes. In case my lords takes up the Lodha first, to my hopes are Mr. Ghosh's matter may take up. I have to give my rejoinder. Mr. Kaur will take an hour.
Keep somebody.
I'm stuck till 12. So if I have to give my rejoinder after reply, I may be.
You don't mention that, Mr.
I want to tell that myself.
My lord will kindly allow me to be online today, my lord. Kindly.
Yes, to appear online, Mr. Rai.
Appear online, my lord.
Yes, absolutely. Leave is always
very
good.
good. Very
Not
good.
taken a leave for that. Yes.
You
want to mention something?
Yes, Milord.
Yes,
With
yes.
great, Milord, risk and trepidation, Milord, may I request for my lord's leave to mention a matter before
Come to the point, Mr.
on 22nd, Milord.
Yes.
I will pray when your lordship sits singly, Milord. I shall pray for Milord not today in one matter for personal reasons, Milord.
Inform your other side, Mr.
I have
Chaudhary.
taken consent from Mr.
Let it
Shah.
appear in the list because we have.
Yes, Milord. I'll pray on that. Milord.
You need to mention for that, Mr. Chaudhary.
No. Very serious matter. She was Milord.
Unless seriously opposed to them,
No,
ever refuse.
Government is
It
not
should.
opposed, my lord.
No, even if you oppose, no problem. If you seriously oppose, then there will be difficult. Yes. Call on the list.
My lord, may I be permitted to one matter, my lord, for inclusion recalling application?
Absolutely, it must be on the appellate side.
Lordship, may I be permitted to mention one?
On your side.
No, ma'am.
Come back.
May I have your lordships kindly to mention a matter on the appellate side?
No, you don't. Come back.
Very well.
When you take up the appellate side.
Very well. I'll be.
Yes. Then, fine.
9-10.
Yes. Mr. Roy was arguing.
No.
It's a different 10:30. Fixed at 10.
Yes.
I am led by Mr.
My lord, I am being led by Mr. Diwan. My lord, Mr. Dhruv Diwan, he is on his way.
Very well. Yes. এই নোটস গুলো দাও আমার এটা ফার্স্ট টাইম আসছে পাঠার রয়েছে ওহ রাইট সরি ইয়েস সরি মিস্টার মুখার্জি ইয়েস প্লিজ
Milord, Milord, may I, Milord?
Please.
Milord, this is an order, Milord, passed, Milord, in a section 34 application. Milord, the respondents, Milord, had challenged, Milord, the award. And Milord, one of the grounds, Milord, in the section 34 were, Milord, of fraud, corruption, and bias.
That matter, understand now. Arbitration and Conciliation Act. Yes.
Now, Milord, I just want to show the circumstances, Milord, under which, Milord.
You took out the section 34, Mr. Mukherjee.
Beg your lordship.
You took out the section.
No, not me, Milord.
Yes, section 34 was allowed.
Correct. So, my lord, one minute. So what happened was, my lord, these were the grounds which were taken. So, my lord, when the section 36 was filed, my lord, one of the exceptions to furnishing security is, my lord, if the award has been procured by fraud or corruption. Lordship would recall, my lord, kindly have a look at section 36.
This is where Mr. Kapoor was.
Correct.
Before we start, we shall make it clear that we know Mr. Kapoor very well. If either party has objection, Mr. Diwan is there online.
No, my lord, he's on his way.
So we are making it very clear. He'll physically appear.
Yes.
We are making it very clear that we know very well the arbitrator. We knew very well the arbitrator. We had great respect for him also, and we know his son also because he's a colleague. So if either of you have any objection, you can take it right now, not when you start the matter.
Yeah.
Very sure.
Because probably that applies to most of the judges.
Yes.
So if you have to have it heard in Calcutta, then probably. Yes. সবাই কাপুরকে চিনতো, সবাই রবিকে চিনতো.
My lord, my instruction is, my lord, that we do not have any instructions to oppose or any.
Mr. Mukherjee, obviously, no, not obviously. Very well.
Yes.
I
because we record that in our order, that we made it clear that we know the arbitrator and his son, maybe we may not miss. Anyway.
And, my lord, the important thing is, my lord, no party has an objection, my lord. Kindly, my lord.
That is what we record in today's order.
The instruction is not, my lord, to that effect. Instruction is, we have no instruction on
It's
this.
a double negative sort of.
Yes.
Yes.
My lord, we do not have any objection. I can say that. Yes, my lord, we do not have any objection.
If you had any objection, Mr. Diwan wouldn't be coming so.
Yes, my lord. So,
Yes.
Now, my lord, kindly have a look at, my lord, section, my lord, 36.
Right.
My lord, 2, my lord, the second proviso, my lord, after, my lord, the code, my lord, is made, my lord,
Yes, Mr. Mukherjee.
kindly see the second, my lord, proviso, provided further
Yes.
that where the court is satisfied that a prima facie case is made out, that the arbitration agreement or contract which is the basis of the award or the making of the award was induced or effected by fraud or corruption, it shall stay the award unconditionally pending disposal of the challenge under section 34. So, my lord, when this section 36 was filed, my lord, exemption from, my lord, putting in any security, my lord, was sought, my lord, by the respondent on the basis, my lord, that the award was procured by fraud and corruption.
All right.
So, my lord, there were also grounds, my lord, in the section 34, my lord, to the effect, my lord, that there was fraud, corruption, and bias. And therefore, my lord, the learned judge passed an order, my lord, that this issue would be decided as, my lord, a preliminary issue, my lord, in the section 36. And therefore, my lord, in the 34 also, my lord, it would be decided as a preliminary issue. I just want to show your lordships, my lord, that order, my lord, which is in volume 14, my lord. Page 1729, my lord.
Now here we are hearing a section 37 is a section 34 final order.
Yes, my lord, it's a preliminary order.
Oh,
Because, my lord, on this issue.
So that was directed to be heard as a
Correct,
preliminary.
that's what I want to show your lordship.
So need not. I mean, unless that order has some significance otherwise. You can give us the page number,
My
Mr.
lord, it's, my lord, my lord, volume 14,
Yes.
page, my lord, 1729. My lord, I'll just read it out, my lord. It'll
Yes,
take
yes.
2 minutes. My
Yeah,
lord.
otherwise, this will logistics will take.
No, okay, I'll just read it out,
Yes.
my lord, so that
Yes.
this court has indicated to counsel that the preliminary question of the end of the mandate of the learned arbitrator for having appeared for an alleged sister concern of the award holder during the pendency of the proceeding, as argued in aid of the application under section 36, is also a preliminary issue in application under section 34. Substantial arguments advanced by Mr. Kohli and Mr. Ghosh is in reply. The preliminary question in the application under section 34 shall be heard along with the application under 36. The parties shall exchange note, etc., conclude arguments, etc. So, my lord, this is really, my lord.
It was actually allowed on the preliminary point.
Correct, my lord. So, my lord, that is, my lord, how, my lord, it, my lord. Now, my lord, how was this preliminary point, my lord? I just want to get to this preliminary point. My lord, kindly take, my lord, volume 1. My lord, I hope your lordships have volume 1, my lord. That
So,
suddenly he checked up.
wanted the volume 1 paper book dao.
My lord,
Yes, yes.
oh, Jetta, which is the one? The first.
342. It 342.
Are first show me which APO is it? 342, my lord. Kindly take 342.
Agree. Yes. Why two
My
matters?
lord, there were two, my lord,
Section
two
30
section 34s, my lord.
by two
section-
different parties.
Yes, my lord, it's my lord.
Same award. Award is
Same, my lord, and
Right,
my lord, the same, my lord, objection.
yes, yes.
My lord, now, kindly, my lord, there are, my lord, history, my lord, is, my lord, referred to. My lord, now, my lord, kindly come to page 13, my lord, paragraph 9.
Yes.
Wants to record consent, please. My lord, kindly take, my lord, paragraph 9. I'll quickly read through it. Without prejudice to the aforesaid, the petitioners, however, state and respectfully submit that the discovery of certain facts subsequent to the passing of the award have rendered the said award void. As such, the award dated 29 February 2022 is no award at all in the eye of law, The petitioners accordingly state and submit that the said award deserves to be and should be set aside on such ground alone upon declaring the same to be invalid and consequently void. Shocked by the contents of the said award, my lord, kindly note this, shocked by the contents of the said award, the petitioners started making random searches on the internet, which shockingly revealed that even while acting as an arbitrator, the learned arbitrator had repeatedly continued to advise and appear on behalf of the companies owned, managed, and controlled by the respondent number 2 without disclosing such fact to the petitioners or the respondent numbers 3, 4, and 5. On the basis of what their searches on the internet revealed, that the petitioners thereafter accessed the server of this honorable court and obtained therefrom the copies of orders and matters in which appearance of the learned arbitrator as counsel for one of the companies of the respondent number 2 is recorded. The copy of one of such orders passed by a division bench of this honorable court on so-and-so, SM Chemicals versus Standard Shoe Sole and Mold India Limited, shows that the learned arbitrator had led the team of counsels appearing for Standard Shoe and Mold in the matter which had been heard on so-and-so, as will appear from the said order, a copy whereof the advocates appearing with him in the matter were the same advocates who appeared for 1 and 2 in the arbitration proceedings and were in fact representing the said respondents in the arbitration proceeding at the time when so-and-so was being heard. While the petitioners have been able to get hold of the judgment and order dated so-and-so, in the circumstances aforesaid, petitioners reasonably believe that the learned arbitrator appeared in other matters as well as for respondent number 2 or his companies during the continuance of the arbitral proceeding without disclosing such fact to the petitioner or respondent. My lord, this is, so my lord, comes the award. They are shocked by my lord, certain my lord, why are you standing?
Yes. No, I can sit down. I think your lordships had perhaps put it to us, whether
Yes, because we knew the arbitrator because he's a senior counsel of this court.
Yes.
During our practice days, we knew and he argued before us.
Correct.
So we put you a question to both of you whether you have any objection on that ground.
Insofar as we are concerned, the respondents, I cannot make a statement today. I'll have to take instructions on that from my clients. Because today I cannot give a consent only by
It's
myself.
an obviously known fact. I mean, that he was a counsel of this court.
Yes, of course. That fact.
Not any other relation with him, but
in fact, for
we
that
definitely
matter,
knew him as a counsel.
as the councils, we also are.
You also obviously knew him.
So,
And his son is a judge of this court.
Correct.
So if you have to have it heard before this Calcutta High Court, then I think that applies to all the benches.
Yes.
that's true.
So you can take it, you can send somebody and take instruction. I mean,
Yes, in the meantime, we'll get instructions.
please do that during this
yes,
hearing.
yes, absolutely.
So that unnecessary wastage of time won't be there.
Yes, I will do
If you
that.
take a specific objection, then we don't want to have a same challenge on the same ground.
Correct. We'll just have someone sent and get.
Please do that. Someone can call him.
Yes,
up.
absolutely.
And in the meantime, we'll continue hearing, Mr. Mukherjee. Yes, Mr. Mukherjee.
So, my lord, what has happened now, my lord, is kindly see, my lord, the award is passed. My lord, portions of the award, or let us say entirety of the award, my lord, shocks them. And they go straight to the internet.
Yes.
And my lord, they then go to the website and my lord, discover a certain fact,
Yes.
which they say, my lord, had not been disclosed. And my lord, that itself, my lord, makes, my lord, nullifies, my lord, the award. My lord, that in short, my lord, is, my lord, the case which is made out.
Right.
Now, my lord, I come, my lord,
But the nexus complained of happened before the passing of the award. At
yes,
the time when the hearing was going on.
yes, yes.
So
My
even
lord,
if
the
they
alleged
came-
nexus, alleged nexus.
Alleged.
Now, my lord, kindly, my lord, now, my lord, in this background, my lord, because, my lord, they're relatives. My lord, the entity for whom, my lord, the learned arbitrator had appeared, they were also shareholders, my lord, there. My lord, so, my lord, just to, my lord, feign ignorance.
They means whom? They.
Respondent.
Acha. Very good.
My lord, they are, my lord, brothers-in-law, my lord, the Bagri and my lord Bhaiya. But my lord, I'm, my lord, going to, my lord, tackle it, my lord, on, my lord, the findings, my lord, of the learned judge first before I come to, my lord, these other points, my lord. Now, my lord, both in fact and in law. Both in fact and in law. Now, my lord, the impugned order, my lord, is in volume 12. I don't know if your lordships have
Volume
that.
12 to the-
My lord, that. My lord, kindly keep 12 and 13. My lord, it's a lengthy, my lord, judgment.
Where?
So, my
12,
lord,
13,
12
20.
and 13, your lordships keep, my lord. I don't think I'll be troubling your lordships. with-
Regarding the allegation in the section 34, this is about all. What
No,
we
no,
have
no, no,
placed.
there are more.
There are more.
There are more. My
So
lord,
this
it's,
is the premise of the.
yes. Now, my lord, I will, my lord, point those out as well. Now, my lord, if I may just tell your lordships, my lord, 4, my lord, points, my lord, which I'm going to argue.
Please, that will be easier for us.
Yes. Now, my lord, the first point is, my lord, that, my lord, the, my lord, entire preliminary point has been decided on the basis of, my lord, the amendments introduced to, my lord, section 12 from 23rd October 2015. My lord, I am not suggesting that those amendments, my lord, would not apply, my lord, at all. I am not, though, because, my lord, though the arbitrator had been appointed, my lord, before, my lord, these, my lord, amendments came in. He was appointed in 2014. These amendments, my lord, are effective from October 2015. But, my lord, when this alleged, my lord, infraction is supposed to have occurred, these amendments were very much in place. And, my lord, I am, my lord, saying, my lord, that why these are, my lord, relevant, because, my lord, these are, my lord, the grounds, my lord, which, my lord, are applicable, my lord, once, my lord, they come into effect, and once the alleged act is supposed to have occurred, my lord, which is after the amendment. So, my lord, I say they apply to, my lord, the allegation made, my lord, in these, my lord, proceedings.
So this is not a point at all. This is not one of your grounds.
No, it's, my lord, it will be a ground to show, my lord, that the arbitrator was not required to make any disclosure of this event.
Pursuant to the amendment.
Correct.
Oh, you say the amendment applies, that is in your.
Correct, correct.
Very.
Saying, I'll tell you why. Now, my lord, the second, my lord, point, my lord, which I wish to, my lord, argue, my lord, is, my lord, that, my lord, none of the grounds, my lord, which have been, my lord, alleged as falling into these slots, my lord, of Schedule 5 and Schedule 7, my lord, on the facts, even holding, my lord, the factual findings, my lord, to be correct, my lord, do not, my lord, apply, my lord, amount to infraction of any of those grounds.
Even if the facts are correct.
As found. Now, my lord, sorry.
Just one second. All right.
Now, my lord, the third, my lord, point, my lord, which is, my lord, important, is, my lord, the finding of facts which have been arrived at, my lord, by the learned single judge, my lord, are without any basis. And that is on, my lord, the relationship, my lord, what has been found.
Relationship between?
My lord, the learned judge, my lord, has proceeded on the basis that, my lord, the entity for which the learned arbitrator appeared was an affiliate of one of the parties. My lord, affiliate is defined.
Pardon?
The expression affiliate, my lord, is defined in the 5th and 7th schedule. My lord,
This is connected to the previous
my
part.
lord, all are connected, my lord. My lord, they'll dovetail.
One follows from the other.
Yes. Yeah,
You
yeah.
have any objection?
Now, I've spoken to my clients.
Yes.
They are not agreeable to give a consent to your lordship's hearing the matter, and because that's perhaps for the reason the history of the matter itself. So, I am not therefore unable to give a consent on behalf of my clients for your lordships to hear the matter. I am very apologetic, but that's the
No,
instructions
don't be
that I've received.
apologetic for that. So if you take an objection specifically, then I mean,
Because I was not here in the morning, but what I was given to understand is that your lordships had perhaps
no
indicated.
no. Whether you are taking any objection, we specifically said that if either of you have any objection, because we knew the counsel, the senior
Correct,
counsel,
of course.
no personal relationship. But for that, if you have any objection, which applies to most of the judges of this court,
Absolutely, absolutely.
probably all the judges.
So,
So then, if you have a specific objection, you tell us.
yes.
If you are somewhere midway, don't have any objection, but you don't consent either, then we'll record that only before proceeding, because we don't want to be hauled up after the entire hearing, our order being challenged, that you took an objection, but we still
Correct,
proceeded with the
because
matter.
I understand the predicament. Maybe I misunderstood because we checked with the client regarding giving of consent. I will just check again right now because if there is an objection or not, perhaps there should
Yes,
not
because
be an
otherwise
objection.
it will be a wastage of court
I,
time.
I quite see. I quite see.
My lord, one fact your lordship should know.
Yes.
My lord, one minute. My
And
lord,
we'll make it clear in our order that that applies to most of the judges of this court.
Yes.
Not in a vindictive
No, I agree. I agree.
just because you take an objection.
No, I
But we'll make that clear. That probably would apply to all the judges. And if it is to be heard by this court, then I mean, we don't personally feel that we will be prejudiced. We make that clear to you. But it's your call also.
Because I'm grateful. Let me just give me one.
Either objection specifically, no consent, that is somewhere midway,
Supreme
or
Court order.
consent, whatever. I
Yes,
mean,
yes.
whatever
The
is your.
Supreme Court.
Because if Mr. Mukherjee argues for the whole day, then you
No,
say that.
I appreciate that. Your lordship, be just so kind to give me a minute.
Oh, yes, yes, definitely. To take that. In the meantime, let us continue
Yes,
the
yes,
hearing.
absolutely.
Yes.
My lord, I don't know if my learned friends are aware. My lord, what happened, my lord, was there were two applications. One before the Supreme Court saying, my lord, that they would not get justice, my lord, in this High Court.
Acha.
And my lord, that I'm told, my lord, was dismissed. I hope.
There is a background to this. Same situation was happening. Learned arbitrator, all of us on across this bar and that side were aware. So 8 judges had recused before the matter was finally heard by Justice Mantha. So
No, because we are not recusing, we are being very candid.
Yes.
Our first impression was to recuse. But then we thought that the parties would never get justice. I mean, because they won't be heard at all.
Correct,
They
correct.
won't get a bench.
Yes.
We abhor that situation where a litigant, just because he was a senior counsel of the court or
Yes,
his relative is our colleague, he won't get justice.
Correct.
That impression should not go.
Correct.
But that's why we were bold enough to put that.
No, I'm so deeply obliged. Because I'm so deeply obliged. Your
Anyway.
lordships have been very candid. So
So
I'm
you should
grateful for
appreciate that also. I
Yes,
mean,
yes, of
we are
course.
not,
Of course. of
nothing
course.
surreptitious should be there in court
Absolutely,
proceeding.
absolutely. Manoj.
We don't, if we felt that we would be biased, we have done in certain cases, we have released matters because there were specific allegations of assault against a particular counsel of one of the parties.
Right.
This bench has released that matter stating that we are not confident. I was not confident, one of us was not confident that I would be unbiased. There may be a reverse bias also to show that we are not biased.
Yes.
So we release that matter. In this matter, there is nothing of that sort.
Yes.
Because this may happen because mostly counsel are arbitrators. So,
Correct.
so we make our stand clear that we don't feel that we'll be biased. Then it's your call. We'll record that. We can turn down that objection also.
Yeah, absolutely.
But you
Absolutely.
can take up, I mean, you take your call.
Just give me a
Take that
moment.
instruction.
Just give me.
Yes. Mr. Mukherjee proceeds in the meantime. Yes. So affiliated, Mr. Mukherjee, you say this affiliation relied on by the learned single judge is not affiliation under schedules
Correct.
5 and 7.
Correct. And my lord, over and above that, my lord, there is, my lord, a finding of control by, my lord, one of, my lord, the parties over, my lord, the, my lord, entity for whom the learned arbitrator appeared.
Yes.
My lord, there is no evidence of control, none at all. So that factual, my lord, matrix, my lord, I'll go into completely, my lord.
Has to be.
Yes. The factual, my lord, matrix, my lord, I'll go into completely.
So you say there was no basis of that.
Correct. None. My lord, that is, control is one, affiliate is another. Then, my lord, one of the claimants, my lord, attending, my lord, my lord, attending to, my lord, conferences in person with, my lord, the learned arbitrator during the pendency. My lord, there's no evidence.
Oh, that's
Nothing.
all right.
My lord, so those, my lord, factual aspects, my lord, I am, my lord, going to go into.
Right.
And my lord, lastly, my lord, the learned judge has recorded, my lord, the submission, my lord, of, my lord, the counsel appearing for the respondents, that he is not pressing the allegation of fraud, corruption, or bias.
Please repeat that.
He is not pressing during the course of hearing. It's recorded. I'll show that.
During the course of hearing of the
That he is not pressing.
section 34.
Yes, yes, my lord, in this order, para 68, 69. But yes, my lord, in spite of my lord recording this, my lord, the learned judge, my lord, went on to examine whether, my lord, 5th schedule or 7th schedule, my lord, was, my lord, contravened. My lord, this is, my lord, whether that at all could be done or not, my lord, is, my lord, a submission, my lord, which I shall. Because, my lord, one then has to see the purpose why these schedules were introduced. My lord, your lordships would recall, my lord, they came from, my lord, the IBA rules. And, my lord, your lordships had, my lord, the red list, waivable red list, orange list, and then green list. My lord, as to how, my lord, the transparency could be, my lord. And it's word for word the same. Supreme Court, my lord, has also, my lord, pronounced on, my lord, these issues that it comes. So, my lord, these are, my lord, the 4, my lord, aspects, my lord, which I'm going to address your lordship on.
Now, Mr. Mukherjee, we will ask you a question directly.
Yes.
You say that these facts, there was no basis of that. But since the arbitrator is a judge, nothing less. Now, do you, I mean, what is your stand? You may be neutral on that. You may not comment on that. Was there actually an in excess? It is something else saying that there was no proof. It was my guilt was not proved.
No, my lord,
If
I
any in
put it
excess, what was in excess? We'll
Yes.
ask you that
No,
also
correct.
directly.
Correct. So, my lord, there is, my lord.
Because if there is an apprehension in our mind,
Correct.
that may go against you
Yeah.
without holding that it is tainted by fraud.
Yes. Now, my lord, first submission I want to make that it's an admitted fact that the arbitrator appeared for this entity,
Right.
my lord, which was earlier known as Chemcrown, and now, my lord, is known as, please, yeah, Standard Shoes and Soles, my lord,
Acha.
that the arbitrator appeared.
The relationship and the links are what you will be arguing on,
Yes, correct. So, my lord,
or lack of it. I mean,
yes. Now, my lord, so, my lord, the fact of this appearance, my lord, is not in dispute.
during the pendency of the proceedings.
Correct.
All right.
That's, my lord, point number 1. I want to, my lord, also, my lord, indicate. Point number 2, my lord. And, my lord, all, my lord, whatever I'll indicate, my lord, is against me. So that, my lord, your lordship, my lord, gets, my lord, a fair picture, my lord. My lord, one of the claimants had said, my lord, that he had founded, my lord, the entity, my lord, for which, my lord, the arbitrator had appeared.
Said means said where? In the arbitral.
In the arbitral proceedings. Yes. Now, my lord, the third thing, my lord, which your lordships will kindly examine, my lord, and I'll start with an example. My lord, Mr. Ghosh and I, my lord, are subscribers to the memorandum and articles of association of a company. So, my lord, we founded it. My lord, we continue to hold shares, but, my lord, we are not majority shareholders. Nor, my lord, do we, my lord, become, my lord, the, my lord, majority directors. My lord, lots of others, my lord, all who are, my lord, before your lordship today, my lord, decide to acquire shares. They may be known to me, may not be known to me. And, my lord, there are several shareholders.
So element of control is what has to be there.
That
Otherwise, there is no useless. I mean,
correct. My lord, that is one aspect. If control falls under, my lord, schedule.
yes.
My lord, because the learned judge, my lord, has decided it solely, my lord, on the basis of, my lord, infraction of the schedules. So, my lord, because the learned judge has gone on to hold that, my lord, the my lord, appellant and, my lord, the entity for, my lord, whom, my lord, Mr. Kapoor appeared, that entity was an affiliate of the appellant.
Yes. Very.
My lord, unless, my lord, if that finding, my lord, cannot be sustained in law and in fact, my lord, this appeal, my lord, should be, my lord, in my respectful submission, allowed. Now, my lord, I'll, my lord, place some relevant portions of the order because, my lord, they give the facts as well, my lord, so that I don't have to take your lordships, my lord, back to, my lord, the petition, my lord, affidavits, etc., except maybe one or two places.
Yes.
My lord, kindly come straight away to, my lord, the order, which is at page 1570.
Yes.
My lord, paragraphs 12 to 19. My lord, is, my lord, what is important. My lord, apropos, my lord, the facts to start with. My lord, their reference, my lord, I must tell your lordships, was started on the basis of a consent order passed by a learned single judge in a civil suit.
All right.
My lord, there were two proceedings. My lord, one, my lord, before, my lord, it was, I think, the, please concentrate here. My lord, one, my lord, which is, my lord,
So section 8 was there.
no, 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 no.
Just
So,
by
my lord, there
consent.
was, my lord, a suit.
Yes.
My lord, there were, my lord, proceedings in the nature of 390 operation mismanagement proceedings, my lord, before the tribunal. My lord, the matter came up, my lord, before a learned judge, my lord, of this honorable court, who found, my lord, that, my lord, it was really, my lord, family, my lord, in the nature of a family dispute, and suggested, my lord, parties to come up with, and in the meantime, there had been criminal proceedings, etc. My lord, came up, my lord, with, my lord, suggestion that the matter should be settled. So, my lord, the lawyers sat together and, my lord, agreed, my lord, to a terms of settlement, which referred, my lord, amongst other things, all disputes, which included, my lord, the civil suit dispute, as well as, my lord, the, my lord, company petition dispute, my lord, to arbitration. So, my lord, and, my lord, the arbitrator, my lord, was suggested by my learned friends, my lord, clients, my lord, which was, my lord, accepted, and, my lord, as a result of which, one of my learned juniors in the matter, my lord, lost his brief.
So there's an order recording that.
Yes, yes, my lord, I'll show that, my lord. Page, my lord, my lord, volume 1, my lord, which your lordship already has.
Yes.
My lord, sorry, my lord, I'll read it out, my lord, I'll
No,
read
no,
it out.
you can later on just give the page number.
But, my lord, if I read it out, my lord, it'll,
Correct.
my lord, I think your lordship needs to know, my lord, this,
Exactly.
this,
For
my
that.
lord, background, my lord. My lord, volume 2, page 169. My lord, it is, my lord, an order dated 1st August 2014. My lord, may I just read it out?
Yes, please.
And, my lord, may I, my lord, just as an aside, my lord, tell your lordship, I was not happy, my lord, which is why I didn't appear on that date. Your lordship will find that. The parties have agreed that all disputes between them,
Yes.
including the disputes pending in other fora, as recorded in the consent terms, be referred to the arbitration of Mr. S.K. Kapoor, Senior Advocate. Consent terms have been drawn up and signed by advocates representing the parties. The consent terms of August 1, 2014 are received and shall be retained with the papers. In view of such agreement between the parties as reflected in the consent terms, CS number 344 of 2012 and all applications pending therein, including GA 2848, are disposed of by referring the disputes between the parties to the arbitration of the agreed arbitrator. The parties have also agreed that the arbitrator will have summary powers. The parties reckon that the reference should be concluded within 6 months from the arbitrator being served an authenticated copy, etc., etc. And, my lord,
But still, even during pendency of the arbitral proceedings, if it
no, I'm not relying on, I'm just giving your
Understood.
lordship the genesis. My lord, this is, my lord, I am, my lord, not for a moment saying that, my lord, the continuing obligation under 12(2), my
That
lord, vanishes.
Goes away, yes, right.
I'm not, my lord, suggesting that. Now, my lord, kindly come to, my lord, the impugned order.
Para 12 of that?
Beg your lordship.
Para 12 of the impugned
Yes,
order?
my lord, of, my lord, the impugned order. Kindly take it from the memorandum. Memorandum, Raje?
We have.
Oh, your lordship has that page.
we have
Very
that.
well. In the
Yes, Mr. Dem.
Well,
Yes.
in the meantime, I have taken instructions. Well, it's in light of what perhaps had transpired in the morning before I came, well, my client does indeed have an objection. I must very respectfully state
Has an objection?
has an objection, Malas. And I, Malas, quite see as an officer of the court with all humility and respected my command, perhaps the reservations your lordship have expressed, that may apply to every single judge of this court.
Yes. What is the premise of that objection, maybe?
Well, perhaps it appears, Malas, that because of the identity of the learned arbitrator, being Malas familiar with a number of judges of this court, including perhaps it came from your lordships,
Yes.
and Malas, the fact that there is a lot of respect for the learned arbitrator, which perhaps is, I would say, usual in the circumstances.
Yes.
And given that, Malas, in the morning your lordship did on your own accord, Malas, say so. Malas, my client believes.
So
that,
we also said that we are confident that we don't have any bias. We won't have any. We
Malas,
won't be biased for that.
Malas, may I say with utmost humility, I am myself feeling a little
No, we
embarrassed about
understand.
it. But unfortunately, I am bound by my own instructions. So
If
it's a
you
little
take an
embarrassing.
objection, we'll have to decide on that.
Yes.
We may accept that, we may not accept
Absolutely.
that. And
Absolutely.
which will be a valid ground in a if a further challenges.
Yes, Malas, I appreciate that. I appreciate that.
So, Mr. Mukherjee, before moving further, do you have anything to say on that objection? And we'll decide on that right now.
yes, my lord, the important thing is,
Because
my
you
lord,
referred to something they had moved up and
my lord, there are two. My lord, not.
just show us that, we'll consider that,
My lord,
and we may or may not accept the objection.
Yes.
Thanks. But you cannot argue on the objection.
no, the
They
objection, my
may
lord,
produce something
Well-
because you have challenged and that has failed.
my lord, there was, my
If you
lord,
want to give a reply on that, we'll take that.
Yes.
my lord, kindly, my lord, make a note, get a copy of the order.
Yes.
My lord, I'll just get a
We'll
copy of.
just take a note.
Yes, now, my lord, the first point, my lord,
Yes.
my lord, which I, my lord, take, my lord. A section 25, my lord, application, my lord, made, my lord, by, my lord, the, my lord, respondents before the Honorable Supreme Court, my lord, for transfer of the proceedings. My lord, on the same ground, my lord, that, my lord, is being taken before your lordships, my lord, as a objection to your lordships, my lord, hearing this matter.
Not this bench.
No, not this bench.
This court.
This
Any
court.
judge of this court.
This court. Now, my lord.
We'll take a copy of that by the end of your argument.
Yes,
Not right now, but
my lord, it's on its way.
we'll take it on whatever
Yes.
you are submitting for that. Yes.
My lord, kindly take, my lord, page, my lord, I'll just read it out, my lord. It's important because.
The order.
Yes, the order.
Yes.
My lord, which I have considered the submissions. It is not in dispute. At present, Calcutta High Court has more than 30 honorable judges. The petitioners have disclosed in this petition that the learned arbitrator is a very well-known figure in the legal fraternity in Calcutta, and in view of his standing at the bar, he is a very influential person. Various achievements of the learned arbitrator have been set out, including the fact that Lifetime Achievement Award has been conferred on him by the Bar Association of Calcutta. What is material is what is set out in grounds H and I, which read thus: because the petitioners apprehend a likelihood of miscarriage of justice because of the overreaching influence and respect that the learned arbitrator, Mr. S.K. Kapoor, commands in the members of the bar and bench of the Honorable High Court, Calcutta. Petitioners are having a reasonable apprehension that they might not get justice in the Honorable Calcutta High Court because of long standing of learned arbitrator in the bar, since the award passed by the learned arbitrator is under challenge on the ground of misconduct of the learned arbitrator as well as inducement and effectuated by fraud, and petitioners apprehend and effectuated by fraud, and the petitioners apprehend that the discretion of the bench at the High Court, Calcutta will sway against the petitioners in light of the respect that the learned arbitrator and his family commands amongst members of the bar and bench of the Honorable High Court, Calcutta, especially because of the nature of the allegations leveled against him which may result in miscarriage, injustice. Thus, what petitioners are trying to suggest is that as the learned arbitrator is an eminent figure in the legal fraternity in Calcutta, they will not get justice from any of the judges of the Calcutta High Court, who are admittedly more than 30. Even assuming that 5 honorable judges, kindly note this, have recused themselves, that is no ground to express an apprehension about the entire High Court of Calcutta consisting of more than 30 judges by contending that the petitioners will not get justice from the Calcutta High Court. Then, even assuming that the learned arbitrator is a very respected member of the bar, I am sure that the High Court of Calcutta will examine the allegations of misconduct without being influenced by the alleged status of the learned arbitrator. Suffice it to say that no ground is made out to transfer the subject petition pending in Calcutta High Court to any other High Court. Hence, these petitions are dismissed.
Which bench of the Supreme Court
Justice Oka.
Yes.
My lord, who, my lord, also commanded, my lord, tremendous respect, my lord, in, my lord, the High Court and, my lord, in the Supreme Court.
And it's Justice Oka who had directed us to change our rules and allocate bail matters to single judges and express displeasure that we are not doing it. So therefore, the same, I mean, so there is no bias regarding Calcutta High Court
No,
that also.
yes. No, my lord, I have, my lord,
No,
my lord, this is one.
yes.
Then, my lord, they made an application before the learned judge, Justice Mantha.
That is a friend of.
Yes, because we want to clarify this at the outset. We are being very clear because we don't want there to be either a bias or a reverse bias also.
Yes.
We don't want to try to prove before you that we are not biased by dismissing their
Absolutely,
application.
Absolutely.
So we have to be very clear on this at the outset.
Absolutely. I'm grateful.
Thank you. Yes, Justice Mantha's order, sir.
My lord,
It's in the impugned order itself or different order?
no, different. My lord, kindly make a note. The Supreme Court order,
Yes.
my lord, was 24th of September 2021.
Yes.
Now, my lord, then comes, my lord, the application before the learned judge who passed the impugned order. My lord, we had moved, my lord, for execution because there was no stay. My lord, that application, my lord, was, my lord, considered, and my lord, I'm just reading out what the learned
application was for
my lord, for, my lord, the
release.
yes, my lord, for withdrawal, my lord. Now, my lord, kindly see.
What is the date of that order, Mr.
My
Mukherjee?
lord, the date is subsequent.
Acha.
My lord, 1 year later, 1st September 22.
Acha.
My lord, is the order.
Yes.
My lord, the Supreme Court order, my lord, is here.
So we'll take a copy of that because we may quote some of the portions of that.
Get copies of this also. My lord, kindly see, my lord, this, my lord, I'm just, my lord, sorry, my lord.
What was the prayer made in that application
My
before
lord, I
Justice
just
Mantha?
get that, my lord.
Just the nature of the prayer.
The prayer before Mantha.
Yeah, to recuse himself on the ground that he is well known to the arbitrator and his son.
Great.
My lord, now, my lord,
In fact, we are less well known than Justice Mantha. Anyway, so
after having heard the facts
yes.
of the main application and AP 364 of 2020 in some detail, this court inquired of learned counsel, Mr. Kohli, as to whether his client would tender apology for the statements made in GA4 of 2022. Please get GA4.
GA4 was that application?
Yes.
We won't go to that extent.
No, my lord,
because they have not made an application.
No, they haven't. Now, my lord, but your lordship needs to see the grounds. My lord, oh, my lord, I need to apprise your lordships, my lord. Of
yes,
these
yes, because we are on this subject.
Yes. Mr. Kohli submitted that his clients regret the application itself as a whole. No apology was forthcoming from his client. This court has carefully considered, as here, my lord, clients are not committing. Mr. Kohli, my lord, apologized. Now, my lord, kindly see. This court has carefully considered the statements in the application. The applicant, who is the judgment debtor under an award that is the subject matter of these proceedings, has made statements that touch upon the dignity and majesty of court. When a party wishes to withdraw an application, courts have more often than not permitted the same. The application in the instant case is unusual. The application sets out misplaced apprehensions on frivolous grounds. As for the prayer for withdrawal, it is one thing to make an allegation on affidavit and get the same adjudicated, and completely different matter to withdraw the same simpliciter. There is no hesitation or doubt in the mind of this court that the application was in bad taste and on inappropriate legal advice. The facts of the case and the conduct of the applicant warrant imposition of appropriate costs. However, considering the earnest implorations and requests for magnanimity of Mr. Nalin Kohli, learned counsel appearing for the petitioner, this court imposes token costs of ₹11 on the applicant. Costs are payable to the High Court Legal Services.
Costs are paid.
The 11 rupees are paid. Yes, indeed, I'm told.
GA4 associated stands dismissed as withdrawn accordingly so and so. All stand dismissed. Let the remaining matters. Well, I'll get a copy of this order and my lord indicate, my lord, the grounds also, my lord, to your lordships, my lord.
Mr. Diwan, we want to, turn down the objection on the premise of primarily the Supreme Court order. If you have to say anything on that as counsel, you may.
Yes, just two small short points.
Mr. Mukherjee, please take your seat. We'll resume with the argument once we do that.
Yes.
Subject to if you are convinced by Mr. Diwan otherwise. Yes.
No, but first of all, as someone who doesn't usually regularly practices here, I frankly,
Mr. Diwan, we are being very candid. It's nothing about the council.
correct
You have to go by your instructions.
instructions. So
we-
it is in that
nothing
sense a
on
little-
that.
Yes, but I must say it's a little
As your
unusual.
counsel, you do your duty.
Well,
Yes.
after what has come from your lordships, and very candidly and very fairly, I must admit, it is a little unusual for me again to press the request. But may I only add just a background
Yes.
to the Supreme Court order, and
Yes.
ultimately I leave it at that. I will
Absolutely.
press it beyond a point. I understand the Supreme Court order came in a background where 5 or 6 learned judges of this honorable court
Recused.
had recused. So perhaps the advice given to the client at that point of time, or the apprehension was that there is an award operating against us and no judge is willing to hear the matter. So perhaps the advice at that point of time was to go to Supreme Court and have the matter heard by a different High Court. The Supreme Court, of course, had good reasons.
But the grounds were quoted. Grounds were different.
Well, it's,
You don't have a copy of this order.
I will get I don't have a copy of the petition, the section 25 transfer petition.
No, that petition, a portion of it was quoted. The
Well, they
page 3 of this judgment.
Those are perhaps only H and I. The only grounds quoted are H and I.
Yes.
At this point of time, I can't say if there are other grounds also.
But these
present.
were also there.
These are also there. I quite see.
The other grounds, in addition, this must have been there.
Certainly there. So, Malaz,
Might not have been the only grounds, but these were also there.
also there. Absolutely correct.
Similar ground as now.
Similar ground is now. Actually, unfortunately, Malaz, I am constrained.
No, your counsel have what?
I'm only constrained to say so. Perhaps because your lordship said so in the morning, so the now client feels that maybe
Yes, sir.
that's
Because the judge himself is saying it.
Malaz, I must candidly say so. That's the only point.
He must appreciate where it came from.
I
Yes.
absolutely quite see, and I just said that I feel myself a little hesitant in
No, I
pressing
understand.
the
We understand.
That's all, Malaz, nothing else.
We understand. At the outset, একটা order record করুন। এই অর্ডারটা প্রিলিমিনারি, তারপর ফাইনালি শোনার পর যা হবে সেটা আলাদা। সেটা যে নেবে তাকে বলো এটার সঙ্গে অ্যাড করে দিতে। At the outset, comma, we made it clear to learned counsel for both sides that due to the learned arbitrator against whom the allegations of fraud were made in connection with the challenge under section 34 of the Arbitration and Conciliation Act 1996, being an eminent counsel of this court and known to us as counsel, comma, although we did not have any personal kinship with the arbitrator, comma, the parties should express as to whether they have any objection to this bench taking up the matter. Full stop, next para. Such expression fell from us, particularly in view of the natures of allegations made personally against the arbitrator. Full stop, next para. At this comma, learned senior counsel appearing for the appellant clearly now made it clear that the appellants do not have any objection in that regard. Full stop. Next para. However, comma, learned senior counsel appearing for the respondents, comma, upon taking instructions from his clients, comma, submitted that the respondents have some reservations if this bench takes up the matter. Full stop. On query of court, comma, learned senior counsel appearing for the respondents further clarifies that such apprehension on the part of in the mind of the respondents arises out of the fact of the learned arbitrator having a commanding respect from the judges of this court and the counsel in general in view of his standing at the bar. Full stop. Standing at the bar at the relevant point of time. Next para. Learned senior counsel appearing for the appellants hands over a copy of a judgment passed by the Honorable Supreme Court in transfer petition within bracket civil numbers 1173-1174 of 2021, along with transfer petition within bracket civil numbers 1203-1204 of 2021 and transfer petition within bracket civil numbers 282-283 of 2021. Full stop. It is submitted that on a previous occasion, comma, a transfer application had been made by the present respondents on similar grounds that the learned arbitrator and his family commands amongst the members of the bar and bench of the High Court at Calcutta, bar and the bench of the Honorable High Court at Calcutta, and as such, the court may be swayed, SWAYED, in passing its judgments. Next para, however, comma, the Honorable Supreme Court had turned down the prayer for transfer on the grounds as mentioned in its order dated September 24, 2021. Full stop. Next para. Upon careful consideration of the submissions of parties on the question of objection, comma, we would like to mention at the outset that that is the members of this bench, comma, do not have any iota of doubt that we would not be influenced or biased in any manner merely due to the standing and the eminence of the learned arbitrator as a senior counsel of this court. Full stop. However, comma, the option was given to the parties in order to obviate any further complications to the extent that the court did not give an opportunity to the parties to take such objection. Full stop. Next para. We want to quote QOT certain portions of the order of the Honorable Supreme Court in dismissing the transfer petitions indicated above. Full stop. Colon দিয়ে এই পোর্শনটা কোট করে দেব এই যেখানটা লাইন টেনে দিলাম thus what petitioners are trying to suggest থেকে এই পর্যন্ত হ্যাঁ মার্ক করে দিলাম এখানে নেক্সট প্যারা learned senior counsel appearing for the appellants also submits that a similar point was taken before the learned single judge who took up the impugned order passed under section 34 of the 1996 Act. Full stop. The said application for
Justice Manta's order.
The said application seeking recusal of the learned single judge was also dismissed. Full stop. While doing so, comma, the learned single judge observed, comma, inter alia, comma, that there was no hesitation or doubt in the mind of the court that the application was in bad taste and an inappropriate legal advice. Full stop. It was also observed that the facts of the case and the conduct of the applicant warrant imposition of appropriate costs, and token costs of ₹11 were imposed on the applicant therein, that is the present respondents. Full stop, next para. We, with utmost respect, agree with the logic of the order of the Honorable Supreme Court in refusing the transfer application previously filed by the respondents. Full stop, next para. Merely by dint of the respect which the learned arbitrator enjoyed as senior counsel of this court, it cannot be assumed that the judges of this court will be biased and shall mete out an order to cater to such CATER to such respect, thereby giving a complete goodbye to the constitutional oath taken by them. Full stop. The moment a judge sits on his chair, given to him by the people of the country through the constitution, he or she is expected to be beyond personal prejudices as well as influence in any manner whatsoever. Full stop, next para. Since we ourselves are confident, that sitting on our chair, we shall not consciously do any injustice by being unnecessarily swayed merely by the influence exerted by the learned arbitrator, influence enjoyed by the learned arbitrator on the members of the bar, and the respect commanded by him as counsel while deciding specific allegations made against him in the capacity of an arbitrator. Full stop, next para. As such, merely because we are judges of this court and were acquainted with the learned arbitrator in his capacity as senior counsel of this court, we are confident that we would not, in any manner be swayed by any consideration, extraneous or otherwise, apart from an objective consideration of the papers before us and the matters which fall for consideration in fact and law. Full stop, next para. Having expressed such confidence in ourselves in our capacity as judges of a constitutional court, we accordingly turn down the objection taken by the respondents in us taking up the matter and full stop. Accordingly, the hearing of the matter on merits is commenced. ঠিক আছে, এটা থাকবে আগে, তারপর যা আজকে হবে সেটা।
So lordships may only say I am not a senior counsel, so lordship may correct.
Oh, sorry. As senior counsel for the respondents ভুলে গেছি, ওখানে respondents একটা counselor. Yes, Mr. Mukherjee, let us start from where we left.
Oh my God.
Para 12 of this.
Yes.
Just one second.
Millard, kindly take Millard paragraph 12 at page 1572.
Yes.
In the first sitting of the arbitration held on 10th August 2014, the learned arbitrator disclosed in writing to the parties that he had earlier represented Bulakidas Bhaiya and his group companies, who is evidently a claimant in the proceedings. Upon such disclosure, the award debtors indicated to the arbitral tribunal that they had full faith and confidence in the learned arbitrator. The relevant portions of the minutes of the meeting held on 10th August are set out below. Millard, I just want to place this. What was Millard disclosed? What was at the outset, and your lordship will see the date, Millard, it's prior to the amendments of 23rd October 2015. At the outset, the arbitrator informed the parties that he had professionally been engaged several years ago as counsel to appear for Mr. Bulakidas Bhaiya, one of the claimants in this proceeding, or companies within his management and control in certain earlier legal proceedings with regard to which Shri Bhaiya had attended the conferences and had occasion to confer with and meet the arbitrators. The arbitrator further informed the parties that his son, Mr. So-and-so, had apparently also appeared for the claimants in interlocutory proceedings arising out of CS 344 before the Honorable High Court. Then Millard, Mr. Jishnu Shah appearing for respondents 1 to 5, and Ms. Shulagna Mukherjee, advocate appearing for the respondents 6, 7, and 8, informed the arbitrator that they had been apprised of details of the foregoing circumstances and being fully aware of the same, had proposed the name of the arbitrator before the Honorable High Court to act as arbitrator in this proceeding. Counsel also stated that they had full confidence and no doubts about the independence and impartiality of the arbitrator and requested him to enter upon reference and continue with the arbitrator thereupon commenced. Then, my lord, these facts are important because, my lord, this appearance comes at a stage what, my lord, is described as the hiatus. My lord, kindly see, in as many as 120 sittings were held in the arbitration between 10th August 2014 and 9 December 2017. After a year-long hiatus, on the 3rd of January 2019, the arbitrator declared that a draft of the award was ready, and after corrections and proofreading, the final award would be ready soon. Minutes of the meeting dated 3rd January 2019 are as follows. The arbitrator apprised the party that his draft of the award was ready and it would take a few days to do the proofreading of the same, as well as making necessary correction of typographical mistakes, and he expected the final copy to be ready very soon. Arbitrator directed both parties to deposit 2 lakhs each by 7 January to meet secretarial expenses in respect of preparation. Between 5th June 2018, my lord, that is, my lord, after 9th December 2017 to 19 July 2018, the learned arbitrator, in his capacity as senior advocate of this court, appeared in the High Court in APD 252 of 2015, arising out of CS number 274B of 1996. So-and-so Standard Shoe Sole and Mold India Limited versus SM Chemicals before division benches of this court as lead counsel for the said SSMIL on 11 occasions. It is stated on affidavit that Bulakidas Bhaiya attended meetings and conferences with the learned arbitrator in connection with so-and-so held with the learned arbitrator. Admittedly, the said SSMIL was formerly known as Chemcrown India Private Limited. SSMIL is a company owned, controlled and managed by one BG Chemicals Private Limited with an ownership of 25.68% shares. Kindly mark this, my lord, because this is, my lord, over 25%, less than 50%. And, my lord, I'll rely on, my lord, our division bench judgment, my lord, of 14 December 23, my lord, in the Birla matter where ArcelorMittal, my lord, was, my lord, cited. My lord, on control. I'm coming to that, my lord. I'm just, my lord, prefacing it. Because, my lord, ArcelorMittal is what is relied on here. My lord, for control. BG Chemicals is itself owned, controlled and managed by Bulakidas Bhaiya and his family members. The registered office of SSMIL is the same as that of award holder CNE Limited, so-and-so. The shareholding pattern of BG Chemicals is as follows. Then, my lord, the shareholding is given. My lord, 10,000 shares. My lord, Bhaiya has 80, one Baldeva has 20, and my lord, Ganga Devi Bhaiya, who's, my lord, the wife of, my lord, Bulakidas Bhaiya, has 8,000, and Bulakidas Bhaiya HUF has 1,900. My lord, this is on 23rd February 2019. The learned arbitrator directed the parties to make submissions afresh, despite having already indicated on 3rd January 2019 that the award had been finalized. Minutes of the meeting dated 23rd February 2019 recorded as follows. Then, my lord, I should place this so that, my lord, whatever, before dealing with other matters, I find from Mr. Singhvi's letter of February 19, 2019 that he has referred to the issue of delay.
Mr. Singhvi means the present respondents council. Your council.
Yes.
So because that could have had an influence.
No, my lord,
It's
we,
the
my
other way
lord,
around.
yes,
You had
yes, my lord, we, my lord,
Yes.
said that why isn't the award coming for so long? My lord, I, who had started initially after getting a portion settled, my lord, found, my lord, there is one hour every day with, my lord, examination. So, my lord, Mr. Ghosh, my lord, had taken over. My lord, I couldn't take it. And, my lord, both, my lord, Mr. Kapoor and I, my lord, we tend to, my lord, argue too much against each other. So, my lord, everybody wanted a slightly more peaceful environment, my lord, at arbitration. Now, my lord, The expectation of counsel was that the matter would be concluded in 6 months' time when they took the order of reference from the Honorable Court. Regrettably, within 6 months' time, the parties did not complete additional pleadings. After that, the arbitrator, without intending offense to anybody, was compelled to give due regard to the overburdened professional times of counsel. However that may have been, the hearings intermittently accommodating everybody continued until mid-2017, when I told both sides that they must proceed on a day-to-day basis and conclude the hearing. I was assured that notes would be given before arguments were made. Regrettably, this was not done. One set of notes was received from the respondents around June or perhaps July 2017, and then counsel argued for the respondents on the first claim with regard to price of goods sold and delivered. After that, counsel for the claimant took over and presented his arguments. I did not then get any notes from anybody. This continued till 3rd December, when I closed the argument and asked counsel to give me their notes. One set of notes was received in January 2018. The second came from the other side in February 2018. And the last set came from the claimants in May 2018, which was just on the eve of summer vacation. I was then proceeding abroad and then took up the matter for consideration after vacation. But then I must honestly admit that very little of the case, if anything at all, remained within my immediate recollection. I was compelled to read the entire bundles of papers by myself and put together my own determination with regard to over 20 separate issues. I had prepared a draft award in December 2018, and before finalization, I took some time when unfortunately the matter, because of my commitments, went out of my mind again. By my notice of 18th, I asked the parties to come to address me on certain matters, which I think they had left incomplete in the earlier arguments, hence the meeting today. Then, my lord, as many as 13 more sittings were held from 23rd February 2019 to 9th September 2019. Award was made 6 months thereafter on 29th February 2020. Now, my lord, the reason I read this, my lord, was that the learned arbitrator was also willing, my lord, to admit, my lord, his, my lord, faults, my lord, that he had not proceeded, my lord, with expedition. Now, my lord, as many as 13 more sittings were held. A brief chart or sequence of events and dates in the arbitration and relevant intervening actions, etc.
And the fraud was the only ground of challenge in the section 34. There were other grounds also.
Other grounds,
But it was decided only on the ground of fraud.
Ground of bias.
Bias, only, my lord. My lord, in fact, it was decided only on the ground of, my lord, the arbitrator, my lord, continuing as arbitrator without disclosing as required under the schedules.
Hiatus period.
Yes. Under the schedules, which were, my lord, operative then. That is, my lord, the only ground. Because fraud is given up. I'll show your lordship. And the learned judge also holds there's no fraud.
So we gave up fraud. We gave up the argument of fraud. We restricted our case
Bias.
only to bias.
Even, in fact, bias was also given up. That I'll show, my lord. I'll show.
We'll hear it.
Yes. My lord, saying no won't do. My lord, it's recorded.
No, but we'll.
Yes.
Yes.
Then, my lord, kindly, my lord, take, my lord, the dates, my lord.
Yes.
10th August, my lord, that's the, my lord, first day, my lord, where the declaration is made. 13th September to 9th December, the arbitral hearings. Hiatus, December 18 to December, January 18 to December 18. Then, my lord, 3rd January, my lord, award had been finalized. 23rd February, my lord, is, my lord, the, my lord, re-hearing. 3rd March to 9th September, 13 sittings. And, my lord, 29th February, award was pronounced. These were, so, my lord, the hiatus period, kindly note, is marked, my lord, January 2018 to December 2018.
Yes.
The arbitrator admittedly did not disclose or inform the parties that he had appeared several times in the High Court for SSSMIL during the aforesaid hiatus period. The award was declared in favor of the Bhaiya Group and its associates for an overall sum of rupees 22 crores with interest. The operative part of the award was as follows. Now, my lord, I'm not going to read this portion, my lord, only to indicate, my lord, that there were cross awards as well. My lord, it's not, my lord, that it's only, my lord, one-sided. My lord, there were cross awards and there was, my lord, provision, my lord, for adjustment. Now, my lord, and my lord, one portion of it was, my lord, also, my lord, a settlement, my lord, which had been arrived at. Till then, my lord, I was involved, my lord, with regard to, my lord, getting both sides to meet and, my lord, at least have, my lord, closure on one issue.
Mr. Mukherjee, you can point out of these which were in favor of the respondent or
Yes, yes, my lord, kindly.
only those, because
Yeah.
which were granted in your favor, obviously.
Yes, my lord. My
Yes.
lord, kindly, my lord, take, my lord. My lord, first is, my lord,
Claim 7 is rejected. That is your claim.
yes, claim 13 also. My lord, claim 7, my lord, is rejected. Then, my lord, claim, my lord, 13,
Yes, rejected.
my lord, is also, my lord, rejected.
Hmm.
Then, my lord, there is একটা claim দাও না যেটা
1503 তে দেখো আমরা চার্জ করে
আরে আমি যেখানে জিজ্ঞেস করছি ওখানে বলো না। Then, my lord, there is then, my lord, kindly come to, my lord, 14, claim number 14. I further summarize the reliefs awarded with regard to the claims of the respondents. Lordship has that, my lord?
Yes.
Now, my lord, there shall be an award in favor of Gopal Das Bagri, being his claim on account, carry interest. So far as against the company, all of them are rejected. Abhishek Kotari against the company are rejected. As agreed, then, my lord, D is the agreement between the parties. Respondent shall sell and transfer the entire shareholding, etc.
Hmm.
And, my lord, the mode in which, my lord, the, my lord, sale will happen. So, my lord, there are two small, my lord, claims which are allowed against the claimants. And, my lord, two of the claimants, my lord, claims are dismissed. Of the claimants are dismissed. And, my lord, there is, my lord, an award on the basis of, my lord, an agreement with regard to sale of shares. Where is that? I'm not, you're not understanding here. My lord, in fact, there is a chart, my lord, in, my lord, the pleadings, but I'm not troubling your lordships, my lord, with the pleadings now. My lord, submissions on behalf of the award debtors. My lord, this is, my lord, their submissions,
Yes.
which your lordships will find, my lord, from paragraph 20
Mhm.
to, my lord, paragraph, my lord, 33. Paragraph 20 to 33. My lord, my lord, now, my lord, only, my lord, 21. My lord, I wish to, my lord, place, my lord, before your lordships,
Yes.
that there can be no dispute as regards the control of SMIL by Bulaki Das Bhaiya. He had the direct or indirect power to control the management, affairs and policies of SSML, either by himself or through his family members. It is stated that SSMIL acted as per dictates and wishes of Bulaki Das Bhaiya and his immediate family members. Reliance has been placed on para 50 and 51 of the decision of ArcelorMittal in so-and-so. My lord, this is why, my lord, I just wanted to. And then, my lord, para 23, my lord, one is, my lord, you had control of, my lord, SSMIL. My lord, it was controlled by, my lord, Bhaiya. Therefore, if you appeared for SSMIL,
Yes.
you appeared for Bhaiya. My lord, that is, my lord, at the highest, my lord, which could, my lord, be said. And then, my lord, is, my lord, 23. Mr. Kohli, my lord, alternatively argues that the aforesaid actions gave rise to justifiable doubts within the meaning of 12(1), 2 and 5 as regards the independence and impartiality. And then, my lord, he doesn't need to, my lord, what is the test of, my lord, bias? And then, my lord, kindly come to 31 then.
Yes.
My lord, kindly take 31 by... my lord, kindly give me a moment. It's just gone off the screen, my lord.
Yes.
Please. My lord, kindly, my lord, come to, my lord, paragraph 31. By placing reliance on section 12 of the said act and the 7th schedule, it is argued by Mr. Kohli that the arbitrator had become de jure incapable of performing his functions by reason of having appeared for SSMIL during the pendency of the arbitration. Reliance in this regard is placed on para 17 of the decision of so-and-so, read with so-and-so, section 12.5 read with section 12.2, casts a continuous obligation upon the learned arbitrator to disclose from the commencement of the arbitration to the end. And then, my lord, the cases, my lord, are cited. And then 32, relying upon para 20 and 22 of HRT Corporation versus Gale, it is submitted that the mandate under amended section 12 in the year 2015, when 5th and 7th were introduced, would apply to the arbitrator in the instant case, irrespective of whether the arbitration commenced before or after amendment. My lord, I proceed on that basis. Then, my lord, come, my lord, our submissions.
Yes.
Now, my lord, para 38. To 40, my lord.
They did not specifically give up fraud.
Yes,
did
yes,
they?
yes, my lord. I'll
Later on.
Later on.
Achha.
My lord, these are all the arguments,
Argument,
my
right.
lord, which is, my lord, in line with what is there, because then, my lord, during the course of hearing, because, my lord, we are also in conversation with the bench.
Yes.
My lord, we have argued something, your lord has put a question, and my lord, we say. So, my lord,
Yes.
I shall presume, my lord, that whatever is recorded, my lord, is correctly, my lord, recorded.
Unless
Nobody-
taken before that,
Yes,
that
yes,
court. Yes.
Now, my lord, Mr. Ghosh has elaborated on the meaning of affiliate within the meaning of the 5th and 7th schedule to the Act. An affiliate can only be of a company and not of an individual in the instant case. Bulakidas Bhaiya. There is no proof or argument to say that SSIMIL was an affiliate of CNE Limited. There is therefore no ineligibility that can be attributed to the arbitrator. Then, my lord, as regards the argument of non-disclosure amounting to concealment and fraud, Mr. Ghosh submits that there is no causal connection or link between the act of appearance for SSMIL and the less in the arbitration, as argued by the counsel for the award debtors. It is also argued that the writ petitioners' counsels have broad brushed the issues and made an unwarranted quantum leap to jump to a conclusion of fraud by reason of non-disclosure. Then, my lord, 40, I don't want to, my lord, go on to. And then 47, my lord, the unavoidable
Yes.
and unintentional overlaps between the professional engagement of a senior advocate and his duties as an arbitrator cannot be a ground for allegation of bias or fraud against the arbitrator. Reliance on this has been placed on paragraph 22 and distinguish the cases relied upon. Now, my lord, kindly see the findings, my lord, of the, my lord, court. Now, my lord, first, my lord, question where I have an issue, my lord, is, my lord, the question framed, which is being, my lord, addressed, my lord, by, my lord, the learned arbitrator. Is Mr. SSSMIL, Messrs. SSSMIL, an affiliate of Bhaiya Group? My lord, this is, my lord, a fundamental question, my lord, which was put, my lord, by, my lord, the learned single judge, my lord, to my lord. Now, having heard counsel for the parties, this court finds that the Bagri group has not seriously disputed, my lord, it should be, my lord, the Bhaiyas rather than Bagri. My lord,
Bagris are the Bhaiyas.
no, it's the respondent one. So that's probably an error, my lord. Has not seriously disputed the shareholding of Bulakidas Bhaiya and his family members in BG Chemicals, which has, now, my lord, kindly note, a controlling interest in SSMIL. Now, my lord, only over 25%, my lord. Except to say that members of Bagri family are also shareholders in SSSMIL, the control of Bulakidas Bhaiya in SSMIL through BG Chemicals could not be seriously disputed. So, my lord, we have a situation here. My lord, SSSMIL, my lord, is, my lord, the entity for which, my lord, the arbitrator had appeared.
Yes.
Now, my lord, BG Chemicals held slightly over 25% shares, my lord, in, my lord, SSSMIL. And, my lord, one of the claimants and his family, my lord, together, not the claimant alone, because I'll come to that limb, my lord, later. One of the claimants and his family, my lord, held, my lord, let us say over 90%, my lord, of the shareholding of BG Chemicals, which in turn, my lord, held, my lord, just over 25% in my lord SSIML.
No, BG Chemicals held over 25%, or these people individually?
No,
held?
no, just the BG
Ah, yes.
BG
No,
Chemical.
BG Chemical had 25%.
Correct,
over 20%.
correct,
Ah,
correct.
very well. And Bhaiya's held more than 90 in BG.
Correct. Bhaiya and his family members.
Bhaiya's, yes.
My lord,
Bhaiya and his bhabis and all.
no, my lord, kindly put it, claimant and his family member.
Very.
One of the claimants.
All right.
Then, my lord, portions are quoted, my lord, from, my lord, the affidavit. My lord, with regard to, my lord, which, my lord, would show, my lord, that there was no, my lord, serious dispute with regard to the shareholding, my lord, which is, my lord, being indicated. Then, my lord, para 49, my lord.
Yes.
In fact, maybe I should read, my lord. I had marked it for being read. I was going fast, my lord. Kindly permit me to read those portions of the affidavit, because it's important for, my lord, the conclusion which, my lord, the learned judge, my lord, has arrived at. The allegations made in para 4 of the petition are denied and disputed. It is denied that information given by learned arbitrator to the
So,
parties.
this is your affidavit in opposition to their section 34. Right.
Correct. As is evident from the minutes of the first sitting, in itself amounted to a representation that he would not appear for representation or advise Bulakidas Bhaiya or any of his companies in the course of the arbitration. It is denied that petitioners FTL and Abhishek Kotari agreed to the learned arbitrator entering upon reference and continuing with arbitral proceeding, clearly with the understanding that learned arbitrator would not act as legal advisor of Bulakidas Bhaiya or any of his group companies during the pendency of the reference as alleged. In this connection, it is stated that several sittings were held after so-and-so, and the advocates appearing for the award debtors before the arbitrator were well aware of the fact that the learned senior arbitrator had appeared in SSMIL appeal in his professional capacity. In fact, the learned senior advocate, Mr. Jishnu Shah, had also appeared in other matters of SSMIL.
Mr. Jishnu Shah was there.
Yes.
Counsel. Yes.
As such, it was thoroughly unnecessary to record the same at that time, since the learned arbitrator had already made the disclosure under 12 and the parties had consented to his appointment. No application was made challenging his qualification, independence or integrity, even though it continued after February 2020. At every meeting, the representatives of the applicants were present and no one raised any objection. The learned arbitrator is a senior advocate and had been associated with the suit of 1996 at all times. The plaintiff in the suit, SSMIL, is not a party to the instant arbitration, and there was no reason for the learned arbitrator to disclose the proceedings and appeal arising out of the decree passed in the said suit. My lord, kindly just make a note of that. My lord, SSMIL was not a party. If you, when I go through the schedules, my lord, one relates to advise on the subject matter of the dispute. One, my lord, refers to, my lord, a connection, various connections, relationships with the parties. And, my lord, the third important thing, my lord, is an affiliate of a party.
Yes.
Now, my lord, in fact, some of the respondents in the arbitration proceedings are also shareholders in SSMIL. Inder Kumar Bagri, Gopal Das Bagri, Rama Bagri, and knew of and were deemed to have known about the appeal. It is unfortunate that the applicant is insinuating that the advocates appearing for the claimant in the arbitration were also representing the appellants in so-and-so. As mentioned above, learned arbitrator is an eminent and popular senior counsel and has even appeared with the advocates appearing for the applicants, and in particular learned senior advocate so-and-so and advocate Sandeep Agarwal in numerous matters during the pendency of the arbitration proceeding. In fact, I have been informed by award holder number 2 that learned arbitrator held several conferences with the aforesaid advocates of the applicant respondent during the continuation of the arbitration proceeding. Moreover, the learned senior advocate Jishnu Shah had also appeared for SSIML and other matters from time to time during the continuance of the proceeding, and as such, the insinuation made about advocates appearing on behalf of claimant is not appropriate. my lord, battle between my
That
lord, Mr.
is nice. Yes.
My lord, Mr. Shah and my lord, Mr. Dhruvo Ghosh.
Yes. Yes.
That is
Precisely.
yes, my lord.
Precisely.
That's
That
what I.
has nothing to do with
My
the
lord,
arbitrators.
my lord, when I asked my learned friend, he said, well,
They have to
he said
defend
something
themselves
about
before-
me.
Yes. So they have to
Yes, my lord, cancel each other out.
cancel each other.
He state
Yes.
that the allegations made in the
But still does not have anything to do with the arbitrator. Arbitrator's liability remains
Correct.
to disclose. all.
Yes, are irrelevant and bad taste and improper only because the learned arbitrator happens to be a busy senior counsel working with different advocates and who happen to represent the parties does not ipso facto disqualify him from appearing as an arbitrator. The appearance of learned senior counsel, including, could not have under any circumstances led the applicants to reasonably believe that he appeared for other matters for BD Bhaya or his companies. In fact, there is no other matter wherein the learned arbitrator appeared as counsel for BD Bhaya or his companies as alleged. Copies of orders evidencing the fact, etc. Then, my lord, this is the finding. A conjoined reading.
Mr. Mukherjee, before proceeding, only one question. After this hiatus period, was there any hearing afresh on merits?
Yes, 13 sittings.
13 sittings were
13
there on merits again.
Yes.
Let us continue.
From a conjoined reading of the extract from the affidavits as above, the declaration of the arbitrator in the first sitting also extracted here and above. The shareholding pattern of BG, its 27 odd percentage shareholding in SSMI and the other shareholders of SSIM, it could be inferred that Bulakidas Bhaya has overall control and management of SSMIL and Messrs. CNE Limited. My lord, this jump to CNE Limited, my lord, I'm still, my lord, searching for that.
C&D is your
Claimant.
claimant.
My lord, there is no shareholding held by SSMIL and CNE.
All right.
Then, my lord, I'll
Still
just,
one question you have to answer.
Yes, yes, of course.
my lord, I can also,
Many others.
Yes, yes.
it can also be inferred. Now, my lord, this is also an inference
Yes.
that the managers, directors, and employees are accustomed to act as per the role, wish, and dictates of Bulakidas Bhaiya. Now, my lord, I pause here. Managers of which company? If I may ask myself this question. And these are inferences. And I'll take, my lord, the three companies, my lord, which are referred to in this paragraph, and, my lord, demonstrate to your lordships, my lord, at least in two. My lord, this could never have happened.
Mr. Mukherjee will be back in
Yes, yes,
10
my lord.
minutes. Sorry, Mr. Mukherjee, please.
No, no, no. My lord, I was, my lord, at page, my lord, para 52.
Yes.
In fact, my lord, para 49 at page 1589.
Yes.
From a conjoined reading of the extract from the affidavits as above. So, my lord, what I had read out to your lordships, the declaration of the arbitrator in the first sitting, which I have also placed with your lordships, my lord,
Yes.
also extracted here and above, the shareholding of BG Chemicals Limited. Then, my lord, it's 20, which is, my lord, over 90% held by the one of the claimants and his family. It's 27 odd percentage shareholding in SSMIL and the other shareholders of SSMIL. It could be inferred that Bulakidas Bhaiya has overall control and management of SSSMIL and C&E Limited. So, my lord, there's one person, my lord, who's controlling both SSMIL and C&E Limited. Now, my lord, assuming, my lord, he is, my lord, controlling C&E Limited. Assuming, my lord. My lord, it has to be shown, my lord, that he is also controlling SSMIL. My lord, there's no evidence of that. Then, my lord, it can also be inferred. Now, my lord, this is very important, that the managers, directors, and employees are accustomed to acting as per the sole wish and dictate of Bulakidas Bhaiya. There is no evidence. My lord, first, my lord, which entity, my lord, do these directors and managers belong to? My lord, is it C&E? My lord, is it SSMIL? Is it, my lord, BG Chemicals? Or, my lord, all of them? Or, my lord, two of them? And if two, then which two? My lord, nothing. But, my lord, it's all, my lord, really rolled up in one. So, my lord, the first adjudication, my lord, which really happens here is, my lord, that, my lord, Bhaiya controls both. And, my lord, this finding is arrived at on the basis of, my lord, the facts, my lord, which have been enumerated above, my lord, and, my lord, reiterated in para 49.
Yes.
My lord, in my respectful submission, my lord, this, my lord, by itself, my lord, does not establish it at all. My lord, I'll show, my lord, the... Now, my lord, comes, my lord, para 50. In GA1 of AP 364 at para 3, it has been averred that Bulakidas Bhaiya has founded ChemCrown India Private Limited, which is the former name of SSMI. This is the example I gave your lordships. We form a company, we found it.
Yes.
My lord, as on a given date, whether it's still under my control, I may be a shareholder, my lord. But, my lord, whether it's under my control has to be determined. Then, my lord, Mr. Bhaiya, now, my lord, kindly see where this is leading to. Mr. Bhaiya was personally present in most of the sittings in the arbitration. So, my lord, he's a claimant. My lord, he's present. Now, my lord, it could therefore, kindly see the inference, it could therefore not be difficult to believe that he must have personally attended most of the conferences with the learned arbitrator at the time of briefing for appearances in connection with APD 252 between January and December 2008. My lord, because he's attended the arbitration, where, my lord, he's a claimant. And
because he's in the habit of attending conferences.
No, but, my lord, I can understand, my lord.
That can only be that can be the only premise. He has a habit of attending conferences with his counsel.
My lord, here, no, my lord, let's put it this way. My lord, the fact that he attended arbitration sittings, which are, my lord, adjudication proceedings, where he's a claimant himself. Bhaiya is also a claimant, along with C&E. My lord, would lead to the inference that, my lord, number one, that there must have been conferences relating to the appeal, my lord, with S.K. Kapoor, where, my lord, he would, my lord, have attended. Though he is, my lord, not, my lord, a appellant, my lord, in those proceedings. It can only be, my lord, on the basis that, my lord, Bhaiya and, my lord, SSMIL, my lord, are, my lord, equated to be, my lord, one and the same. And it's an inference, my lord, which is being drawn that merely because, my lord, he attended arbitral proceedings where he was a claimant, he must have attended first conferences were held, my lord, by clients' representatives were asked, not just, my lord, the advocate on record or juniors. And second, my lord, if client's representative was asked, my lord, Bhaiya would have attended those conferences. Now, my lord, kindly see, my lord, para 51. My lord, this is not even, my lord, a case. Family-controlled companies are commonplace in India. The control of the family is exercised either through direct shareholding of the family members or through other companies controlled by the same family or a member of the same. Now, my lord, I pause here. My lord, it's taking, my lord, judicial notice of, my lord, understanding, my lord, of what the business environment is. My lord, the learned judge's understanding of, my lord, what it is. It's not, my lord, the law. This is not, my lord, the law. It has to be, my lord, it may be the practice, my lord, in, my lord, let us say, my lord, the Birla Group. My lord, it may not be a practice in the Reliance Group. My lord, it may not be a practice in what we term as the Mahindra Group. And, my lord, it was established where my learned friend, my lord, was assisting, my lord, me, my lord, in the Tata Group. We succeeded right up to the Supreme Court. That Ratan Tata was not the person who was controlling everything. And, my lord, that was all based on facts. Yes, it does. My lord, at the most, it could happen, my lord, in a family. But control by itself.
You can't generalize.
Yes. Cannot, my lord. We have to look at it here because we have to equate. Then, my lord, the above proposition is clear from the expression control and management as explained succinctly in the case of ArcelorMittal. And, my lord, paragraphs 50 and, my lord, 51, my lord, are quoted. Then, my lord, if your lordship goes to the next volume.
Whatever. ঠিক আছে দিয়েছি আচ্ছা এখানে আছে বসু আছে 13 yes.
And your lordships, my lord, would recall, my lord, that control here is with reference to the takeover code, my lord, 21C. And, my lord, the Honorable Supreme Court, my lord, said that, my lord, control, my lord, in, my lord, the takeover code, my lord, means, my lord, proactive control. In other words, I can get these things done by virtue of A, B, C, or D. Factual situation being there. Reactive control, which is merely having slightly more than 25%, is not control. Because, my lord, there, my lord, I am preventing things. Because 25% is required to block a special resolution. So whatever requires a special resolution, my lord, I can, my lord, block. It's, my lord, what is termed a reactive control, not a proactive control. Now, my lord, at the highest, my lord, on the basis of the facts as disclosed here, assuming
You could not take affirmative action.
Correct.
In a
Absolutely.
sense.
Absolutely. Because that is real control. The other is, my lord, back to the wall, my lord, pushing someone away.
Yes.
It's reactive.
React.
You can't throw me out. I have some rights. Unless, my lord, there are shareholder agreements, voting arrangements.
Those are not come
nothing.
here. Not come.
But those have been relied on. Otherwise, in a position to. How? By being, my lord, head of the Bhaiya family, or, my lord, because he's attended arbitral hearings. Then, my lord, kindly come to the next one. In the context of the Income Tax Act, the Supreme Court recently, in the case of Man Sarovar Commercial versus Commissioner of Income Tax, reported in so-and-so at para 71 has stated, the sum and substance of the above decisions of this court, as well as various high courts, would be that where the head and seat and directing power, kindly note this, head, seat and directing power of the company and the control and management must be shown is not merely theoretical control and power, that is not de jure control and power, but de facto control and power actually, kindly mark the words, exercise in the course of the conduct and management of the affairs of the firm, that the domicile or the registration of the company. My lord, this is, my lord, one of the oldest line of cases, my lord, which is, my lord, where, my lord, would the tax be imposed? My lord, there were various, my lord, companies who had, my lord, head offices, my lord, in, my lord, tax havens, where, my lord, there was no business being carried on. My lord, they come to, my lord, a tax, my lord, country, my lord, which is not, my lord, a tax haven. My lord, the entire business is carried on there. But the profits are reflected, my lord, in, my lord, the head office. Question would arise, is it taxable? You say, no, I'm earning it there, but the activity is here. Then, my lord, who is the person? My lord, who is the directing mind? My lord, it's in those contexts. My lord, this. Now, my lord, this is, my lord, apropos control. So, my lord, in short, my lord, what the learned arbitrator, the learned single judge has said is, look, higher controls BG Chemicals, because he and his family have more than 90%. BG Chemical in turns
25 in SSI.
slightly above 25. Learned judge says 27. According to us, is not even 26, but it's slightly above.
As you said, between 25 and 20 and 50,
Yes,
which is relevant.
Yes. Now, my lord, looking at that, says he's in a position to control Chem Crown. But, my lord, the next step, my lord, so Bhaiya is in a position to control Chem Crown. That is, my lord, the first link, my lord, I say no. It is not so. You have to show something more. Then the learned judge says, now, my lord, assuming, my lord, that directors, managers, etc., my lord, which doesn't say which entity, my lord, let us say, my lord, is referring to, learned judge is referring to Chem Crown. My lord, where is the evidence of that? My lord, the 5 factors which the learned judge has considered do not lead to that. And, my lord, then, my lord, next is, where is the jump then to, my lord, CNE? There's no nexus. There is, my lord, no allegation or finding that, my lord, SSS MIL controls, my lord, CNE.
BG Group is not one of the parties.
No, BG Chemicals,
BG Chemicals is
not a party.
It's an intermediary to show the control of.
Yes, my lord, it's treated as a conduit.
In the line, conduit, right?
Yes.
Conduit is the right.
Yes.
Yes.
So, my lord, used, my lord, look, Bhaiya and his family have
90%.
90%. This, my lord, 90% translates to 26% in Chem Crown.
Yes.
Chem Crown was founded by Bhaiya.
Yes.
And then, my lord, therefore, there is control of not only Chem Crown, but also CNE, which is a claimant. So, in effect, you are appearing for the party.
Now, what is the connection between CND and SSMIL and Chem Crown?
Nothing.
Bhaiya.
Yes, that's Bhaiya. That's all.
All right. Now, what is the?
No, that's what sorry, man.
Sorry, CND is
a claimant.
No, CND is a family company of Bhaiyas.
1 minute. Yes, not only Bhaiyas, also Bagris.
Them.
Yes, that was the 397.
So that's why the. Yes. You started with that actually.
Yes. Now, my lord, kindly come to paragraph 54. My lord, page 1592. Given that the definition of affiliate under section 12 of the Act encompasses all the companies, including the parent company, this court, kindly mark this, is hesitant to hold that SSMIL is an affiliate of CNE Limited of the Bhaya Group in the arbitration. Mr. Ghosh's argument that an individual, that is Bulakidas Bhaya, in control and management of SSMIL does not qualify as an affiliate cannot be accepted by this court. Now Millard is hesitant to hold that they are affiliates.
Probably this was an error. Otherwise it would be contradicted.
Absolutely.
Hesitatingly holds maybe.
That's what I, Millard, said. Millard hesitatingly holds.
Yes.
And Millard, I
have some hesitation, but
still hold. Millard, that's how I would read it. That's how I would read it.
The difference between a few and few. There are few people who know this law. But there are few people who know this is completely different. Maybe hesitating in that context. So let us go by that.
I'm going by that.
Yes.
I'm going by that. Millard, I am taking the worst Millard scenario.
Scenario against yes. Yes. That is the right way, Mr.
Millard, that's. Oh, Millard, you just put the worst scenario for me to answer it, which I also enjoy.
You always do that.
Millard, yes.
You always do that.
Millard, I always enjoy
particularly when people like you are there.
No.
You always do that.
Millard, if I may digress, just 1 minute, Millard. Justice Ajay Nath Ray, Millard, whenever I appeared, Millard, before the learned judge, Millard, I know, Millard, I was very fond of him. He was very fond of me. But Millard, at times, Millard, the matter was to get lost. Because Millard, the Millard battle was Millard of wits.
Right.
Millard, I'm outplaying him, Millard, in chess or not.
I fully understand it. Justice Sanjeev Banerjee's bench, I mean, during arguments, I was seriously arguing a premises tenancy matter probably. Suddenly, all of a sudden, Justice Banerjee said, do you know that the double helix has been discovered in some period which it should not have been? I was just taken out of context. I mean, double helix. Then I I mean, he was in a completely different.
Millard, he remains that way.
He remains that way.
And more so, Millard, if I appear, Millard,
yes,
it's more so. And your lordships would have felt it, Millard, when your lordships, Millard, for a brief period, Millard, in the division bench.
Not a brief period. He was my mentor in a sense.
Yes.
And he used to say, when he sat in the other building, this is my domain, let me do whatever I do. And when he came here for the order for 10 matters, he said the reverse, and I'll go to sleep. You do. So that's why he's so lovable, actually. Yes, let us come back to Mr. Ghosh.
Yes, Mr. Ghosh's argument that an individual, that is Bulakidas Bhaya, in control and management of SSMIL does not qualify as an affiliate cannot be accepted by this court. The said Bulakidas Bhaya and his family members directly and indirectly do control and manage SSMIL and CNE Limited, and the latter two companies function as per the wishes and dictates of Bulakidas Bhaya. So, my lord, these two companies, my lord, have my lord Bulakidas Bhaya in control.
Even if the worst case scenario, as you said, can be taken against you, Bulakidas Bhaya has 90% control over this this middle company, that's conduit, BG, and BG has 25
correct
plus.
My lord, it cannot be.
So even BG does not have, you are saying.
Correct, control. Right. That is number one.
Yes.
Next, my lord, I'll show the definition of affiliate. My lord, they cannot form.
Right. It has to be between companies.
Correct. The definition in my lord, the my lord Arbitration Act in the schedules, they gave a definition.
Can there be a piercing of the corporate veil in that context?
Even here, that has been done.
That is being done. That's what
that has been done. My lord, I'll come to piercing later. My lord, a case has to be made out for piercing. Also.
Piercing of veil is a different concept altogether.
Yes, yes.
Anyway, even
now, my lord, kindly see. My lord, in fact, my lord, the view was, my lord, in my lord ArcelorMittal, which I'll also point out, that my lord, where my lord, the statute has provided, my lord, the extent of piercing of the veil, courts cannot go beyond that. My lord, these were, my lord, the first line of all the 29A cases. My lord, where, my lord,
we are waiting for a case where we'll distinguish between piercing a veil and lifting a veil.
Yes.
There's a qualitative difference.
Yeah,
qualitative difference.
Yes.
How far we can lift or pierce.
Yeah.
Anyways.
My lord, Rukh se hi naqab is, my lord, lifting the veil.
Now we will not dwell on that. Just beyond affiliation.
Now, my lord, kindly see, my lord, the said Bulakidas Bhaya and his family members directly or indirectly do control and manage and the latter two companies function. Now, my lord, kindly note this. And the latter two companies function as per the wishes and dictates of Bulaki Das Bhaiya. This court is therefore of the view that an individual or group of persons, including a family and control and management of a company,
Oh, actually lifted.
that's what I said, upon lifting of its corporate veil, can definitely qualify as an affiliate. Now, my lord, what happens here? So the learned judge is holding that an affiliate can be an individual or, my lord, a family, my lord. A family can also be, my lord, an affiliate. And, my lord, that can, my lord, for that to happen, my lord, the corporate veil, my lord, has to be lifted. Because you look who's behind, my lord, that corporation.
If the human agency is the commonality between the two, then it has to be lifted.
Yes.
Yes.
Now, my lord, upon lifting of its corporate veil, can definitely qualify as an affiliate within the meaning of explanation to the 5th and 7th schedules read with section 12 of the Act of 1990.
This is a very interesting interpretation.
Yes, and now, my lord,
you'll destroy the interest in that.
No, my lord, my lord, hopefully, my lord, give your lordships, my lord, something to, my lord, think about apropos this. My lord, I want to show your lordship, since we are on this, my lord, before, my lord, I really develop, my lord, the argument, because we are coming to the next aspect. My lord, everything is, first is affiliate.
Yes.
Then, my lord, there is violation of, my lord, certain schedules. My lord, certain provisions of the schedules, 5th and 7th. So, my lord, before, my lord, anything else, I just want to touch upon what is affiliate. My lord, before we go, my lord, because the provisions of the schedules also use the expression affiliate.
Affiliate, yes.
Now, my lord, kindly take the Arbitration Act, my lord.
Yes.
Now, my lord, kindly take first section 12, my lord.
Yes. Section 12.
My lord, does your lordship's book, my lord, have the footnotes which would show the position before the 2015?
Yes.
My lord, kindly take that first, my lord.
The prior position.
Yes, prior position.
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances likely to give rise to justifiable doubts as to his independence or impartiality.
Wider.
Much wider. My lord, and my lord, is what the arbitral tribunal might feel.
Perception.
It's the perception of the arbitral tribunal.
Arbitral tribunal.
My lord, I might say, my lord, if I were an arbitrator, that, my lord, my chamber junior's sister is a director of a company which is before me. Others may feel it's wholly irrelevant. I do not know the sister, nothing.
It works both ways actually. Wider in the sense that you had to disclose more, and wider, but more restricted in the sense that it depends on the perception, as you say. As you now you say. So standards differ.
Correct. Standards differ. My lord, many people, my lord, in our court, my lord, appear, my lord, in, my lord, the chamber seniors, my lord, court, who is, my lord, the sitting judge.
Yes.
And many don't. Vice versa. Juniors also, seniors do not appear,
and
but
also
some
regarding
seniors
acceptance of briefs, Mr. Mukherjee, like if I ever appear for anyone, appear against anyone, even if in some unconnected matter, suppose I appear in a commercial matter and a matrimonial suit of that person, I never used to take a brief. So we don't know.
Yes, so we have different
standards. So many people take it and quite justified in taking that also, if it's a different matter.
Yes.
So standards totally vary.
Correct. Now, my lord, this was the position.
But this has changed.
Yes, that's what I want to show. Now, my lord, now kindly come to the new section.
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. Now, my lord, kindly, my lord, note this once. It says existence which is direct or indirect. In what? Any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute.
So either subject matter or parties.
Parties. And my lord, it could be a direct or indirect, past or present relationship.
Yes.
Then, my lord, the nature of, my lord, the interest, financial, business, professional, or other kind,
Yes.
which is likely to give rise to justifiable doubts as to his independence or impartiality. My lord, B I am not concerned with for the time being.
No. Professional interest or relationship with any of the parties comes into play here.
Correct, correct. Professional or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. Now, my lord, kindly see. Explanation 1. This is, my lord, after B, my lord, which is very important.
Yes.
The ground stated in the 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. So, my lord, the 5th schedule, my lord, is a guide. Then explanation 2. The disclosure shall be made by such person in the form specified in the 6th schedule. Then, my lord, subsection 2 is important. Now, my lord, what happens? My lord, we had, my lord, at the time of appointment,
Inception.
my lord, 10th of August 2014, my lord, a subjective, my lord, declaration that this is what I feel could give rise to. I'm letting you know. My lord, he was, my lord, fairly expensive. My lord, I should say. My lord, I appeared for, or any of companies controlled, etc. Then, my lord, comes this amendment. Because there's a continuing obligation.
Throughout.
Yes. So, my lord, once the amendment comes in, it's a guiding factor.
This comes in.
This comes in. So, my lord, his disclosure, my lord, is
Also because the alleged offensive acts were done after
correct,
this.
correct. So, my lord, that's how I'm
Right,
looking at it. So, my
Apparently,
lord, I am not in dispute. That's my argument, my lord.
yes.
What I'm saying is now, therefore, my lord, when I do not disclose, it has to be tested
Fifth
on the
and
basis of the grounds of, my lord, the 5th,
Fifth.
and, my lord, not, my lord, what I said earlier, but, my lord, 5th, because that's now guiding me, or has to guide the arbitrator,
Yes.
as also the parties to the arbitration,
Yes.
and, my lord, the 7th schedule.
Yes.
Now, my lord, kindly see. An arbitrator,
Previous, sorry, Mr. Mukherjee, also previously, when a person is approached in connection, he had to disclose.
yes,
So previous provision does not govern this at all in
correct.
any event.
I'm grateful.
Because continuing it,
Correct.
if it has to be continuing liability, then it has to be by
Correct.
virtue of this amendment.
Correct, correct.
So then 5th schedule comes in as a circumscribing factor.
Correct. Now, my lord, kindly see.
Yes.
An arbitrator from the time of his appointment
Hmm.
and throughout the arbitral proceedings shall, without delay, disclose to the parties in writing any circumstances referred to in subsection 1. That is, my lord, now the new subsection 1.
Yes.
Unless they have already informed of them by him. My lord, this is, my lord, I'm proceeding on the basis, my lord, already informed would not apply here because this happened, my lord, subsequent.
Yes.
Now, my lord, an arbitrator from the time of his appointment and throughout the arbitral proceedings shall without delay disclose to the parties in writing any. So, my lord,
But he
throughout.
had disclosed this connection. This connection was not disclosed.
Okay.
His SSMI, nothing was.
Now, my lord, all that he said, my lord, was that he had in the past,
Yes.
my lord, appeared for hire and companies under his control. And, my lord, nobody has alleged that he had, my lord, appeared for, my lord, SSMIL, my lord, prior to that. Now, my lord, an arbitrator may be challenged only if, my lord, these grounds, and, my lord, may challenge an arbitrator appointed by him or participate only for reasons of which he becomes aware after the appointment has been made. And then, my lord, 5, kindly see. Notwithstanding any prior agreement to the contrary, any persons whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be, now kindly see, ineligible to be appointed as an arbitrator. One is guiding, second is, my lord, ineligible. And, my lord, but kindly see the proviso, provided that the parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing. So, my lord, 5, my lord, can be waived, my lord, in writing. Let us say, my lord, I made a disclosure during the course, it's not during appointment, during the course, that I am actually appearing for Bhaiya in a particular matter. Do you have an objection? It can be waived, my lord, it may not be in writing. Disclosure has to be in writing, but, my lord, it can be waived otherwise.
No, but proviso?
That's for, I'm talking about explanation 1, 5th schedule. 5th schedule is also waivable.
But that can be by without.
Yeah, without writing. But here, my lord, applicability, my lord, of 7th schedule has to be in writing, because these are seen as ineligibility provision.
But it's what I'm saying is extremely restrictive. But it says ineligible to be appointed as an arbitrator, not to continue as an arbitrator. But maybe that would be too restrictive.
Yes, my lord,
it becomes de facto
yes.
ineligible. But the express language is used appointed.
Yes, my lord, one of the arguments also is going to be that 7th schedule would not have applied because it relates to appointment.
Yes, maybe that would be too restrictive. Keeping in spirit with the.
My lord.
But even then, that's a valid argument.
Yes, my lord, we'll make that argument. I'm telling you, lord, or warning you. Lordship.
Weaker arguments, one of the.
Yes, my lord, I have not put it up front. My lord,
No,
I've indicated the 4, my lord, which I'm going to put up front.
Right.
But, my lord, as far as 5th schedule is concerned, my lord, that is, my lord, ongoing. Clearly, my lord. Yes,
no
my lord, is not, my lord, only, my lord, at the time of, my lord, appointment. Now, my lord, kindly take the schedules. My lord, the 5th schedule.
Item 2.
Yes, but, my lord, I just want to point out there's probably a mistake.
Yes.
5th schedule refers section 12(1)(b). My lord, it's not 12(1)(b).
No.
It's, my lord.
Oh, right. Right.
Then, my lord, the following grounds give rise to justifiable doubts as to the independence or impartiality of arbitrators.
Actually, 12(1)(b) is a misnomer.
Yes. Cannot be.
It has not been, it still remains.
Yes.
I've never noticed this, yes.
Now, my lord,
Takes care of it.
my lord, kindly, my lord, see, my lord, the arbitrator, my lord, I'm just reading one,
Yes.
my lord, because there's one case which I will, my lord, refer to, HRD, my lord, which shows, my lord, how these are to be construed, 1 and 2. My lord, the arbitrator is kindly mark the words, is an employee, consultant, advisor, or has any other past or present business relationship with a party. Then, my lord, 2. The arbitrator, now, my lord, kindly mark the words, currently represents or advises one of the parties or an affiliate of one of the parties. My lord, I'm for the time being highlighting, my lord, currently represents. And, my lord, these, my lord, is an employee consultant, have, my lord, both been interpreted, my lord, in HRD. Then, my lord, 11, my lord, has also, my lord, been relied on. The arbitrator is a legal representative of an entity that is a party in the arbitration. So, my lord, legal representative of an entity that is, my lord, a party in the arbitration. Now, my lord, the Arbitration Act contains, my lord, a definition of, my lord, legal representative.
The legal representative, not in the other sense.
My lord, I'm arguing both.
Acha.
My lord, first is, my lord, legal representative in, my lord, the sense which your lordships, my lord, and I, my lord, initially, my lord,
Yes.
would, my lord,
Take it.
take it, my lord.
Yes, yes.
And my lord, in any event, my lord, or otherwise, my lord, at the highest, my
This
lord,
consultant has been used separately also.
correct. So, my lord, the arbitrator is a
Buyer
legal
of fund is
representative.
also there
Yes.
separately.
The arbitrator is a legal representative of an entity that is a party in the arbitration. So, my lord, it could also be, my lord, if we go by the definition, my lord, an heir.
Only two can apply at best.
My lord, two is what has been looked at. My lord, I am telling your lordships what the learned judges have. My lord, learned judges, my lord, considered as a violation. My lord, one is 2, one is 11, one is 15. And I want to show, my lord, that none of them will apply. Because the learned judge's finding, my lord, I'll come to that now. I
Yes,
just
15
wanted to
also.
place it.
15 also.
15 has given legal advice or provided an opinion. Now, my lord, it won't apply because it has to be on the dispute. On the dispute to a party or an affiliate of one of the parties. And then, my lord, comes 20. The arbitrator has within the past 3 years. So, my lord, there's a distinction being drawn between counsel. Served as counsel for one of the parties or an affiliate of one of the parties, or has previously advised or been consulted by the party or an affiliate of the party making the appointment in an unrelated matter.
But this he disclosed. Bhaias.
Well, that was first.
Yes. Within 3
The
years.
question is whether the continuing obligation.
Ongoing relation.
Yes. But the arbitrator and the party or the affiliate of the party have no ongoing relationship.
No ongoing relationship with Bhaias was established apart from SSMIL.
Correct.
In this case.
Correct. Now, my lord, kindly have a look at the explanation. My lord, explanation 1, the term close family member refers to a spouse, sibling, child, parent, or life partner. Explanation 2, and that's what's relevant, because, my lord, the first point I will make, my lord, that assuming, my lord, we look at, my lord, the possibilities, my lord, of, my lord, 2, 11, 15, and 20. My lord, the fact of the matter is, my lord, the arbitrator has not appeared for any of the parties.
Has to be a juristic person. Affiliate also has to be a juristic.
Correct. Now, my lord, that is number 1. My lord, the reason I'm, my lord, saying this is, the allegation is not that you appeared for a party.
No.
The allegation is that you appeared for an affiliate.
Yes.
Now, kindly have a look at affiliate. The term affiliate, all companies in one group of companies, including the parent company. So, my lord, all the companies have to belong to one group.
But group company is an entirely different concept from controlling interest.
Correct. I'm grateful. And, my lord, it has to have a parent company.
Yes.
Now, my lord, the question would arise, my lord, what is the parent?
Then it has to be subsidiary.
I'm grateful. There has to be a parent, and then we have, my lord, a group of companies. That entire group, my lord, can be traced to the parent. This is, my lord, the affiliate. Because if we take party out of the equation, my lord, then what has to be established is not that Bhaiya was the parent.
So even if one person has controlling interest in several companies, they do not automatically become group companies by virtue of
I'm
that.
grateful. And my lord, there has to be a parent.
Yes.
And my lord, the parent is a parent company. That also has to be a juristic entity.
Yes.
My lord, this is, my lord, what, my lord, the issue is. Now kindly have a look. My lord, kindly come back, my lord, to, my lord, the impugned order at page 1592.
So let us clarify this first, Mr.
Yes,
It's our doubt.
Yes.
That now, therefore, even if you pierce the or leave the corporate veil, whatever you do,
You see an individual.
boils down to an individual. So does not come with an affiliate under explanation 2.
Correct. Now, my lord, I want to just add another point. My lord, and I'll show, my lord, since we are on affiliate. I've shown your lordship, my lord, the definition. My lord, this definition came, my lord, from the IBA guidelines. My lord, held to be so. My lord, that Schedule 5 and Schedule 7 have come from IBA guidelines. My lord, has been held to be so, my lord, in HRD by, my lord, the Supreme Court.
We'll have to look into that.
Yes, my lord, I'm just indicating, my lord,
Yes,
where I'm,
yes.
my lord, going.
Yes.
Second, my lord, IBA guidelines, my lord, were, my lord, of 2004, my lord, at that time. Sorry, 2014. My lord, just kindly make a note, my lord. I'll just come back to IBA guidelines 2014. My lord, had, my lord, the same definition of affiliate. My lord, 2024, the rules were amended. By, my lord, IBA. And
Which means the guidelines were amended.
yes,
Yes.
by IBA, my lord.
Yes.
Now, my lord, there, my lord, now individuals have been included.
So therefore, you mean to say by specific exclusion? I mean,
We have not, my lord, amended ours till now.
that's conspicuous.
Correct.
In its absence.
In its absence. It wasn't there earlier. My lord, in any event, we adopted it from the guidelines. We kept it to, my lord, juristic entities. We are very clear, my lord, what is meant.
Because like the uncitral model of the 96 Act, probably the uncitral model had some scope of challenge, interlocutory challenge against jurisdiction issue.
Yes.
But that was not adopted in our.
Correct.
Something like that was
Yes,
there.
my lord, one could approach the court.
One could approach the
Yes.
court. That is
Absolutely.
deliberately omitted.
Yes.
So by specific exclusion.
Correct. But here, my lord, 2004, it adopted what it was. But after the amendment of my lord, 2014, my lord,
2024 amendment?
Yes.
That was not.
Yes. Now, my lord, kindly come back to the impugned order, my lord.
Yes.
My lord, the question, my lord, which is put, my lord, the first question I had a reservation about, my lord, that it was, my lord, the really a wrong question, my lord, which was being put, which I showed your lordships, my lord.
Yes. Why do you say that?
My lord, kindly have a look at, my lord, paragraph, my lord, 48, my lord, findings of this court.
Yes.
My lord, at page, my lord, 1587.
Achha. So Bhaiya Group, affiliate of Bhaiya Group could not have been a proper question.
Yes. Is SSMIL an affiliate of, it has to be one of the parties, which had to be the corporate entity, which is CNE. So, my lord, the question itself, my lord,
gives the answer.
Gives the. I'm grateful, my lord.
It's a suggestive question.
Yes.
That's one of the things we have to look at while framing issues.
Yes. Now, my lord, kindly come to, my lord, next, my lord, chapter, my lord, which is in the judgment, my lord, which is paragraph, my lord, paragraph 55, just above that, 1592.
Has the arbitrator.
Has the arbitrator rendered himself ineligible under section 12(2) and 5 and grounds 2, 11, 15 and 20 of the 5th schedule and grounds 2, 8 and 15 of the 7th schedule of the Act of 1996. So, my lord, now the preliminary question in the application under section 36(1) and 34 is whether by reason of appearing for SSML on several occasions in APD so-and-so, the learned arbitrator rendered himself ineligible to continue the arbitral proceedings in an impartial manner. In other words, whether the arbitrator has fallen foul of any of the grounds under the 5th schedule in terms of so-and-so, section 12(2) of the Act and 7th schedule in terms of subsection 5 of section 12(5). So, my lord, first is, are you an affiliate?
Yes.
My lord, that is examined. But unfortunately, my lord, with a wrong reference. My lord, it is, my lord, not a leading and suggestive, my lord, question. My lord, which is,
Leading question.
yes, my lord, what I'd say, my lord, a wrong question, my lord, which is, my lord. And then, my lord, comes, my lord, the next.
As
now,
the philosophers say,
yes, now,
the answer lies in the
yes,
question.
Now, my lord, the moment, my lord, affiliate is answered, because affiliate is used right through, my lord, these, my lord, grounds, my lord, are taken and seeing, are you fitting into it or not? That's how it is. Now, my lord,
But probably, in all fairness, the learned single judge was trying to fit in the provisions with their arguments. The premise of their arguments was sought to be put in a frame.
My lord, I have known, my lord, all the judges, my lord, of this court for a long time. I'm not even arguing it, my lord. My lord, I'm just saying, my lord, that the finding was wrong because the wrong question, my lord, was, my lord, which is on a, my lord, basis of an argument advance.
Obviously.
A wrong reading, my lord, of, my lord,
Absolutely.
legal provisions. Now, my lord, para 59, my lord, kindly come to at page 1593.
Yes.
This court need not enter into an inquiry as to whether Bagri group came to know of alleged impropriety of learned arbitrator. What is important is whether the same would attract ineligibility under section 12(2) and 5 of the Act. So, my lord, one argument had been made by my learned junior that they actually knew and it is impossible for them not to have known. And particularly, my lord, my lord, search of the internet, my lord, globally, and then, my lord, the High Court website, my lord, that, my lord, they knew their shareholders and their family members, my lord, in one sense, sister, brother, my lord, are, my lord, involved. And, my lord, they just took a chance, waited, and then they came. But, my lord, the learned judge says that is,
yes.
my lord, the learned judge, my lord, took, my lord, view that no, the obligation was
irrespective of that.
Irrespective of that,
yes.
there is. Now, my lord, let us examine this. Then, my lord, 62, para 62. Given the very limited scope of challenge of an award under section 34 of the Act, the requirement of neutrality of the arbitrator has assumed the highest importance. No matter how fair and judicious an award may be, kindly note this, one cannot be oblivious to the fact that there is one side who will succeed in receiving the huge financial benefit and the other side shall be liable for the same. The consequence of the award and limited scope of challenge for the same are far-reaching for the parties. Then, my lord, 12(2), then observations in Vestal, Pioneering, Shinen, Himadri Chemicals, they're all cited. My lord, paragraph 66.
Yes.
My lord, what led to, my lord, the amendment? My lord, there's a Law Commission report also. My lord, I can, my lord, place that. In this backdrop, the Arbitration and Conciliation Act came to be amended in October 2015 by insertion of section 12(5). The object and purpose behind the amendment with regard to findings of the Law Commission have been already dealt with at length in Vestalpen, Shine and GmbH. In this regard, it may necessary to set out the observations and so on. Then, my lord, kindly see, my lord, para 68.
Yes.
This court is, however, not inclined to accept that non-disclosure by the arbitrator, having represented SSMIL in the High Court during the pendency of the arbitration, would amount to fraud. This is, my lord, a finding given, my lord, by, my lord, the, my lord, learned single judge. Then the next, admittedly, to establish fraud, a very high degree of proof is necessary. The same is required to be preceded by sufficient particulars included in the application under section so-and-so of the Act of 1996. Sufficient particulars are not available in the application or the affidavit filed to the application under so-and-so. Now, my lord, kindly have
So
a look.
Dewan is waiting for you to come to para 69.
I am, my lord, reading.
His legs are moving so rapidly that his movement can be seen on the upper body also.
I'll have to be a little careful now the way I'm saying.
Yes, 69 is very.
Yes. Now, my lord, Mr. Kohli, my lord, has candidly submitted in the course of his arguments that his clients do not wish to press the argument of corruption and bias against the arbitrator. In the above circumstances, the issue of fraud is not dealt with. This court even otherwise does not find any fraud having been committed by the arbitrator in the proceedings. So, my lord, first, my lord, there is, my lord, no finding, my lord, no case made out for fraud. Second, my lord, it's a submission made that, my lord, fraud, argument of corruption and bias is also not being made. So, my lord, the court says, I do not go into the question of fraud because of that. But now kindly see what the court does in para 70. It is, however, necessary to consider whether the arbitrator representing SSMIL, an affiliate of so-and-so, so-and-so, during the pendency of the arbitration, would either constitute bias or act likely to suggest or indicate bias on the part of the arbitrator. My lord, our submission is, my lord, once, my lord, during the course of hearing, in, my lord, fairness, my lord, in fact, there's an English case which I'll come to later, my lord, where the same thing happened. My lord, the disclosure wasn't made. And they said, sorry, if there is an error done by someone, my lord, depending on your conduct also.
Provided it is a waivable right, a waivable objection.
Yes, yes.
It has to be
correct.
amenable to be waived.
Yes.
If it's absolute bar, then no. And that you probably touched on that when you said that two.
Yes. Two, my lord, this is the continuing obligation. And 5, my lord, the waiver has to be in writing. Now, my lord, we also know, my lord, even where there is, my lord, provision for writing, my lord, where, my lord, settlement occurs, my lord, statement of counsel, when it's get recorded, we have our High Court division bench judgment as well. Because we are authorized, my lord, to, my lord, make statements which bind, my lord, the client.
But if there are judgments both ways, probably, Mr. Mukherjee, that if there is no specific power to give a concession on, because this is on facts also.
No, if there is, my lord, a specific power, my lord, regarding, but nobody said Mr. Kohli didn't have the power.
Right. Right.
Then, my lord, reference in this regard is made to para 8 of the decision in the case of Hashmukh Lal, so-and-so and others. Then, my lord, this is on all these cases, my lord, are on bias. My lord, it goes on. Then, my lord, whether it's, which is the correct test, real likelihood of bias or, my lord, real danger of bias. Because, my lord, the learned judge, my lord, adopts, my lord, not the real life. My lord, if I remember correctly, the apprehension of real likelihood of bias. Then came, my lord, danger of bias. And the learned judge, my lord, has said both up to a point and then says, I would accept there is a real likely danger of bias. So higher, my lord.
Higher.
It's higher than, my lord, likelihood. But, my lord, these are all cases, my lord, which, my lord, goes down. But, my lord, 77, my lord, is very important, my lord, in the interpretation.
But justice must not only be done, but also appear to be done. That comes in some way or the other.
Yes,
But maybe if it's statutorily
correct.
crystallized in a particular form, we have to go by that.
Yes, and my lord, the important thing is, an arbitral proceedings, my lord, are held in camera, so to say. My lord, it's, my lord, a forum established by, my lord, consensus. My lord, your lordships
Yes.
might recall the old line of cases.
Yes.
My lord, where, my lord, if an allegation of fraud was made, my lord, the person against whom an allegation of fraud was made could file a 34 and say, please do not send it to arbitration. I want to vindicate myself in the public forum because I've been accused of
Yes.
fraud.
Because the confidentiality aspect of arbitration is
Correct.
there.
So,
Any
my lord,
ADR confidentiality.
correct, absolutely.
That
My
is the,
in fact,
like party autonomy. It's
correct,
one of
totally.
the pivots of
I'm grateful. I'm grateful.
one of the pivots of. So therefore, it's all the more
Yes.
a reason to prove it.
Now, my lord, given the very narrow scope of intervention with an award under 34, the rigors of 12 and 5th and 7th schedules must be strictly and compulsively imposed.
You are reading paragraph
77, my lord, 1601.
Oh, right. Yes. Please continue. We'll
Yes.
catch up.
Such strict, compulsive, and rigorous imposition of the mandate of Section 12 is necessary to ensure that the institution of arbitration remains sacrosanct. After all, the parties are deemed to have imposed pious and reverent faith in one individual or persons to resolve their. Any infraction of 12, 2, and 5 and the grounds under 5th and object would desecrate the foundation of the institution. So it quite clearly shows, my lord, that, my lord, this is the reason, in spite of, my lord, during the hearing, my lord, point with regard to fraud, corruption, my lord, and bias being given up, the learned judge says that this is important. Therefore, I'm going to decide it. Now, my lord, bias, real bias, likelihood, danger of bias, my lord, that's the heading.
Judgment court করেছে আসলে অনেক বড় হয়ে গেছে এতগুলো
My
প্যারাগ্রাফ
lord, kindly come to para 85.
Yes.
It's clear and explicit from the above dicta that the conduct of an arbitrator and his duty to disclose commences and continues from the time of appointment of the till the award. It is a continuous any act that would suggest a likelihood of bias would, in most uncertain terms, lead to the termination of mandate. Then, my lord, the various tests, my lord, we go into.
What is this in the most uncertain terms?
My lord, your lordship's looking at, my lord.
Any act on the part of the last sentence of para 85?
Yes, my lord.
Any act on the part of the arbitrator that would suggest a
Like
likelihood of
would, in most uncertain terms, lead to the termination of the mandate of the arbitrator. So, my lord, this is
likelihood in most uncertain terms?
correct. Yes, my lord, I read it like that because, my lord, here, my lord, if the facts had been known, my lord, before the conclusion
Yes.
of the arbitral proceedings, there would have been a challenge procedure.
Yes.
My lord, that, my lord, they say, my lord, the search of, my lord, the globe
Later on.
came afterwards. Because there was nothing, obviously, during the course of arbitration to indicate, my lord, there was a likelihood of bias.
Yes.
Nothing. The corollary of that is, my lord, this. Now, my lord, kindly come to, my lord, paragraph 92, my lord. My lord, the definition, my lord, of reasonable man from Black's Law Dictionary is referred to. Then 92, my lord, court accepts it. And then Mr. Ghosh relied on a very interesting decision, my lord, AT&T Corporation versus Saudi Cable Company. But, my lord, the learned judge, after, my lord, that was cited, my lord, says in para 95, this court is of the view that this is conclusion of the Court of Appeals in the said case, upholding the mandate of the arbitrator after setting aside of the views of the High Court, may not apply to a case where there are codified rules like Section 12 and 5th and 7th schedules to the Act of 1996. My lord, there were ICC rules, my lord, which, my lord, have the force of law, my lord, when, my lord, an arbitral dispute. May I continue, my lord? Next one.
নেক্সট হার্ড আগের যে পার্টটা ছিল তার সঙ্গে অ্যাড হবে আগে একটা পার্ট দিয়েছি সকালে হ্যাঁ ওটার সঙ্গে একটু দেখে অ্যাড করে নেব হার্ড ইন পার্ট ফর ফার্দার হিয়ারিং
Wednesday
on
Budhar?
August 20, 2025. 20th
I have only one request to make. If not inconvenient, could it be the next day, 20?
No, I am not available. Let me conclude. You do
20th.
it.
So 20.
Mr. Dewan, let us hear
Let us
Mr.
put on 20th.
Yes, and if you are in difficulty, just ask for time. We'll put it
Yes.
your reply on the next.
Okay, I'm so
You
deeply.
can- Your junior can take notes
Yes.
of that.
I'm deep.
At 10:30 করে দাও।
I am mentioning one order 41 matter, urgency is this.
Order 41, we don't have determination.
Today and tomorrow, you lot.
No urgency, Mr. Rai.
No, my lord.
Bench cannot do no.
No, my lord. Why?
Presumption is there is no urgency.
Extreme urgency because plaintiff filed a suit for declaration.
Hand over the slip. Is there a caveat?
No. Let it be listed tomorrow, my lord.
Tomorrow also we have determination.
Yes, tomorrow. That's why, otherwise I should.
Can you please wait? Ask somebody to come back at 2 p.m. because 2 p.m. onwards we will be taking appellate set. Yes, just mention. It can wait till tomorrow. It will be listed.
I have
Similar answer. Yes. Thank you, sir.
May I have my lord's leave?
Yes, right.
My lord, order 41 matter.
What is the urgency, sir?
Urgency is, my lord, the plaintiff filed a suit for declaration and recovery of possession. Filed an application for injunction not to transfer me the property to third party. I am running a shop room there in the suit. Admitted. Now, my lord, the learned judge says in civil suits it will take a long time to decide the suit. So there is prima facie case of the plaintiff, and injunction is granted, my lord, restraining me from entering into the shop room and
Running shop.
in it.
Please hand over. কালকে এগুলো এই যেগুলো যাচ্ছে সেনের ডিটারমিনেশন will come from that set. Yes. 17. Yes.
Because if the matter will not come by tomorrow, so
let it be called on. If it is not called, yes. If it is not called on, please come back at 4:15 and just mention 4:15. But please keep watch. It may be called on before.
This is an mandamus appeal group 1. I want to file this memo without the certified copy. I have annexed the server.
Yes, leave is granted.
Your Lordship's kindly, my lord, an urgent, my lord, matter relating to the determination of my lord justice show mention.
What order for 1?
No, my lord, it's a first appeal. My lord, 19th is the date fixed for execution in the learned trial court. My lord, we are the, my lord.
You have filed an application?
Yes.
Write application and hand over.
But I have written application.
Give a notice to the other side if somebody is.
There is no KVF.
Well, yes.
My lord, on the last occasion, I have mentioned 16 review application. My lord,
yes. Those are.
No, my lord, I know, my lord, because the officer told me that main file has not come. My lord, only difficulty, my lord, kindly consider one thing, my lord. My lord has passed, my lord, the honorable division bench, my lord, this honorable division passed an order dismissing my application that is regarding on the ground of laches negligence.
Whatever,
of the
yes.
officer. My lord, fact remains that previously, though it was not within time specified by the another honorable division.
That is the ground of the review.
Yes.
Now, the file, why is the file not coming? কোথায় আছে?
No, main file, they are.
Generally tag the files because otherwise the files get misplaced. Trying to ensure it comes
And
tomorrow.
why, my lord, I am mentioning I could not.
No, we understand. There must be some urgency.
No, because, my lord, the check that is was in the name of the legal aid services. My lord, has already check.
Try to please as early as possible.
Swear, my lord.
আপনি আবার রিকুয়েশন করুন বলুন যে আমরা কোর্ট জিজ্ঞেস করতে কেন আছে yes
obliged
group 8 we have determination
yes
please yes
first miscellaneous appeal, my lord, in urgency there's, my lord,
justice change determination
urgency, my lord, I filed, my lord.
Mr. Chatterjee, the previous key. Huh?
Oh.
কোর্ট বলে দিন ওনাকে
Yes,
Respondent number 1 is going to take testing of my transformer, my lord, at Bhopal, my lord. Even after the 3 testing has already been done, my lord. That my lord, they
very well hand over. If there is a caveat, then inform the other side.
I have given already them notice.
No, give a notice. This is a different bench. Give a notice that it will.
I have given them, my lord, stay application and memo of everything I have served.
We are not the regular bench. Therefore, give a notice that you have mentioned before us.
Yes, my
they
lord.
might not be following.
Yes,
do that. এটা কালকে দিয়ে দেবেন জাস্টিস সেনের ডিটারমিনেশন yes
grateful, I am grateful.
yes
may I
what is the matter
The heading, my lord, to be mentioned.
why
Lordship, pursuant to Lordship's order, special messenger post could not be deposited within time.
hand over understood
My lord, inclusion of one recalling application, it was that matter which was referred to the landed honorable special bench.
recalling
Yes.
by this bench
By this
yes
bench.
My lord, may I permit to mention one to take leave, my lord, for my lord.
Filing without certificate copy.
No, my lord. A second appeal was filed, my lord. There was a defect, my lord. That is was, my lord, and the execution proceeding has already been initiated. And
What are you wanting now?
For appropriate order, my lord. Some
File it in the department and application. What appropriate order?
The matter was fixed for hearing on to the.
We don't understand. All orders we suppose are appropriate.
Lordship, for staying the proceedings of your execution proceedings.
So you file an application for stay.
Lordship.
The appeal has to be admitted under order 41.
No, Lordship, not admitted.
Not a second appeal.
Second appeal not admitted. Well, there is a defect, some defect. That is why. Well,
if there is a defect, how can we have it admitted?
Well, defect has already been rectified, my lord, by the.
What is the defect?
Well, there are some defects, my lord, that has.
No, mention before the regular bench. Justice Shen will take up. For one day determination, this is determination urgency, not matter urgency. Mention before, no, have it done before just the regular bench. Yes. Yes.
May I have your lordships kindly to mention a group 1 appeal.
Yes.
It was to appear on Monday. But may I pray for some preference in this matter, because I tell you, lordship, what has happened. But I had a lease of a property, my lord, in Salt Lake, residential lease. But it was allotted to me in 1978. But they have cancelled the lease in 2018. Thereafter, if I preferred a writ petition, my lord, challenging the cancellation, that has, my lord, I have, my lord, lost round 1. But therefore, my lord, it's a question of a residential property. My lord, some preference any day, my lord, gives you. Any day.
No, let it appear in the list first, then we'll consider.
Very.
Call on the list.
Hitting to the
2 p.m. will come.
Appeal for the petition, this is that matter, where the content arising out of order for payment of alimony and its arrears. On the last occasion, there was a dispute regarding the dues. But now there is a development.
Yeah, for the husband.
For the husband.
Yes, is that matter?
Yes,
yes. Wife has shown a very good gesture. She wants to sit with my client.
Excellent. So let us send it to mediation or what?
No,
formal mediation.
They are going to sit today only.
Excellent.
So
we'll take it up on some other
talk. Yes. May I indicate today evening when the parties are sitting after court?
We'll keep it on Monday.
No, on Monday, the matter, because Honorable Supreme Court is adjourned till Monday. On Monday, Honorable Supreme Court will take up the matter. So, the same thing has fallen from Honorable Supreme Court also. If any development happens in the meantime, the Honorable Supreme Court will also take the pass appropriate orders. Can you take it on Tuesday?
Tuesday. Both parties submit.
May I indicate just one thing?
Yes.
He has overstayed. He is now supposed to leave the country on Wednesday. If my lord kindly excuses his appearance from Wednesday
on
onward.
that I'm objecting. On that I'm objecting.
Why? Because you're
we don't know what will happen. Last time also the same situation happened. When we said
he has a job abroad. His job will go.
He's living on Wednesday.
He will give PDCs also. He'll give a check. And he will give PDCs also, post-dated checks also. To cover
post-dated
checks. That's what failed from Mr. Chatterjee on the last occasion. That was his suggestion. We have agreed to that.
On that I'm objecting. Can you give on Tuesday if he's living on Wednesday?
If he loses his job, that will not adhere to my...
No, what do we propose then? We'll keep it on Tuesday.
Very well. Tuesday,
he's living on Wednesday.
Monday could be.
Monday,
but if for some reason or the other it does not happen on Tuesday.
Let it come up on Monday.
Monday.
So great. Learned counsel for the parties submit that the parties are attempting a settlement of the matter mutually. Footstep. Accordingly, on the prayer of the parties, the matter is adjourned for the day and be listed on August 18, 2025 under the same heading. To be mentioned in August 18.
He will be here on Monday also.
At 2 p.m. At 2 p.m. At 2 p.m.
Can he record his personal presence? But has not recorded.
The alleged contemnor shall be personally present on the returnable date as well. Till now, let him be present. We will consider.
Great.
Try to settle it, Mr. Chokro.
Well, absolutely.
We are thankful, to the wife, for showing.
We are thankful to both of you.
Grateful.
No, if there's a mutual resolution, that's the best possible solution. Best possible solution.
Absolutely. Grateful, dear Lord.
Yes.
Item number 2, I am for the.
Talk about what does it matrimonial?
Matrimonial, I am for the husband appeal in My suit for divorce on the ground of desertion and cruelty has been dismissed.
Your suit has been dismissed.
Admitted.
To try a chance, take a chance in mediation.
16 years, we are not living.
No, mediation can mean either way. I mean, you may choose to part ways.
Yes. So,
none appears for the respondent at the time of call. Full stop. The matter arises out of the dismissal of the appellant's suit for divorce. Full stop. Learned counsel for the appellant submits that the parties are living separately for 16 years, more than 16 years. Full stop. Be that as it may, comma, since an exercise of mediation includes options, both of the parties parting ways or resolving their disputes and living together, comma, the matter is fit to be resolved by mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of having a mediation between the parties upon notice to both parties.
If
it fails, then you can always come back.
I appear for the respondent.
Both sides are there. Matrimonial.
Matter has come at my end. Yes, my lord.
You are the husband.
Husband, my lord.
You got a degree. Divorce degree.
Yes, my lord. Since, my lord, we want early disposal if the mediation is.
Let us try mediation. Yes.
Yes.
The matter arises out of a matrimonial suit. Full stop.
It was
Hard learned counsel for the parties. Full stop. The parties are, comma, in principle, comma, agreed to mediation. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of resolution of the dispute by way of mediation. Full stop. Thank you.
My lord, last occasion, my lord, please to direct the.
You are Mr. Bondhu.
Yes.
Yes. We remember. Yes.
But I am for the respondent.
Here for the respondent. Alimony application stage. Let it be sent for mediation. Everything will be resolved.
But this was referred to the mediation.
Already previously?
Already.
Failed.
Failed.
Why?
The quantum that was asked by the appellant wife, it is not being affordable by the respondent husband.
Yes, you come down a bit.
Well,
if they can't pay, what's the use of asking for that?
Yes,
Have another chance at mediation. We cannot do that mediation. We cannot negotiate. We are very bad negotiators. I can't speak for my learned brother. I am a very bad negotiator. So have another chance at mediation. It transpires. The matter arises out of a matrimonial proceeding. Full stop. It transpires that a previous attempt at mediation had failed. Full stop. The primary bone of contention appears to be at the present juncture, comma, the quantum of alimony payable to the appellant wife. Full stop. We express full hope and trust that if a mediation exercise is undertaken in the hand of qualified and trained mediators, comma, the parties may come to an amicable settlement between themselves on all counts. Full stop. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for having a fresh attempt at mediation. If it fails twice, then definitely we'll take up and decide the alimony and these. Grateful, man. Grateful. Thank you.
My lord, I am appearing.
Yes,
for
Mr.
the
You appeared yesterday also.
My lord, I have served notice to the other side.
Yes, I am here.
Yes. Don't look so menacingly at him. So let us have a chance at mediation. Your suit for divorce their suit for divorce was dismissed.
Yes.
So mediation means you can go either way. It may be kept this way, you will part ways, or you may come together, whatever.
Now, so far my assistance is concerned, things are not like that. We are not advancing for the mediation, mediate the matter.
Why?
It is there.
Is the advocate who comes in between?
So there.
No, you will also have a role in the mediation.
But she's an.
We'll open it. We'll keep it open for the advocates to also be present if necessary at the time of mediation.
So let it be kept for that. Where we could have negotiated the matter otherwise.
Very well.
But they.
Learned counsel for the respondent, comma.
Living separately, my lord, since 2019.
Very well.
So far the today's petition is concerned.
We are not on merits.
Oh.
The present appeal arises out of the dismissal of the appellant husband's suit for divorce. Full stop. Learned counsel for the appellant submits that the parties are living separately for quite a long time. Full stop. Learned counsel for the respondent initially submits that the respondent has some reservations with regard to mediation. Full stop. However, comma, upon a dialogue between the court and learned counsel, comma, the parties agree in principle to have a chance at mediation. Full stop. We make it clear that if deemed necessary, comma, the counsel for the parties will be permitted to be present along with the parties, but the parties themselves,
Oh, yes, yes,
along
of
with the
course.
parties, if necessary, during the mediation process. Full stop. Next para, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the option of mediation. Thanks. If it fails, then you can always come back.
Much obliged.
Thanks. Next.
My lord, item 6, my lord, I am for the appellant wife, my lord. We lost the suit for divorce, my lord, rather.
Divorce was granted against you.
Yes, my
You want to
lord.
go back. You may not after the mediation, we don't know.
I asked my client, he doesn't have any objection for mediation.
Very well. Who is appearing for the other side? Did somebody appear? We don't know.
No, not now.
Very will direct the mediation to be done
Yes,
upon notice to both sides.
Or if my lord grants me liberty, I can also send them a notice.
Please do that and send a copy of this order, and also the mediation committee has to give them. This the present appeal arises out of a divorce decree obtained by the respondent husband. For some next para, learned counsel for the appellant wife submits that the appellant has no objection to the matter being resolved by mediation. Full stop. Since none appears for the respondent at the time of call, comma, we request the learned advocate for the appellant to serve a server copy of this order on the learned advocate for the respondent, indicating the present order. Full stop. Next para. As the matter pertains to a matrimonial dispute, comma, it is deemed fit to be sent for mediation. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of exploring the option of mediation upon notice to both sides. They will also give a notice. You also serve a server copy of this order.
Deeply obliged, madam.
Next.
Yes, Mr. I appear for the appellant, my lord. Ex-parte decree was obtained challenging.
Wait, let the papers. Yes, ex-parte meeting.
Ex-parte decree was obtained challenging your preferred and appeals, my lord. Last occasion it came up to your lordship, my lord. I served a notice through email upon the husband as well as the learned advocate on record for the respondent, my lord.
তাড়াতাড়ি করুন, ওটা নিন। পরের ফাইলটা রেডি করে রাখুন, তা নাহলে একই জিনিস হবে পরের বার। Notice regarding this matter appearing before us.
Yes, today.
Despite a notice given by email, comma, none appears for the respondent. Full stop. A printout of the said notice given by learned counsel for the appellant be kept on record. Full stop. Next para. The matter arises out of a matrimonial dispute, and as such, there is scope of mediation between the parties. Accordingly, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation upon notice to both sides. Thank you.
My lord, I am for the respondent husband.
Respondent, yes, you appeared yesterday.
No, I am for the
You are for the appellant. Matrimonial?
matrimony.
Not possible.
Why not possible?
Decree granted on his favor on the ground of irrevocable breakdown of marriage.
Yes.
We have challenged that.
Just because you have a good ground.
Not that, but it's all about money now. I don't think
that is why precisely mediation is necessary, Salai. That is one aspect we have to decide, adjudicate, which may not be correct, may be incorrect.
No,
but mediation can.
There is no alimony application pending.
No, even then, no difficulty. Mediation is for that purpose only. You agree on a point, there has to be a common point. Go to mediation, Mr. Lairi. We have coaxed you sufficient.
We have a 40% success rate.
In mediation?
As a mediator.
You are a mediator. We won't refer it to you.
No, I know. I have a
so it will be more than, maybe more than 40.
Matrimonial 40%.
40% is quite high, Mr. Lahiri, actually.
I have 40%.
So you should be the last person to resist mediation.
But in this case, my lord, I think it will be a waste.
Why?
The amount will not.
We'll record that, but send it to mediation all the time. And we'll record your sentence. You have an objection to mediation.
Yes, my lord. The thing is, this one is not going on the last occasion, my lord. I have also
Why do you say?
Because, my lord, both the parties, my lord, they were separated. It's now more than 17 to 18
So why do you
years
say a mediation would not work out?
Because, my lord, during the point of
you have obtained the decree of divorce.
Yes, I have obtained the decree of divorce.
Yes, so you may decide to part ways also.
Yes,
the mediation may be to sustain that decree.
Yes, my lord. During that period of time when the matter was going on, my lord, a small mediation took place, my lord, where they've demanded.
Small mediation means?
Because between the husband and wife.
Not by the trained mediators. They are trained to do this.
Because the claim of money what they've demanded is more than crores, my lord, which is
that
not
is
possible.
The reason it should be mediated, because you have to come down. They have to come down a bit. You have to go up a bit.
My lord, in
So that can be done by trained mediators,
That is the only thing which.
not by us. We will adjudicate, you will not comply, an application for implementation, you will be threatened of going to jail, you will pay up a part of the amount, the same rigmarole we are going through every matter. Let us have a try at mediation, and if it cannot be resolved, then he'll come back to us.
But my lord, my client is a merchant navy, my lord. He is now traveling, my lord. I think
Yes,
he
that
in
this is the
somewhere-
matter where we commented you have to go up and they have to come down. She's in the
She's staying
airlines.
at Dubai.
I am in Dubai, he is merchant.
You fly, he floats.
Yeah.
So you have to come somewhere in between. You have to.
Only other thing, my lord, we had deposited the special mention record. The LCR has not come.
It will come.
In the meantime, my lord, kindly direct, because if it fails, otherwise we cannot prepare the paper book.
You have already put in. There is a direction by court.
Kindly direct the department to just send the notice that to.
What will the department do?
To bring the.
If you have deposited special message, it must have been sent. It might not be ready at the other end. Initially, there was some hesitation on the part of the parties to participate in mediation, as learned counsel for the parties, on instruction submitted that the matter may be beyond reconciliation. Upon query of court, it transpires that the primary friction point between the parties now boils down to the quantum of alimony to be paid by the respondent husband. The nature of the dispute, being a matrimonial one, and the fact that the quantum of alimony may be a bone of contention between the parties, justify all the more the matter to be the option of mediation to be explored by trained mediators. Accordingly, we deem it fit for the matter to be resolved by mediation. Hence, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation. Liberty, however, is given to the parties to mention the matter for inclusion in the list in the event mediation fails. It is made clear that the reference of the matter to mediation shall not in any manner impede the trial court records to be brought in the meantime by special messenger, since it is submitted by the appellant that special messenger costs have already been put in.
My lord, in that case, my lord, I will request one more thing, my lord. In case, my lord, my client is staying outside India right now, my lord.
It may be done online.
No, we have facilities for video conferencing.
Online.
That is it.
Absolutely. You cannot be compelled to come here for the
No,
mediation.
we have facilities for video conferencing. I have done.
Yes, you have done it in the mediation. If you are trained mediator, you have done it.
Grateful, my lord.
Thank you. 9, yes. Yes, Mr. Bhattacharya.
Grant.
Matrimonial.
Wife's happy, yes.
Wife's happy.
The husband has obtained a decree of divorce, my lord, the wife has challenged.
Oh, this is the matter where you are not there.
Mediation, lord, I am not standing in the way because the parties will do that.
You are standing in the way.
I am not standing in the way, my lord. I have
But objecting. Because you have got a decree.
both working, my
Who
lord.
knows whether that decree will survive?
No, no, she appeared, she filed a written statement. Thereafter, she did not choose to appear.
She did not.
Yes.
But there is always a chance of you losing in the appeal.
True. But only thing is, my lord, both my lord, managerial level, my lord, employees in State Bank of India. My lord, I have spoken to my client. My lordship would anyway
Sir
send.
Das, you never know what happens
But
in
we
a
can always explore
before
the
trained
possibilities.
mediators, Mr. Das. That is the training they receive. They receive training at the corporate level also. So they are managers, but the corporates themselves also sometimes agree.
Lordship would say.
The matter arises out of a matrimonial dispute. Next para. Should we record your objection formally? Initially, there was resistance on the part of the respondent, through counsel in the matter being referred to mediation. However, upon a dialogue happening between learned counsel and the court, it has been made clear that in view of both the parties being responsible and highly qualified persons, there is always a chance of mediation by trained mediators, by appealing to the reasonableness of the parties. Accordingly, we deem the matter fit to be sent for mediation. Hence, let the file be sent to the Calcutta High Court Mediation Committee for the purpose of mediation, with liberty to the parties to mention the matter for inclusion in the list in the event the mediation fails.
True.
Okay. Next. Ten. This is not mediation.
No,
Don't
no,
worry.
not mediation.
Yes. Yes, Mr. Haq. You
Yes.
started on the last occasion.
In Lordship, I handed over the updated record of rights showing that Forman Mondol's name has
Just
been
give us a back. Let us check up our previous order. Give us 2 minutes. Oh, you said that already it has been recorded. Their names have been recorded.
The heirs of Amina Bibi.
Yes, what do you say to this? Farman Mondal is one of the heirs.
One of the heirs.
My lord, out of plot number 4154, the recorded owner of the said plot, he was holding 56 decimals of land. Out of 56 decimals of land, by several deeds, your lordship, he sold 49 decimals of land in favor of the petitioners and their predecessor in interest. Lord, out of which, your lordship, as it be evident, Lord, from the record that's been supplied, it speaks of only 38 decimals of land. And out of 38 decimals of land, your lordship
This
kindly...
is a different and new cause of action, Mr. Haq. Your initial grievance before the tribunal was that they were not mutating your names, recording your names, right? They took a point that the tribunal said that no, first they took a point it was vested, then BLRO report result from that position. Tribunal said since that report has been given, therefore they have complied with the civil court order.
Vested portion was also not recorded. Otherwise, part of the land was vested,
Right.
recorded.
Therefore, your grievance was that there was no recording of your name at all.
No, your lordship, part of it was not recorded because, your lordship, it is already appearing in the record, part of the land. The 18 decimals of land, they initially said that it was vested. Subsequently, they came before the...
Regarding that, yes, regarding that part, it has not been recorded in your name.
No.
Yes, Mr.
Milord, it is unfounded. Lordship, Milord, I'm showing just 3 pages. Milord, may I just submit, Lordship?
Milord, one thing,
He is
another thing, your
claiming
lordship.
Amina purchased only 16.5 decimal of land. Purchase deed is very much annexed to this writ petition. How can he claim 36, 50? Where from does it come? Kindly see. Milord, may 3 documents.
3 deeds are there. 3 deeds
No,
out
from
of the same plot. Not kindly, your lordship. From the same plot, 4154.
I will
Milord,
show 3
part of the land being recorded, definitely. Milord, part of it was not recorded. Milord, they allegedly held that...
Mr. Kali, you file your affidavits and you disclose these accounts. We thought we'd be able to dispose it of, but...
No, Milord, may I shorten, Milord, subject to your lordship's...
we wanted to shorten, but there is a dispute.
No, he may prefer, his representation is very ambiguous, not annexed to this writ petition also. What I may suggest, subject to your lordship's correction, that let him prefer a comprehensive representation that we are all the heirs and successors to Amina Bibi entitled to this portion of land, and let it be considered by the jurisdiction of BLLR.
I'll do that.
Upon giving opportunity to all the persons whose name presently appear in the LR
Whoever is
record.
interested parties.
Yes, sir, lordship.
Lordship.
Interested parties will keep it more wide for you. Because
Kindly do that so that it can be decided.
The present dispute arises out of an initial representation by the petitioner for mutation of his name as heir of his mother, one
Amina Bibi.
Amina A-M-E-N-A.
No,
Bengali.
A-M-I-N-A. Amina Bibi. Next para. Although originally the state took a stand that a part of the land was vested in the state, subsequently a report was filed by the block land and land reforms officer indicating that the
It's a Rayati land.
It is a Rayati land and as such not vested in the state. Next para. The learned tribunal disposed of the matter on the premise that the BL and LRO has complied with the decree of a civil court which had been previously obtained by the petitioner, thereby declaring the right, title and interest of the heirs of Amina Bibi over the concerned plots of land. Next para. Learned counsel, a learned senior government advocate appearing for the state submits that the names of the heirs of Amina Bibi have been duly recorded in the records of rights. Full stop. However, comma, learned counsel for the petitioner objects to the same and contends that the recording has not been done in respect of all the plots owned by Amina and subsequently her heirs. Full stop. Next para. Learned counsel, learned senior government advocate submits in his usual fairness that since the initial representation of the petitioner was somewhat vague, comma, if a comprehensive representation is given disclosing the names of all the heirs and legal representatives of Amina Bibi as well as the exact plots in respect of which the names of such heirs are required to be recorded, mutated, comma, along with supporting documents, Mr. Huck, supporting documents also, along with supporting documents, comma, the respondent authorities shall consider the same and take appropriate action. Full stop. We find substance in such contention. Full stop. Accordingly, WP LRT 111 of 2025 is disposed of by directing the petitioner to file a fresh comprehensive representation, comma, clearly disclosing the names of all heirs and legal representatives of Amina Bibi as well as the particulars of all the lands in respect of which the mutation is required to be effected. Full stop. The petitioner shall, comma, along with such representation, comma, furnish copies of supporting documents in support of the claim of the said heirs and legal representatives for mutation in respect of the concerned plots of land. Full stop. Such representation shall be filed within 3 weeks.
Yes, Lordship.
You can file before that also. Within 3 weeks from date, full stop. If so filed, comma, the respondent authorities shall give appropriate opportunity of hearing to all interested parties and come to a reasoned conclusion in writing, thereby deciding the representation of the petitioner. Full stop. It is expected that such exercise shall be concluded by the respondents within what will be a reasonable time? 3 months. Within 3 months from the date of making of the representation. It is made clear that the rights and contentions of the parties on merits have not been entered into by this court with regard to the mutation. Full stop. No order as to cause.
Sorry, Mira, kindly use the word recording. Mutation will create problem.
Mutation, that we were thinking that mutation is not exactly applicable. যেখানে mutation বলেছি না recording.
I'm sorry.
No, why? Sir, that would suit your purpose.
My
No.
lord, Amina Bibi and 2 other persons are there, my lord, Horman Ali and Lukman Ali. They all are, my lord, they're the,
You cannot be your own heir.
no, not my, I had also purchased part of it, part of the land also. It is,
All the interested parties have to be given opportunity of hearing.
yes, that is
The process.
No, after hearing, my lord,
Heirs of
heirs
Amina.
of Amina Bibi and others, and the petitioner and his
And
Horman
all-
Ali.
Lordship, use the word.
Lukman Ali
You are
and
the
Amina
only
Bibi.
petitioner, right? You are one of the heirs of Amina.
Yes,
So heirs of Amina include you.
yes, Lord.
You will be given a hearing and all other concerned.
Lordship.
Yes, Lordship. Obliged.
You are the only person who gave the representation.
That I did, your Lordship.
Obliged, Lordship. And if you give a comprehensive representation, give an entire representation. I mean,
I will do that.
next. 11. Yeah, for the respondent. Oh, Mr. Go, acha that. Acha.
I have come up by filing this writ petition, Malad, to implement the order passed by the tribunal. Malad, that was of 21st May order. Malad,
Family court matter.
no, that tribunal matter. And Mr. Mitro was placing. Oh.
The lordship has passed
behind.
behind.
On 11th August, lordship passed that order.
Yes, Mr.
But we have sought for the implementation of the 21st May's order, my lord. My lord, both the writ petitions, my lord, the other matter has fixed on 22nd. My lord, let it be fixed on 22nd. This matter, present matter.
If this maintenance at all, withdraw it. Or sin the ground. What the order asking
We
for?
were seeking for implementation of this
Very
order
good. No.
only.
For the writ petition or the execution.
What was the order?
My lord has fixed the other matter on 22nd.
You're wanting an implementation of that it appears on 22nd.
No.
What is the order you are trying to implement?
Main order, main tribunal's order, with 21st May's order, my lord.
So how can you come up with a
No time limit. The ground is only no time limit has been fixed for BLRO.
Not for implementation of the
tribunal's order.
You have to go before the tribunal then.
That's right.
Go before the tribunal, will give you liberty.
If I am successful in this, the other matter, which my learned senior friend has.
He has challenged that main order.
Yes.
No.
Yes, that main order has been challenged.
Why are you being so loud, Mr. Thor? This is your problem. Yes.
Sorry. It comes automatically.
Check yourself. Have some restraint.
I'm sorry.
Yes. Yes. Mr. Mithu, what do you say to this matter being heard along with the other matter? This depends on that. It won't be implemented if you win. Wait.
Only ground is that the tribunal, while allowing their appeal, did not fix a specific time limit within which BLRO to carry out the implement order. That is the ground. So what the jurisdictional error, not fixing a time implies must be done within reasonable time.
No, you have challenged the parent order of the
parent order, and that's been rested now.
So let us take this along with that. This is dependent on if you win that, this in any event becomes impact.
This is not meant, but this is not mentioned with that written.
That will keep
because it is necessary for them. This order, if either affirms the order, then Lordship would have fixed the time.
Automatically, yes. Very well. At the outset, learned senior counsel appearing for the, you are for the respondent.
I am respondent.
In this, for the respondent. Number one, objects to the maintainability of the present writ petition. Full stop. Next para, learned counsel appearing for the petitioner submits that since in effect, this application, this writ petition is for implementation of a parent order of the tribunal which has been challenged by the present respondent number one in a different proceeding which is due to appear before this court on September 22.
Upon completion of affidavits.
September 22, 2025, let this matter be listed along with the same. First of all, we find substance in such contention. First of all, accordingly, let this matter be listed along with, what is the other matter? This.
That one. 126.
Be listed along with WP LRT 126 of 2025 on September 22, 2025 under the appropriate heading. First of it is made clear that the objection, that the issue as to maintainability of the present writ petition is kept open for being decided at the final hearing.
May I convey my thanks to my learned friends for not serving the copy earlier. My client saw the matter on the list and in panicky briefed all of us. Had he seen this petition, we would not have been briefed. None of us would have been briefed.
Right, I was going to ask you that actually. Why such a battery of counsel?
Because you didn't know. Because you didn't know what the petition is about. That's why.
This is the next time also, Mr.
At this time, no one would have been.
Yes.
Item number 12.
Why the expression changes, Mr.
I am at fault because he is less pugnacious.
Mr. Banerjee is there too in this matter too.
No, I'm.
The other Mr. Banerjee is there, obviously. Yes. Yes. Why are you at fault?
I'll just there was a service of a can. The can is in connection with the main matter which is pending before your lordship, arises out of my lord proceedings under 14M. I am a person who buys land, sells land. State says that at a particular point of time, the land has exceeded the 7 standard hectares ceiling limit under 14M. I have disputed that. I am saying I continuously buy and sell and create third-party rights. So this couldn't have happened. That was the point on which the first forum found against me on something which on the face of the record, according to me, is perverse. Their second forum was the appellate forum. The third forum was the LRTT. There other questions came up as to whether under 14T3 any land can be now taken over by the state in view of the fact of Bhumijibi's judgment, which says that if you take over that land, you have to pay compensation. There are no adequate provisions for compensation, and therefore that particular provision was held to be ultra vires. Now that is pending before the Honorable Supreme Court. Pending that, there is an order of cross maintenance of status quo, which happens ordinarily in all cases. In that case, their adjudication would also be hit by that particular cross maintenance of status quo at the relevant time. Be that as it may, I was not wanting to press that point as of now. Even on merits, I am in a position to show that the land which I hold is well within the ceiling limit at all material times. Therefore, the exercise of jurisdiction by the first forum was perverse. And the first order was perverse, appellate order and the LRTT's order are also consequentially perverse. Now, my lord, during the pendency of when the writ was admitted, an interim order of status quo was made. Status quo as regards possession, because I have bought so many properties, I hold on to possession of certain properties where projects are being developed. In certain cases, I hold on to land parcels where projects would be developed. So there's a status quo qua the parties. This writ petition got dismissed in default. Thereafter, it was restored. The dismissal order does not contain a vacation of the interim order. Therefore, restoration of the writ means automatic restoration of the interim order. Thereafter, the matter was heard. It came up before an honorable coordinate bench, where the honorable bench was pleased to do two things. It said, please fix any date according to the state, in which, according to you, there is an excess land in the hands of the petitioner, and give a balance of lands. There are two orders of the coordinate bench. One date was fixed at one particular point of time, 2008.
So and another is in a form of a report or something.
In the form of a report. We have reacted, rejoined. I can show on the face of the record that I am below the ceiling limit. In the meantime, what this CAN application has been required, because after the revival of the writ petition, in which the status quo order got revived, the state has barged into my property, put up a sign in a portion of the property saying that ei jomita Poschim Bongo Sarkarer jomi or something like that. Page 16. This has happened in the teeth of the interim order. Page 16 of the.
This was after the restoration of the writ petition.
This was after the restoration of the writ petition. In June 25. This is in June 2025, just 2 months ago.
May I?
I need protection from this.
Let us just see it. Yes.
It was the first order of injunction.
First order of injunction was.
I haven't got the copy of the application, my lord. Day before yesterday, my lord,
I've served this
paper books
6 weeks ago.
That's why, my lord, I said, my lord, I am in a difficult situation, because day before yesterday, I was
given no one represented the state. We gave them.
So it says বর্তমানে কুলেরদাঁড়ি গ্রাম পঞ্চায়েত কর্তৃপক্ষের অধীনস্থ।
We have taken it up. Kindly see. বর্তমানে আচ্ছা দেখুন মৌজা দৌলতপুর জেল নাম্বার সো এন্ড সো জেল they have made
বর্তমানে সাজেনসাজ গ্রাম পঞ্চায়েত
সরকারি খাস জমি।
ও আচ্ছা।
বর্তমানে কুলেরদাঁড়ি গ্রাম পঞ্চায়েত কর্তৃপক্ষের অধীনস্থ আছে। So they have done some machination by which they have made it অধীনস্থ. They have treated it to be সরকারি জমি and they have made it অধীনস্থ of the.
So what do you want now? Removal of this?
There was an order of status quo. Despite this has now happened. If they start constructing on it, then everyone will come and say that now it has been given to me. I am the municipality.
Will clarify that by the revival of this writ petition, status quo was revived. That cannot be changed. So that will help you. And
that will help you. And please, therefore, Lord, restrain them.
Remove
this and keep it in the position as it was. Admittedly, and there is no difficulty. I have.
But Mr. Zod doesn't have a copy of this application. Give a copy. Come back tomorrow.
Copy straight away.
Yes. What do you say?
Yesterday, no one was present. I have filed this application 6. কদিন আগে ফাইল করেছি আমরা 4 সপ্তাহ 6 সপ্তাহ হয়ে গেল।
You have given a copy to them previously?
Yes. Twice I have served. Again, they were yesterday absent.
Status quo part will right now clarify.
Yes.
There is no need to further reimpose
the status quo. But the status quo means that the possession should not be. And now that they are barged into possession.
Where is the dismissal order? Do you have a copy of the dismissal and the restoration order?
Yes.
Or have you annexed it here? Yes. The dismissal is annexed here. The restoration is also here. Let us see.
See, the dismissal doesn't have any vacating.
12:30. We'll clarify that the restoration. Learned Senior Counsel appearing for the petitioner submits that when the matter first came up for hearing, a coordinate bench, by an order dated August 23, 2017, had inter alia directed the parties to maintain status quo as on that date with regard to possession over the land in question. The writ petition subsequently got dismissed for default on July 14, 2023, without there being any specific observation that the interim order of status quo was being vacated. Hence, when the writ petition was restored upon recalling the order of dismissal for default on August 14, 2023, comma, it is submitted that there was automatic revival of the status quo order. Full stop. Even thereafter, comma, the respondent authorities are attempting to encroach upon the property and have put up a sign over the property, comma, a photograph of which has been annexed at page 17 and other pages of the present application.
11 June 2025, my lord, they did this.
Allegedly on June 11, 2025, indicating that the property belongs to the state, comma, which is in violation of the status quo order. Who's up next para? While controverting the submissions made by learned senior counsel for the petitioners, comma, learned counsel for the respondents, state respondent submits that he is not equipped with a copy of the application due to certain communication gaps with his client. Full stop. Next para. As such, comma, let the matter stand adjourned till tomorrow. Full stop. Next para. We make it clear that in view of the materials on record and upon a perusal of the orders passed earlier in connection with the present matter, comma, it is evident that by the order dismissing the writ petition for default, comma, the status quo order regarding possession as passed on August 23, 2017 was not specifically vacated, and, comma, as such, comma, the restoration of the same on August 14, 2023 automatically revived the status quo order. Full stop. Next para. No, this much. Come back tomorrow.
Lord, I've served him a copy of the
Yes,
application.
Take instruction, Mr. Dhar. What happened
Yes,
there?
I have already.
We may direct you to remove that.
Yes.
That whatever sign posted.
And my lord, regarding the main matter, my
Main
lord,
matter is ready for
can it?
any day. I'll tell you lordship why.
একদিন page.
No, ঠিক আছে, let him come
Lord,
prepared. But I'm saying
let it be posted for next week, at least for the main matter.
any day. I'm telling you lordship why. This main matter looks like a hearing matter, but it's actually tethering on a short point of whether there is.
It's very visible.
Yes, this is because of the bulk of the council. Maybe they wanted to replicate, my lord.
Bulk of the council, gravity of the council, and the matter dissuades us from fixing it next week or anytime soon. Status quo order is there. Be satisfied with that, and the bamboos and whatever they've given to you on the land,
That bamboo
we'll
will be
remove those bamboos.
unbambooed, right?
We'll unbamboo them. Yes. Yes, Mr. Rai.
But this is an application, my lord, for attached.
Yes, that matter which we are. No.
But an order was passed, my lord, for alimony pendent light. It was not complied. Not in
12 চলছে 13 লেখা ছিল না যখন আপনি দেখালেন this we are taking up can 4 wait
Can 4 hours.
acha they have not paid alimony
No, they, my lord, after
till May 2025, my lord.
let them complete, will come to.
My lord, initially there was an order, they did not pay, my lord, I paid for an attachment.
You are appearing for the third party name matrimonial suit.
State.
State?
Yes, last order.
They are, no, they are,
Matrimonial suit.
আপনাকে রিলিজ করে দিয়েছে তো।
না রিলিভ করে নি, লাস্ট একটা অর্ডার আছে দেখো।
There is an order directing the state to be implemented.
No, state not implemented. State was directed earlier to deposit the money thereafter.
He's an employee. You are the
Yes,
employer.
Yes. This is the latest report pursuant to lordship's last direction. দাঁড়ান একদম। Last direction, the entire money 1,98,000 বোধহয় না?
Last order, your lordship clarified, but needless to mention, Chandanagar Police Commissioner is not required to appear. Paragraph 10, order dated April 8, but perhaps Mr. Banerjee will be required to appear because I paid.
Yesterday matter was taken up.
ঠিক আছে,
And I said, Mr. Banerjee knows very well that regarding this matter. But what has happened, last order, your lordship is directed 1,96,836 should be credited in account of that particular lady.
That
We
part
have
is
done
over.
so.
That part is over.
না হয়নি ওভার আমাদের করেছি।
The entire arrears have been transferred.
Yes.
That was your stand. That's why we said that you need not
And
appear for.
the latest report, Lord.
What is the latest report? That you.
It is the latest report. 1,90,000, 96,000 we have already Credited.
That was the latest report on the last occasion also.
Yes.
No, no, no. That's
We recorded your submission. In the order dated April 8,
April 8, everything is.
8th April, paragraph 7, we have we are directed to transfer.
yeah, that is why 11th April it was done.
All right, fair enough. Fair enough.
And
So you have done that for that this report.
Yes. Only one application that can be supplied.
Copy.
Copy of the application.
Give a copy to them.
No, in this go have.
No, that is for other purposes.
This is
No,
yes.
yes, yes.
No, this
That's
is
right.
this is also now.
Very much correct.
We know.
Now, at that point of time, my lord, he was in service.
At this point of time, he is appearing.
Yes,
So
I need
he
Mr.
requires a
Banerjee.
copy of the application.
I need Mr. Banerjee when provided your lordship.
Give a copy of the
Because I
application.
have already said all the documents.
Because my lord, I
Documents regarding
paid for it.
material documents.
Yes, otherwise they will not. Entire documents we have sent it.
My lord, now I have prayed for attachment of the pension. Earlier there was an attachment of the salary. For that reason, Mr. Banerjee was one of appearing on behalf of the Chandanagar Police Commissionerate pursuant to the direction of.
Pension is paid by which authority?
Now, my lord, it is.
What the paying hands? Who are the paying hands?
My lord, that my lord, Mr. Banerjee will be able to clear.
Yes, Mr. Banerjee, take instructions, come back tomorrow. I will, before that we'll hear them. Yes, you are still not paying current alimony.
He paid for 2 months. Thereafter again, my lord.
I have paid rupees 20,000 till May 2025.
2 months.
Acha.
Then I have paid rupees
May
7,000
2025.
May 2025.
Since June 2025, pay by tomorrow.
June.
Since June till date,
He
pay
is
by
in
tomorrow.
hospital at present now.
Why?
In ICCU.
ICCU?
ICCU.
After passing of the order?
No, my lord. Since
Why ICCU?
Since 8th of
Due
this
to whom?
month.
You or the court? Either of the two has to be either of the court because you directed to pay alimony or you charged your fees, whatever. What is the reason? What is the reason for this ICU? We are not very convinced with this. Who gave you this?
I have collected from his attendant. No one is in his house.
Oh, attendant means hospital attendant or
no. Who look after in his house?
this is a photocopy of what? Discharge.
Discharge. This is the visiting card in which
Acha.
hospital he is admitted.
Visiting card to documents গুলো দেখাও just এগুলো দেখাতে হবে তো।
When should you take up the matter? Tell us what happened to him. What has happened to him?
Actually, he is a chronic patient of kidney problem.
But he's getting his pension.
At the rate of 30,000 and 69 and odd.
See, we'll direct you to file an opposition.
File objection in this regard. Kindly allow us to 3 or 4 weeks.
4 weeks we cannot. He'll be discharged soon. If it's kidney, he'll be discharged. After whatever procedure is done, we'll give you 2 weeks time. You take
See,
instruction, draft and get it prepared within 2 weeks, we'll give you 2 weeks. Mr. Rai will give them 2 weeks. We'll give you them 3 weeks actually.
As your lordship, please.
Mr. Banerjee, Learned Counsel appearing for the state, files a report indicating that the order of this court has been complied with by crediting the arrears of alimony to the tune of rupees 1,96,836 to the account of the petitioner wife by way of arrears of alimony payable by the respondent husband. First of next para, Learned Counsel for the petitioner submits that although the arrears have now been cleared, further arrears have been left unpaid, since payment was made only up to the month of May 2025.
June and July, they have paid 7,000.
7,000 and?
Only 7,000 each month.
What was the direction?
20,000.
First up, it is further submitted for the months of June, and July 2025, an amount of rupees.
Pension. At present now, he is getting pension.
An amount of rupees 7,000 has been paid, which is much below the directed amount of rupees 20,000 per month. For some next para, Learned Counsel for the respondent husband submits that since the respondent's income has decreased and he is now living on pension, the amount of alimony ought to be decreased. However, since there is a standing order of payment of alimony, unless a proper application is filed for alteration of the same by the husband, the said order stands and it is the incumbent duty of the respondent to go on paying alimony at the rate as directed by this court, that is rupees 20,000 per month. Full stop. Next para, learned counsel for the petitioner seeks an attachment of the pension to the tune of the alimony amount payable by the husband. Full stop. Learned counsel for the respondent, however, hands up a photocopy of a purported visiting pass of one Mercy Hospital situated at Park Street, where the respondent is allegedly admitted due to kidney problems.
My lord, kindly fix it for hearing, final hearing.
Full stop. Next para. Accordingly, on the prayer of the respondent husband, the respondent husband is directed to file affidavit in opposition to the to Can 4 of 2025 within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing on September 15, 2025. Full stop. Next para. Although the respondent husband seeks the appeal itself to be fixed for hearing, it is a settled principle of law that unless all amounts of alimony are cleared off by the spouse who has been directed to pay the same, the matter cannot be disposed of finally. Full stop. Thus, the no directions of hearing of the appeal are being passed at the present.
My lord, kindly give them direction to.
As far as the state is concerned, your lordship kindly.
What amount have we
Insofar
have
as the state is concerned, further appearance of the state is dispensed with.
Give the blast.
Grateful, my lord.
Thank you. If you want, you can file an alimony. You can file an application for decreasing the alimony. That's your call. Mr. Rai, did you direct paper books to be created, to be filed?
Well, everything is complete. Everything.
Other things, sir. We cannot take up the appeal for final hearing unless you clear up the alimony. That is settled principle.
But this is an application under section 10 of the Guardians and Wards Act. That is the custody of child. My lord, defects are so far.
Section 5 has to be.
Yes, my lord, I have already filed and another.
It has to be decided first.
No, my lord, there is some defects. The remarks is some defect is not till removed.
What defects?
My lord, that is written so far. I am aware all the defects has been removed, but there is a remark in the cause list, and therefore.
No, there must be something in it.
Yes.
Yes, the name of the trial judge. Unnecessary recital of lower court details.
My lord, to cut short this matter, my lord,
these details have to be removed.
Yes, my lord, that is it.
Remove that will right now give you liberty.
Yes, my lord.
This is appearing for the first time, the section 5.
First time, my lord.
Serve a copy and come back. We'll direct you to serve the copy.
Yes, my lord.
The petitioner shall serve a copy of Can 1 of 2023 on the respondent, indicating that the application shall be listed for hearing on when should you keep it? Today we are on 13th. On August 27, 2025.
Yes, my lord, another aspect is this, my lord.
When the petitioner shall file an affidavit of service to that effect. Yes.
Another aspect is that the address given by the respondent, my lord, in the trial court. So many letters we are sending over them, but there is not finding. I do not know what is true.
No, that you will have to find out. We can only direct you to serve copy.
Yes,
leave is granted to the learned advocate on record for the appellant to carry out the necessary rectification by deleting the unnecessary details regarding the trial court's order in the first portion of the cause title of the memorandum of appeal during the course of the day. This from and onwards upwards.
Yes,
this you will have to delete. It will start from in the matter of laltum only.
Yes, I'm doing it here now, right?
Yes. And serve copy. If you can find out the correct address, you find out. Yes.
15 minute, I am for the petitioner.
Yes.
The appeal filed by the wife, my lord, decree of divorce granted in favor of the husband. Now, kindly see the last order, my lord. I have already served upon.
Last order is none appears for the parties.
No, on previous, my lord, there is an order for service. So I have already served, but the husband left without any instruction.
Then you have to serve afresh. What is the can for? Stay.
Can is for application for stay.
Yeah, achha.
In compliance with the order, I have already served, but the husband left without any instruction because
Husband obtained a divorce decree.
yes,
You have served at that address.
yes,
Ascertain the current address will grant an injunction in the meantime.
I can yes, kindly hear me, Lord, my can and grant an
No, we'll grant an ad interim
Yes,
order.
that is
Stay we don't grant, we'll grant injunction.
yes,
The application is for stay.
yes.
The appeal arises out of a decree of divorce obtained by the respondent husband. Full stop, next para. Although the application is couched in the form of a stay application, comma, we are not inclined to grant stay of the impugned divorce decree, comma, in view of the same being a judgment in rem and having wider ramifications than those restricted to the parties. Full stop, however, comma, since otherwise the appeal will be rendered infructuous, comma, we hereby restrain the respondent husband by an order of injunction from contracting any remarriage, comma, if not already done, comma, till disposal of the application. Full stop, next para. The petitioner files an affidavit of service and an envelope indicating that the attempted service on the husband has failed and the envelope has returned with the endorsement addressee left without any intimation. Full stop. However, comma, it is pointed out that the husband had obtained the decree by describing his address in the plaint before the trial court, comma, which is the same as the address to which the envelope was sent. Full stop, next para. Be that as it may, comma, the appellant is directed to ascertain the present address of the respondent and as and when so traced out, comma, to effect the necessary correction to the cause title of the memorandum of appeal and the stay application. Full stop, next para. The application shall next be listed on August 25, 2025 for passing final orders. You please try to ascertain the address in the meantime.
May I send it to the Lord his place of posting? He is
Yes, wherever. If you can find it out, you just effect the correction. We have given you blanket liberty. Do that in the memorandum and the application, and you can serve another copy also. আরেকটা line add করে দিন তো। In the event the current address of the respondent is located by the appellant, in the meantime, comma, the appellant will be at liberty to serve afresh at the said address by indicating the next returnable date and file an affidavit of service, file a fresh affidavit of service on the returnable date.
Good.
Thanks.
Will answer the respondent number 1. Writ petitioner, respondent number 1. For the appellant, my lord, may I humbly beseech one thing, my lord. As per the last order of this honorable court, my lord, I have prepared the supplementary affidavit. But today, my lord, I have not brought it, my lord. It is necessary for.
You have given a copy, must be.
No, my lord. The copy have.
Why?
My lord, it's my mistake, my lord. My lord.
You are enjoying any interim order?
No. Only one thing, my lord. I know my learned senior friend has difficulty. It's 2023 order. If your lordship once looks at the order impugned before your lordship, it's nothing but my property is being utilized by the PHE department by a water supply project. This honorable court in 2023 directed the PHE to consider as to my land has been utilized or not. After a lapse of, my lord, 1.5 years, they have preferred this appeal. Now tomorrow is the date fixed before the honorable single judge, my lord, in a contempt proceeding. And they are repeatedly asking for adjournment, showing that this.
What is your ground of appeal?
My lord, the land, my lord, it does not exist even, my lord. My lord, I have the
So
document.
you'd say that in your representation.
Yes. My lord, the latest document, my lord, shows the land in question mentioned by the writ petition and in the petition, my lord, does not exist even. Does not exist.
You are directed to assess within 45 days whether LR plot number 188 measuring 0.03 acres of land has been utilized by you for construction of Sakrail water supply scheme. If aforesaid plot is found to have been utilized, then further directions.
My lord.
You should consider the representation and say that the land does not exist or whatever. No, there is nothing in the appeal. We'll dismiss the appeal.
But may I get
it is not a judgment. Intra-court appeal does not lie. No right or interest of the parties have been decided. See, go and face the contempt.
I get a 1 day accommodation, my lord. 1 day accommodation.
No. I will dismiss the appeal right now. Learned counsel for the state stroke appellants, comma দেবেন না, submits that although a supplementary affidavit has been prepared pursuant to the previous direction of this court, comma, the same is not with him and requires some more time to and seeks some more time to file the same. Full stop. However, comma, we find that the direction was given as long back as on June 3, 2025, and as yet no copy thereof has been served on the respondents. Full stop. Learned counsel appearing for the respondents points out that there is no merit in the appeal at all. Full stop. It is submitted that by the impugned order, comma, the learned single judge merely directed the disposal of a representation of the writ petitioner stroke present respondent and to assess as to whether a particular plot of land has been utilized by the Public Health Engineering Department for construction of Sakrail water supply scheme, and if so utilized, comma, past further directions. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the impugned order is not amenable to an intra-court appeal under the latest patent of this court, comma, since no rights of either of the parties have been decided at all, and thus, comma, the same does not come within the within the definition of within double inverted judgment, double inverted clause, comma, which is a prerequisite for an order to be challenged in intra-court appeal. For sub next para, the innocuous nature of the impugned order is merely a direction on the executive engineer of the Public Health Engineering Directorate, comma, Howrah Division, to assess whether LR plot number 188 measuring about 0.03 acres of land has been utilized by the said department for construction of the Sakrail water supply scheme, and if found to have been so utilized or for allied purpose, comma, the executive engineer is to directly send the proposal for acquisition upon giving the petitioner an opportunity to produce her documents in support of her claim under the provisions of the appropriate statute. Full stop. Next para. It further transpires that the present application has been mentioned in the teeth of a contempt proceeding taken out by the writ petitioner stroke present respondents for non-compliance of the said order of the learned single judge. Full stop. Next para. Upon a bare perusal of the impugned order of the learned single judge, comma, for the reasons as recorded above, comma, we find that there is no scope of interference in the appeal. Full stop. Whatever contention is sought to be raised now by the respondents appellants, comma, to the tune that the said land does not exist within bracket which is disputed by the writ petitioner stroke respondent, bracket closed, comma, could very well have been reflected in the reasoned decision taken by the present appellants in their consideration of the representation as per the direction of the learned single judge. Full stop. Thus, comma, for the reasons as stated above, comma, Mat 828 of 2025, along with Can 1 of 2025 and Can 2 of 2025. What is Can 2?
Can 2 Miller is Can 1 is Section 5 Miller.
Section 5
has been allowed.
No, not yet. Miller, your lordship allow it on consent.
Accordingly, Mat 828 of 2025 along with Can 2 of 2025 are dismissed without any order as to cost. এই পুরোটার আগে সংখ্যা একটা জিনিস করে দাও, পুরোটা যা বললাম তার আগে। Can 1 of 2025 is an application for condonation of the delay in preferring the appeal. Full stop. Having heard learned counsel, comma, we are satisfied that sufficient reason for the delay has been made out, and accordingly, Can 1 of 2025 is allowed on contest, thereby condoning the delay in filing the appeal. Go and comply with the order. You show before the learned single judge that we have only dismissed the appeal today, so that you get some time to. Mr. Mukherjee, cooperate with them on that. Within 1 week, at least, consider that. This was the matter we were mentioning. So now called on, move your matter.
Lord, in this matter, my lord, Mr. Bhattacharya, Milan Bhattacharya is leading me, my lord. He is coming, my lord.
You mentioned for
my lord,
the ground of urgency.
My lord, he is coming, my lord. So, my lord,
Let him come, you move the matter. Yes. Certified copy you have not filed?
No, because my lord, order passed on 8th, my lord.
8?
8th August.
So by now you should have got it.
Friday.
Last Friday. Yes.
Last Friday, certified
Matter
copy.
was heard at length on last Friday. And my lord, I believe the lordship had granted leave because of the urgency to my learned friend.
You?
I'm for the Union of India, assisted by Mr. Bosch.
No, you said what have you done due to the urgency?
My lord, the encroachment drive is fixed on 18th of August. That is on Monday at 10 a.m. by the railways.
That is the urgency.
That is the urgency.
Yes. What is it?
Lordship, kindly see the my lord, order influence passed by the learned trial court, my lord, first.
We will not see the entire order. Tell us what is your best point.
My lord, my best point is.
What is the writ petition for?
My
You are
lord,
an encroacher of railway property.
Yes, we are residing, my lord, we are, my lord, doing our business, my lord, after forming a cooperative society, my lord, and after taking permission from the my lord, railway authority. Lordship, kindly turn to page, dekhi.
Take your seat.
My lord, Lordship, kindly turn to.
No seat. Yes.
Right.
No, Mr. Banerjee, that's too far away.
My lord, page 78 first, my lord.
70?
78.
Right. There are two paginations. Which one should you look?
My lord, because my lord, it,
No, the larger pagination. Which should we?
My lord, at the top, my lord.
All are at the top. There are 4 sets of paginations, not 2.
78.
Anyway, 78. Is it a letter date, communication date 21st of February?
21st.
February 2006.
My lord, my lord.
Yes. Yes. What is this?
My lord, this is, my lord, this letter issued by the railway authority.
You are given a license at any point of time.
My lord, license means, my lord, this, my lord, the railway authority, my lord, allow us to.
You are on the platform.
No, not platform.
Railway land.
My lord, this is, my lord, spearable land. Here it is mentioned, my lord, in this letter. In connection with the above, the address to the petitioner number 2 issued by the railway authority. In connection with the above, an application has been received from Sujoy Malik.
Sujoy Malik is petitioner number 2.
Petitioner number 2.
Chief promoter means?
Chief promoter, wherein it has been proposed for doing business on the spearable railway land.
On cooperative basis.
On cooperative basis in the vicinity.
Proper documents were sought for. Then?
Thereafter, we applied the next page,
Yes.
We applied for registration or cooperative society before the ARCS, the Hooghly. 2 letter issued. This is very vital. Lordship, kindly first turn to page 81.
Yes.
Lordship, this is page 81, last paragraph. You being, this letter written by the Assistant Engineer Cooperative Society, Hooghly, to the Divisional Manager, Railway, Eastern Rail, Last paragraph, you are being the cancelling authority of the land of the eastern area, west side of Chandan.
Understood. So they require no objection from them for you to register. Then
next, Lordship, kindly turn to page 79. It is the reminder. Same letter written by the ARCS to the railway authority.
So then what happened?
Thereafter, we have got the registration of our cooperative.
After that?
Now in the impugned order, they.
What is the writ petition for?
Writ petition. Writ petition for eviction notice challenge before this honorable court. That is, my lord.
Where is the eviction notice?
Yes, my lord. I am coming. Eviction notice, page 112.
But you are a squatter of the land.
My lord. My lord.
You are not in lawful possession.
My lord. We are land of the railway authority. There is no
doubt.
There is no doubt.
So you are admitting because you have written to them.
We are admitting. But the authority concerned in such a manner cannot oust us. Second thing, my lord, another writ petition which is pending before
According to you, what should be the process? This is not public premises. This is not governed by public premises, public land unauthorized occupants. The Railways Act has its own provisions.
My lord.
You may at least argue that you are not an encroacher, but you are an encroacher.
My lord, we are, my lord, doing our business, my lord, last, my lord, about 40 years, my lord. So, my lord, after, my lord, getting permission from the railway, they are, my lord, specifically stated that this is a spearable land. My lord, this is this.
That does not give you a right, Mr. Rahman.
I am not claiming my right, but a writ petition is pending. That is, my lord.
Another writ petition, a different writ.
My lord, before, my lord, this authority in the year 2001 to 1997, they, my lord, issued a, my lord, eviction notice. That was challenged before this honorable court. Honorable Justice Satyavrat Sinha, as his lordship then was, my lord, pleased to pass and, my lord, stay order. That was continued up to 2006. Thereafter, my lord, after getting permission from the railway authority, we are doing our business.
Permission was never given.
My lord,
Permission was they sought for documents from you.
documents. Now,
Let us see the learned single judge's order.
Lordship, kindly see, my
Let
lord,
us,
for
let
a
us-
moment.
because you are asking us to do that.
My lord.
Lordships will kindly see page 111, then see the learned single judge's order.
Acha, very well. We'll see page 111.
Page 111.
This is the order challenged before the single judge.
My lord. No, this order was challenged in another writ application.
That is pending.
It's pending. No interim order. No order has been
Because-
passed in that writ application.
Because, my lord, only, my lord, on the pair of both the parties, the matter was adjourned. Thereafter, my lord, determination changed.
But if
the,
this
my lord,
order remains, then what?
So, my lord, this order remains, it is challenged before this honorable court. That is pending also.
No stay order.
No, my lord, that we have not got any stay order. That
has
I have
also-
submitted.
And that has also been taken care of by the learned judge, learned single judge.
Lordship, kindly see, my lord. Yes.
You are given a hearing.
My lord.
Then?
My lord, in such a manner, the order was, my lord, passed by the railway authority.
You have no right whatsoever on the land, Mr.
My lord, Lordship, kindly
Rahman.
consider one thing, my lord.
Yes.
Lordship, kindly see the impugned order, my lord. Last.
You are trying to say that they are taking advantage of their own wrong by not giving you the permission to have it registered and not giving no objection and taking advantage of that.
My lord, the trial court, my lord, taking the view that the letter of the ARCS, my lord, my submission before the learned trial court, that when the railway, my lord, the ARCS, my lord, requested the railway authority to give no objection. Thereafter, my lord, that was, my lord, the second time reminder also sent. After few months, we got the, my lord, the registration under the, my lord, Society Registration Act.
Mr. Rahman, suppose you have a registration.
My lord.
What right do you have on the land?
My lord, our right that, my lord, in such a manner, in what manner, my lord, such a manner, they are, my lord, trying to oust us, my lord.
Even if you have a registration of your cooperative society, that cooperative society, they never gave you even a license to squat on that land. You wrote to them that on this sparable land, permit us to stay. But they never gave you that permission. Yes, Mr. Bhattacharya is here. Mr. Bhattacharya, they never gave you.
That building, my lord.
Oh, I'm sorry.
I am old man now.
You will never be old.
Lord, in
Mr.
this case,
Bhattacharya,
I have two points to argue before you, lordship.
Yes.
Kindly. My lord, I have points. This particular lands in question was acquisition by the railway authority five decades ago. Railway authority did not utilize this particular plot of land for the 5 decades.
Did not regularize means?
Utilize.
Utilize, not regularize.
Not utilize.
Utilize. Then, my lord,
you don't have the locus standi to challenge that.
we approach the railway authority that we want to start
business.
We'll pay revenue to you.
Yes.
Because and Rally Authority asked us to form a cooperative society.
They told you to give documents, proper documents.
Yeah, I will just indicating the point.
Acha, very yes.
Then we proceeded for the formation of a cooperative society according to their direction. Then we formed a cooperative society. Then we applied. They kept mum for all years, for 16 years. In the meantime, in 97, they wanted to evict us. We came before this honorable court. Honorable court passed order of status quo. Thereafter,
Status quo, stay of that notice.
of the there at that time no notice, nothing.
Oh, status quo order was passed.
Because the structure.
Acha.
Structures.
That status quo order is
At that
still there.
time, no notice was issued.
That status quo order is still there.
Yes.
Subsisting or disposed of.
No, writ petition has been dismissed in the meantime 2007.
So that goes.
Now I am not making submission. Thereafter, my lord, the authority concerned, can we see after 16 years, issued a notice to us that Rally Authority kindly consider, my lord, notice was issued by assistant engineer. Then we came before this honorable court. This honorable court said that you make a comprehensive representation, they will consider. And in the meantime, not to disturb. We made, rejected. We came again. High Court said that you have not given proper opportunity, set aside. Again, hearing. That hearing, again rejected. We came before this honorable court. This honorable court passed an order now that order is affirmed. Rejection order is affirmed. And suddenly passed an order, learned judge, directing the police and all these things. Your Lordship has gone through the order. Your Lordship, can you see? Suddenly, learned judge switched over the matter to the defense.
What right do you have to stay on the property? You have been given a right of hearing also. What is the present right you have on the land? You are a squatter.
Now we are in possession. Now my first submission of law, subject to Lordship and sanction.
Yes.
It is a central government property. Railway is the part of central government. Now, railway is bound by the provisions of public premises, eviction of unauthorized occupants.
I was expecting this is public land.
Public land.
62 Act. But the Railways Act have a provision. We'll ask your learned friend on that.
Let them show. I have tried to find out.
No, there is a provision there anyway. But there is a judgment also that which says that anyway.
Illegal property, not land. I brought the book. Illegal property.
You can argue on that before
not land.
You can take the wind away from their sail by arguing on that first.
The law kindly
they will obviously refer to that section. So before they do, you just explain that section to us.
Illegal property.
Kindly see, Your Lordship. Kindly see the. I've given 2 books.
No, this is there. This is there. This is the premises. Are these premises or land?
Then section 4.
This is not applicable, Mr. Bhattachaji. If it is land, then there is a separate act for this. There is a 71 Act for public premises. There is a separate act called the Public Land Eviction of Unauthorized. That is 1962 Act. This is land. This is not premises. Is there a premises on that land or this is a vacant land?
The vacant land.
Then Public Land Eviction of Unauthorized Occupants Act 1962 is there.
This is public premises.
It's a different act. This governs public premises. Premises is defined here.
land.
It's a structure.
Public land.
Public land, eviction of
that
unauthorized.
is public land.
Otherwise, same
Another
land.
Documents Act 1970, another book is there.
1962 Act.
No, that is West Bengal Act.
That is there.
West Bengal Act, we are not governed by the West
But then
Bengal
this is not applicable because this is not premises, this is land.
Act. Now, kindly see, this is the section 4. Kindly see section 4. Kindly see section 4. 4, kindly see.
No, you are right, Mr. Mr. Bhattacharya. The premises means any land or any building or part of building. You are right. Yes. Otherwise, this should be applicable. If there is no.
My lord, there is no notice.
No, in the Railways Act, is there any provision? Please check up the Railways Act.
In my book, I could not find out. In my book, I could not find out.
Because you are for the petitioner, your petitioner's books will be different from the.
I could not find out.
Yes,
if my learned friend can assist, that can be done.
Exactly similar matter, my
Because
lord.
your lordship
with regard
remember-
Mr. Bhattacharya, Mr. First, let him complete. Mr. Bhattacharya, then your contention is that unless the regards of this act are followed, first formation of first opinion that it is unauthorized occupation, and then notice to you, and this,
then appeal.
they
I have
can.
a right of appeal also.
Section 9 is yes.
Yeah.
So,
Now,
very
another
well.
submission I am making.
What is the other submission?
The notice which has been issued.
Yes.
Kindly see, very interesting notice. Very interesting notice.
Why interesting, Mr. Bhattacharya?
Eviction comes show cause notice. Page 112. Eviction, show cause notice. Show cause notice will precede eviction. Not eviction will precede show cause notice. This is a bogus notice. This notice, how I moreover kindly see.
Railways are were never famous for linguistics.
As such, my lord, on
As per
this
the order of the
particular point, on my submission before your lordship, the learned judge, while affirming, said, no, give them police. This is not my list.
You are taking an
My
undue advantage of that extra word introduced by.
Now kindly see your learned
Very well,
judge.
we'll set aside the police portion, but retain the eviction portion.
Learned judge is very much overzealous. Kindly see. Consequently, kindly see page 118.
Yes.
Consequently, WPA is hereby dismissed. Before parting with this, court direct the respondent to proceed with the eviction such as why? What is the necessity of the learned judge to say police authority in everything, such and such,
That may be superfluous.
Why this has been done?
Maybe superfluous. So,
This is
Mr.
not
Bhattacharya,
jurisdiction.
it boils down to
It is not in
the applicability of this act.
First of all, my
If
lord,
this act is applicable,
no, first of all, my lord, I want promissory estoppel. Can you see the
where is the
letter
promise?
of the railway?
Show us that promise.
Yes, promissory estoppel.
Where is that promise, Mr. Bhattacharya?
Yes, sir. Promise, can you see?
Page 78, 21st of February letter, which was placed by Mr.
I am
Rao.
showing a lordship letter. Page 78.
Yes, yes. This is not
Page
promise.
78.
There was no consensus ad item. They only said you were requested to please submit proper documents regarding formation. They did not agree to anything or promise to give you this land.
My lord, can you see in we have made an application to the railway authority
Yes.
for development of shopping complex and railway land through cooperative societies.
Yes.
In connection with this, railway authority, can you see who has written the letter? Divisional engineer.
Right.
In
See the
connection
second
with
paragraph.
the above,
Second paragraph, Mr. Bhattacharya.
an application has been received from Sri Sujoy Malik, such and such. In this context, you are requested to please submit proper documents regarding the formation of registered cooperative society to the undersigned for taking necessary action at this end. We form the cooperative society. Kindly see next document.
Yes.
My lord, page 84.
That is also admitted in at page 111.
Yes.
That is the speaking order. So-called speaking order.
Then, my lord, kindly see, they issued a letter at page 90, eviction notice. My lord, the writ petition which we moved in 1997, kindly see one thing, my lord.
Yes.
They are aware of the entire proceeding. We got the order on 24th January 1997. They issued this particular letter 90 after 16 years, after 26 years. What is the urgency?
But
after 26 years, they issued the notice.
Bhattacharya, there is no question of urgency. Whenever they give a notice to you, they can at any point of time give a notice.
No, only submission before your lordship, because
yes.
Now railway say there is, railway has not said there is any urgency.
No,
railway has not.
That logic would be applicable whenever they give you a notice. You will say there is no urgency. At some point of time, they can give you a notice. If you are a squatter,
I am come before your lordship under Article 226
Yes.
India. Your lordship will kindly consider the conduct of the railway authority also.
So 2 points, Mr. Bhattacharya, primarily. Apart from that superfluous portion of the impugned order whereby police help was granted, that we fully accept.
Yes.
Could not have been a part of the initial order of eviction.
My submission before your lordship.
No, one is that Public Premises Act, this act has not been complied with, although it is applicable, which is a very good ground otherwise if they don't show anything else.
Yes.
And also promissory estoppel in view of the letter dated 21st of February 2006, where they said that for taking necessary action, you produce proper, this necessary action you said is intended to give you some permission. And thirdly, they waited for so long. 16 years after this,
and they
11 years,
they are not very much
yes
conscious about their eviction, in as much as it took 26 years. 26 years to issue a notice after the High Court's order. High Court's past order 97. 24th January.
When was that writ petition dismissed, Mr. Bhattacharya?
2007.
2007.
97.
No, 97 to dismissed 2007.
Oh, it was dismissed for default 2007.
This is a default, not dismissed.
A default, no?
No, dismissed.
It was dismissed in 2007.
Dismissed.
Even then thereafter they issued the notice in 2023. Kindly consider their conduct. Whether railway is very much serious about the matter to evict us and to demolish our structures. Now, my lord, thereafter another submission I will make before your lordship.
Yes.
After this order passed by the Honorable High Court, after the order passed by the Honorable High Court is the contested order, page 91. On 16 February 2023, the order was passed by them after our representation on on 23rd of March 2023, page 105.
21st March.
No, 21st of March 2023. That means on 23.
That did 2 rounds of litigation before this court and ultimately decided by this.
Now they
111.
order present notice. Kindly see, my lord.
1st of August 2025.
Present notice has been issued on
1st August.
1st August 25. Page 112.
No, another submission I have got before the lordship. This particular order.
Yes.
Thereafter we moved the Honorable High Court.
After the speaking order, 111. Yes. What happened?
Page 106. Page 106. 4th July 2023, High Court passed an order. Can you see?
Yes, 111 is after that.
Set aside the order.
Yes, and directed hearing to be given to you.
Thereafter,
we have crossed that stage, Mr. Bhattacharya. We have come to page 111.
Two revisit
petitions, we know that.
An order was passed on 17/10/2023.
Rejecting your representation.
This is the impugned order. Thereafter,
Yes.
This order was challenged by a writ petition.
So what happened to that?
In that writ petition, the both parties made a prayer for adjournment. কোথায় গেল এটা?
But no stay was granted.
Both parties prayer for adjournment, made a prayer for adjournment.
Both include you.
Yes, including the railway.
Both parties include you, Mr. Bhattacharya.
Yes.
You had the urgency. They did.
Including the railway. Can you see the order?
Dekhi, Dean,
Can you see the order? Both parties.
both includes you.
Railway also.
They didn't have the urgency.
Railway also. Railway also said that adjourn the matter.
You should have asked for stay. No stay was granted.
Since the matter is being adjourned, question of because
you had also asked for adjournment.
That day we have done impression. Since the railway is taking time, there is no
So
question
there
of
is
stay.
the position is that there is no stay. That is pending since 2023.
My
Till date, you have not moved for stay in there.
Stay may not be there, may not be prayed for on the ground. Since both parties are seeking adjournment, I have not made a prayer for.
That is no ground at all.
No,
From 2023, you could not mention the matter.
May not accept my submission, but this is my humble submission before your lordship. Now your lordship can
Even accepting your submission, this was passed on April 2024. This order, both sides praying for adjournment. We are in August 2025.
Subject
1 year, 4 months.
Just to interrupt, my lord, for just for
There
once.
is no urgency before the railway.
Let him.
When the matter was just one, when the matter was taken up on the first instance, on the first day, none appeared for the petitioner, and on the second day, the matter was adjourned on the.
We are not very serious on that. So, as Mr. Bhattacharya says, that he will make his submission, but it's on us to decide.
On prayer of both the parties.
We have seen that, Mr. Bhattacharya.
Yes.
Please proceed ahead.
I'm not.
Any other point?
I'm not repeating before your lordship because this is not the court of repetition. Because your lordship, only one submission I am before.
Yes. This is absolutely not.
Focus notice. Kindly, I am giving emphasis on this.
We have recorded 3-4 points. Correct us if you are wrong. One is promissory estoppel. Second is 1971 Act, Public Premises Act. Third is that they waited for so long, even after 2007, the dismissal of the writ petition. In 2023, they are giving you a notice, which in addition to your promissory estoppel in the same line. And lastly, this eviction cum show cause notice, it is vague. On the basis of this, you cannot be evicted because cum show cause, the moment they say that, they did not give you that opportunity of showing cause.
Because they say we should show cause.
That opportunity was not given, and
But
that was sought to
they
be.
say no, eviction should be first, show cause later.
Later.
You die first, then you reward.
Retrospectively,
Retrospectively,
but then you have
you
to
die first.
You have to do a seance,
Then
and
reward.
Planchet has yes.
This is
So let Mr. Dev now.
notorious application of
Now let Mr.
by the railway authority.
Let the railways.
Another submission.
What submission?
Another submission whether
Yes.
assistant engineer
Has the power.
page 111. Assistant engineer can decide the issue.
But that
Submission
is
before
subject matter of challenge in the other writ petition. That
page 111. We have challenged in the writ
that is,
petition.
you have done nothing from 2023 after filing the writ petition.
Now, before the appeal court, I can make this submission on question of law. Whether assistant engineer is the proper authority under the.
So we'll also consider whether irrespective of this rejection, they have a right to evict.
Because
this was
law. Under this law, it is the state officers. No other than a state officer can.
No, this is not a notice under section 4.
I cannot say because this particular another law is there. I do not know that particular law.
That will ask.
That he will assist you, lordship. If there is any law, let him show.
Well, Mr. What is it? Take a seat. Let us check.
Last submission.
You have made your last submission.
Oh yes.
Yes, Mr.
With reference to page 112.
Another submission. My lord, last submission. When a writ petition is pending.
Yes.
Writ petition is pending. Whether this particular punishment can be imposed upon us.
Mr. Bhattacharya, you have taught us the law. What is the law on that?
I am showing a judgment of Justice Alok Gupta.
We'll have to defer.
Your lordship knows the judgment.
Settle position. If pendency of an appeal itself
judgment.
Mr. Bhattacharya, no, cite it formally.
Your lordship knows the judgment.
We may not.
74 CLJ.
Decided.
relying upon
Mr. Bhattacharya,
English decision.
pendency of an appeal even cannot operate as a stay under the law. So how can pendency of a writ petition? You have taught us the law wrongly then. Either you taught us law wrongly or you taught Justice Gupta wrong law.
Now,
Our must have been appearing in that matter.
Our High Court said,
74.
my lord, a notice was issued for suspension.
Milandai বুঝিয়েছি.
Thereafter,
No, you are not there. You are not there.
Advocate's notice was given.
Yes.
Thereafter, they issued departmental proceeding. Then we came in contempt. The Honorable Court passed an order that it is a contemptuous. And officer concerned has been punished. Kindly see the judgment. The English
Any particular paragraph, Mr. Bhattacharya? Which
yes, only 3 paragraphs. Only 3 paragraphs. My lord, it is a long paragraph.
No, the relevant portion you can.
Paragraph 12.
Yes.
Paragraph 12. But your lordship knows the judgment because your lordship has vast knowledge in this. Then, my lord, the honorable Justice Gupta, Gupta in paragraph 13, quoted from the English decision saying that it is a contempt. And the officer concerned, government officer, was sentenced to fine of rupees 500, and that was paid. Contempt was found. They complied with the contempt orders. No appeal. My submission is when a writ petition is pending, known to them whether this particular order of eviction can be passed, while they are intending to issue show cause, but they pass the eviction. And our High Court said, no, give the police protection, police force, RPF, all force should be provided to the railway. What is this going on in the trial court? Trial court has come to the arena of the railway, RPF. What is this? The appeal court should take into consideration this aspect of the matter.
Yes, Mr. Yes.
Let me come to the factual aspects first. My lord, with regard to the order impugn, my lord.
Under which law have you given this notice?
My lord, with regard to the public premises, with regard to that, I will have to come back before your lordship. With regard to that, whether
you are not prepared on the Railway Act. There has been detailed argument on this Railway Act, but we held in a different matter, I had held that this applies only to persons who have immediately come, not on persons, I mean, who are in occupation of the land for quite some time. Railways Act, that provision, that is for temporary encroachers. Like suppose people coming onto the platform, a huge crowd coming on the platform, you can remove them immediately without notice. But not for people who have been permitted by you to stay there for quite some time. So they have made out a prima facie case for hearing the petition.
Permission. At no point of time, any sort of no objection was never issued on part of the railways.
No, but you have to comply with the law.
My lord,
you cannot show any law to us as of today.
My lord, with regard to that act, I will have to come back. But my lord, even as a very similar matter with regard to Chandannagar railway station had come up, and my lord, the Honorable Apex Court was of the view that these sort of encroachments should not be allowed.
That is very general and vague.
My lord, this is with again a cooperative society. They had formed a society.
Society. দেখি কি বলেছে
সুপ্রিম কোর্টে গিয়েছিল।
This was with regard to a different railway station, Chandannagar. This is Chandanpur. Different.
The principle remains the same.
Principle is on this. that this sort of squatting, even if it is continuing, this should not be allowed.
একটা extra copy চলে এসেছে এটা ওনাকে ফেরত দিন স্যারকে একটা you want to miss it?
This is not similar matter. This is not similar matter.
না, না,
Not similar matter.
আচ্ছা, so public premises এর এটা করছে কি?
কোথায় do not have license. Under the scheme presently the shops, it is an admitted fact that they do not have license. No, proposition of law is laid down.
No, man, I'm not on that. It's a different railway station, but I'm on.
No,
I'm
railway
on the-
station different does not mean the law will differ. But
Absolutely.
this is not a whether an adjudication of a point.
Well, it's railway squatters that was not allowed.
We'll grant them stay for a limited period.
Well, we will in any way. I will have to come back with regard to the public
You
premises.
go through the Railways Act, there is a provision and there are judgments on that.
My lord.
At least I know of some one or two judgments which were cited before me. I also passed an order. But you have to go through those because all of those are binding on us.
My lord. My lord, the stay which was in 99, that was just for 1 week. That which my learned senior.
That in any event that has been dismissed.
My lord. Third round of litigation, my lord, eventually the final order was passed in page 111. That was challenged. No interim order as of now has been passed by the writ court.
The present appeal has been preferred against an order dated August 8, 2025 in WPA 18067 of 2025, whereby the learned single judge, while dismissing the writ petition preferred against an eviction cum show cause notice dated August 1, 2025, issued by the respondent authorities against the petitioners, also directed police assistance for the purpose of carrying out the proposed eviction program, thereby evicting the present petitioners. For next para, learned senior counsel appearing for the appellants submits that the impugned judgment is bad in law on several counts. Full stop. Next para, by placing reliance on a communication dated February 21, 2006, issued by the divisional engineer within bracket ARBN bracket closed stroke Howrah, it is argued that by the said letter, on the application of the petitioners to do business on the sparable railway property in dispute, the petitioners were requested to submit proper documents regarding formation of a registered cooperative society to the author of the said letter, double inverted, for taking necessary action, double inverted close, at that end. Full stop. Thereafter, the petitioners obtained a registration of their cooperative society and thereafter moved the railway authorities for necessary permission by giving a representation. Full stop. Initially, the representation was turned down without passing any reasoned order, whereupon a challenge was preferred before this court, and pursuant to a direction of this court, an opportunity of hearing was given to the petitioners, and thereafter an order was passed on October 17, 2023, thereby turning down the said representation of the petitioners on the specious ground that the railway authority had not given permission to the petitioners for registration of their cooperative society, thereby doing a volte-face on the stand taken by the railways by their letter dated February 21, 2006. Full stop. Next para. Although previously an order of status quo was granted in respect of a prior writ petition, the said writ petition was dismissed for default in 2007. Full stop. However, the railway authorities sat tight over the matter and waited till August 1, 2025 to give the impugned eviction cum show cause notice. Full stop. Next para. It is next contended by learned senior counsel for the appellant that the premises come within the definition of the said expression as given in section 2 within bracket small c of the public premises within bracket eviction of unauthorized occupants bracket closed act, 1971. Full stop. Next para. As such, the petitioners are covered by the said act, and in the event the railway authorities were of the opinion that the petitioners are unauthorized occupants within the contemplation of the said act, a prior formation of opinion in that regard under section 4 of the act had to be made, and thereafter only upon a notice and proper hearing could an eviction order be granted, that too by the estate officer designated for such purpose, which has not been followed in the present case. Next para. Thirdly, it is argued that the impugned notice dated August 1, 2025 is captioned as an eviction cum show cause, double inverted মধ্যে পুরোটা, notice, semicolon. However, no opportunity to show cause was given at all to the petitioners before implementing the same. Next para. Also, the authority of the assistant engineer in passing the order dismissing the representation of the petitioners has been challenged in the previous writ petition. However, despite the same having been adjourned on one occasion on the prayer of both parties, by completely overlooking the pendency of the same, the eviction notice dated August 1, 2025 was issued. The appellants rely on judgment reported at 1974 CLJ, page 465, wherein it was held that an act of taking steps in a disciplinary proceedings despite the pendency of a writ petition challenging the action of the respondents would invite the contempt jurisdiction of the court. Next para. Learned counsel appearing for the railway authorities opposes the arguments of the appellants and submits that no question of any promissory estoppel arises, since at no point of time was any consensus ad idem reached by the parties or any promise made out to give the land or allot the same to the petitioners. Next para. It is also argued that the 1971 Act is not applicable in the facts of the present case. Next para. Furthermore, in the pending writ petition in connection with the refusal of the representation of the petitioner bearing WPA 28289 of 2023, an adjournment was sought by both parties, including the present appellants. Moreover, on an occasion prior to the said date, that is April 8, 2024, the petitioner had failed to appear although the respondents were present. Thus, the inability of the appellants to obtain a stay order in connection with the said writ petition, which is pending since 2023, does not automatically operate as stay of all proceedings in respect of eviction of the appellants. Next para. Upon hearing learned counsel for the parties, we find that a sufficient prima facie case has been made out by the appellants for the appeal to be heard on merits. Apart from the question of applicability and the interplay of the 1971 Act and the Railways Act, as to which of the said statutes is applicable, we also find that prima facie the learned single judge overstepped jurisdiction in directing police help to implement the eviction drive of the railway authorities, beyond the scope of the writ petition itself, thereby passing virtually an execution order along with the parent order dismissing the writ petition. Full stop. Next para, that apart, comma, we also have to take into consideration as to whether the representation given by the railway authorities to the appellants, insofar as considering the proposal of the appellants for setting up business on the property subject to the appellants getting registration of their cooperative society has to be looked into. Full stop. Thus, comma, a sufficiently strong prima facie case for grant of stay has been made out. Full stop. Accordingly, we grant stay of operation of the impugned judgment dated August 8, 2025, passed in WPA 18067 of 2025, as well as stay of operation of the eviction cum show cause notice dated August 1, 2025, comma, which was the subject matter of challenge in the writ petition, till September 15, 2025, or until further order, whichever September 30, 2025, or until further order, whichever is earlier. Full stop. The respondents shall file their affidavits in opposition to Can 1 of 2025 within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing next on September 11, 2025. বইটা ফেরত। হ্যাঁ? হ্যাঁ, আনিয়ে নেবেন আর দুটো আপনার বইটা পাতলা বইটা বেরিয়ে চলে যাবে। Next.
But in this matter, I appear for the respondent number 5. Only yesterday I have been served with the notice stating that the matter will appear in the list tomorrow.
What has happened, my lord, in the presentation form, in the presentation form, the date was filled up 14th. Accordingly, we served notices that it will appear on 14th. My lord,
Then we cannot take up the matter
the
today.
state is also not here, so
No, we cannot take up.
my lord, kindly takes it up tomorrow, my lord, because
Tomorrow we'll take up.
I'm grateful.
Learned counsel for the respondent number 5 submits that counsel received notice of the matter only recently and could not get prepared. Full stop. Learned counsel for the appellant, comma, in his usual fairness, comma, submits that that in the computer form, comma, the listing date was given as tomorrow, and as such the matter will be taken up tomorrow. Full stop. Accordingly, let the matter stand adjourned for the day. Anindita?
I'm grateful, my lord.
My lord, at my instance, the matter has been listed.
But
you have changed situation, my lord. Yesterday, this is relating to my lord land acquisition matter. Yesterday, my lord, so far the National Highway Authority is concerned, they have demolished the front portion of the land, my lord. Therefore, today, my lord, I am praying for time because, my lord, service has also not been completed.
You are for?
But I am appealing for the National Highways Authority, my lord.
To accept this notice, my lord, day before yesterday. I sent by hand. They have office have also received refused. Therefore, I have to send by post.
If they are appearing, you can serve.
Yes, I can. But my lord, kindly let it go out of this for the time being.
Why go out of the list?
My lord, this because of this change situation, my lord, I shall take things.
So you have challenged what?
I have challenged the acquisition, but my lord, land may be taken, but not by the old act, by the new act. This is my complaint.
It relates to compensation.
Yes.
So why
whether
do
it will be under 2013 Act or will be, my lord,
Yes.
1948 Act?
Why are you asking for adjournment? What has been done?
We shall take instruction, my lord, from the client, my lord. There is some talk of.
My lord, may I submit, my lord? My lord, I am appealing on behalf of the National Highways Authority, my lord. On yesterday, my lord, that demolition has already been carried out. My lord, the physical possessions, my lord, in the presence of the petitioner, my lord, has already been taken over.
So
My
that
lord,
is why Mr. Mahathir.
my lord, my humble submission, my lord. In that case, my lord, I presume, my lord, he may be filed one CAN application, my lord. My lord, this CAN application, my lord, at this moment is becoming infructuous, my lord. This is my humble submission.
File it, otherwise, unless they file a CAN application, how can you
I
say?
think, my lord, the application is incomplete. He has annexed the document of my affidavit in opposition, not the matter of the pleadings.
Only few annexures has been.
Few annexures have been annexed.
All this by supplementary affidavit itself.
Our preference is always for the underdog. Since so many people are opposing Mr. Mahato, we go for Mr. Mahato. On the prayer of the petitioner, the matter is at the outset, the National Highway Authorities take an objection that the writ petition,
My lord, my lord, though I don't have the copy, my lord, but I presume, my lord, he may be asked for.
that can 1 of 2025 might have become infructuous, although no copy of the application has yet been served on the National Highway Authority. So learned counsel for the other respondents also submit that complete copies of the application has not been handed over to them. So in any event, learned counsel appearing for the petitioners seeks an adjournment and submits that proper service has not been effected on all the respondents. Hence, learned counsel for the writ petitioners further submits that in view of changed circumstances, since a portion of the property has been demolished, the matter may go out of the list for the time being. Thus, then why shouldn't we make it?
In fact,
infructuous?
kindly see the prayer. Kindly see the prayer. Not to demolish. If demolish, then what?
My lord, that is my submission. My lord, kindly.
Is there? Their portion is a different portion.
Not to demolish.
Demolishing boundary wall that has been demolished.
My lord, I have this document.
Mr. Mahato, you have been dispossessed and it has been demolished.
There, my lord. The front portion where my lord Kona Express will be widened. But so far the back portion is
Very well.
concerned.
Accordingly, let the matters go out of the list with liberty to mention for inclusion in the list in the month of September 2025. It is made clear that the pendency of this writ petition shall not, the pendency of this appeal or the connected application shall not prevent the respondents from taking any course of action which they are entitled to in accordance with law. So this Mr. Mahato protects them also.
After all, it's a public project.
Definitely.
My lord,
So you have clarified in
I
the
have these documents, my lord, that the demolition has been already carried out. My lord.
Submit. And we have made it clear that's why that this shall not prevent anybody from doing anything.
My lord, I am requesting my landlord to make the proper application because some of the documents.
Mr. Mahato was not aware of the demolition before this. Otherwise, he would have made a proper.
My lord.
And he will make. That is why he is asking for time.
His client is present, my lord. In his presence, my lord, the demolition has been carried out.
এটা না আরেকটা দিয়েছে কেএমডি এর হয়ে দিয়েছে
Yes. 20, yes. Mr. Mahato, you are there? Oh, Mr. Ghosh is there. Yes, Mr. Ghosh and Mr. Yeah, you are there. Oh, Mr. Day, on your ground it was fair. Yes.
Lord, this writ application has been directed against an order passed by the West Bengal Land Reform Tenancy Tribunal.
Yes.
Lord, that order is at page 70.
Mr. Ghosh, this will take some time. Should we release the other matters?
It will take some time.
There is any chance of this flopping midway? Let us be sure. For 10 minutes, we'll hear you at least. Then if you find, then we'll release it. Sometimes what happens, something is missing. Mr. They will say, no, that document is not with me.
No, my lord.
He'll not say that.
Only, my lord, a limited question is arose in this matter, my lord.
Not the
very limited.
Yes. But the subject matter was challenged in the original, in the writ petition, that is in 1995. That is under section 14T6 of the West Bengal Land Reforms Act. Lord, for determination whether the property, some properties which are Devottor properties, which should be included in the ceiling limit of the who dedicated the land, the Rayat. Lord, that is the third notice. Prior to that, by 2 other proceedings which has been held upon inquiry that Devottor property, it has been dedicated. Devottor is not separate property and Devottor, the deity is a separate Rayat. According
Devottor is a separate property means it cannot be included within your holding.
Yes. Whether or not the third notice is maintainable, we challenge it before this honorable court.
Third notice means?
That is the third time. Earlier 2 proceedings which were held that those properties are Devottor properties dedicated long before 1946, dedicated to deity.
And therefore you are not the owner of those, therefore
Yes.
those cannot be taken to be your land.
And the deity is a separate right.
So you have now challenged the notice itself.
Notice itself was challenged, but that has been, this is subject matter in a writ petition before this honorable court.
Then?
Lord, kindly see, my lord, that notice it was by Justice, Honorable Justice N.K. Mitra, as his lordship then was stayed all further proceeding.
Stayed further proceeding?
Yes. But
that is still pending?
No, my lord, that writ petition, after coming into operation of 1997 Act, West Bengal Land Reform Tenancy Tribunal Act, it was transferred.
Right.
To the tribunal.
Hmm.
But thereafter, tribunal passed an order and held that yes, it is maintainable.
Third notice?
Third notice is also maintainable. And
my lord, different act is there.
Oh.
1953 Act, and my lord, last notice is 1956 Act, West Bengal Land Reforms Act. And previously, my lord, West
55.
Bengal Estate Acquisition Act. Different act, independent act.
Oh, that is not correct. No, I am telling you. But second proceeding is
Yes.
under West Bengal Land Reforms Act under same provision. First one is under 1953 Act.
What was the logic of the tribunal? That you have challenged that here?
Yes, Lord, no, the tribunal has said under section 14, subsection 5, they can do it.
14M subsection.
14M.
That is the subject matter of challenge here?
Yes, 14M. Under section 14M5.
Land Reforms Act din to?
It can be done anytime.
West Bengal Land Reforms Act? এটা রুলস রুলস থাক তার তলারটাই ল্যান্ড রিফর্মস অ্যাক্ট ওনাকে দুটো ওটা রুলস বেরিয়েছে একটা এই বিজলি এই কালারে দেখা যাচ্ছে এখান থেকে ঠিক আছে সরি ইয়েস মিস্টার ঘোষ
Yes.
Mr. Ghosh will release the other matters. Other matters are
yes,
released.
yes.
Yes, next.
Well, your lordship can see section 14(6)(m). 14(m), subsection 5.
M.
14M.
Yes.
Lord, with
ওই কালকের হ্যাঁ ওই সিলিং এরিয়া এটা নেই বেশিরভাগই তাই পন্ডিতা ছিল না বলে কালকে টাইম হয়েছিল কালকেই হয়ে গেছে
Lord, yesterday your lordship been that's what discussed.
He is the culprit.
Lord, your lordship section 14M, ceiling area.
Ceiling area.
Lord, your lordship can you see that is the ceiling area. What would be ceiling area? Single member, Lord, more than single up to 5. Thereafter 0.50 hectares each. And Lord, kindly see to section 14M 5. That has been included.
এই আগেরটার সঙ্গে কেমন রেখেছিল ঠিক আছে এটা আছে না এখানে রয়েছে Yes, 14M.
14M subsection 5.
14M subsection 5.
But it has been included by way of amendment. It was brought in 1981 amendment with retrospective effect 7th August 1969.
Right.
Lord, what is the provision? The lands owned by a trust or endowment other than of a public nature shall be deemed to be lands owned by the author of the trust or endowment, and such author, trust and such author shall be deemed to be a riot under the Act to the extent of his share in the said lands, and the share of such author in the said lands shall be taken into account for calculating the area of lands owned and retainable by such author of the trust or endowment, and for determining the ceiling area for the purpose of this chapter.
Mr. Ghosh, the previous second notice, as you say, it was rejected when? That was set aside when?
That second notice, Lord, your Lord.
Before 1981?
Yes, I am telling you. Lord, this was decided on second proceeding 50, page 53. 53 to 54, not just I am telling.
Yes, you check up.
53. Lord, this was done on 15th March 1991.
This is page 53.
Lord, your lordship, it starts at page 52. 52 it starts. Last. That is 15th March 1991. After this amendment came into operation.
That notice was regarding under the West Bengal Estate Acquisition Act.
No, Land Reforms Act.
Then no, page 54 mentions absolute Devottar in the EA Act.
Yes, Devottar. It has been held upon inquiry. Lord, 54, same thing held in under the Estate Acquisition Act also. The earlier notice. That order I am showing, Lord. Your lordship can see that
It was
order.
also after 1981.
No, that is much earlier.
That is not much. That is irrelevant because of 1981.
Yes.
But this order was passed after this.
After coming into operation of this act. Therefore, whether this notice is
operates
tenable
as res judicata.
Yes. And it has been held, though earlier, Justice Ajit Kumar Sengupta as his lordship then was that it can't be done.
What can't be done?
This second time. Second time. But there must be some finality of the matter. And here, my lord, kindly see, and your lordship has gone through that judgment of Paschim Banga Bhumijivi, paragraph 189.
That we have forgotten. We don't recollect like you.
No, not I am not so. But
we don't have such memo.
But your lordship is well
convinced. No, we generally know Paschim.
It's
annexed here.
No, not annexed. I am providing.
We are handing over.
Challenging the vires of this act, not the Amendment Act, writ petition was filed, single bench was turned down. The division bench, Justice Sinha, Satyavrata Sinha, and Honorable Justice Satyanarayan Chakraborty.
Paragraph you said?
189, straight away go. 189. Paschim Banga Bhumijivi. It is reported 1996 volume 2 CLJ page 285. Volume 2 CLJ. 285.
This was held in respect of the Estate Acquisition Act.
Land Reforms Act. Virus.
In terms of the provision of West Bengal Estate Acquisition Act.
Yes.
189.
Yes.
Oh no, but you are right.
Yes.
In the context of 14M.
Yes.
Yes.
14M.
Yes, absolutely. Absolutely. If you continue from para 187.
Yes.
It was 14M that was being.
Yes.
Analogy was drawn probably from Estate Acquisition. Right.
And this transfer is not within prohibited period. It is much earlier. That is 1946. This endowment was done. And on earlier inquiries, under the Estate Acquisition Act and the Land Reforms Act, the second notice, he held that income is provided. And that is also immaterial, whether income is utilized for other purpose. Honorable Apex Court has held that is immaterial for this purpose.
No, only one exception was carved out in para 190.
Yes.
Only in a given case where a private trust has been created in order to avoid sealing,
yes,
the appropriate authority may become entitled to tear the veil.
Yes.
No such case has been made out in your case.
Not.
In your case,
No,
there is
no,
no,
no. This is
allegation
not
that you did it for the
No,
purpose of.
But it is much before.
Much before,
Yeah,
exactly.
yes, 46, 1946.
1946.
Yes.
But 14M has not been expressly held to be ultra vires.
No.
But this proposition was laid down.
Therefore, not in view of this.
So three grounds. One is that principle of res judicata in general. No second notice is permissible under the Act.
Yes.
Thirdly, this idol is itself a riot.
Yes.
Therefore, this Poshimanga Bhumijivi.
Yes. But he can the idol can maintain a separate ceiling.
Yes, if that be so, then it would be contradictory to hold that it will be counted in your land.
Yes.
Because the riot it's a riot in its own right.
And what section 14M also said, other institution 7 hectare. That is the limit.
Yeah, that is there.
Yes.
Now that in any event applies.
Yes.
And what is the notice? Just let us, before parting with the matter, let us see the notice and the order of the tribunal.
Lord, I have seen the notice. The notice is at page, third notice at page 62. Page 62. Well, can you read this notice? He is just sitting over the earlier order. State didn't challenge that earlier order in any proceeding. State didn't challenge that order.
That was an order by the tribunal itself.
Yes, yes.
High Court read petition.
That order was by revenue officer itself.
By?
Revenue officer.
Revenue officer itself.
56, 55 Act.
Yes.
Lord, this
so
is
how did the tribunal overcome this
Lord,
point?
kindly see, Lord. Tribunal has given this power. He has not looked into that, this Humijivi and other provision.
Because he did not place.
Lord, Mr. Banerjee are good there.
Which Mr. Banerjee?
Mr. Vidyut
Oh.
I think
Mr. Roy is Mr. Banerjee.
Yes. Lord, your Lordship will get that order at page. Yes. At 170. 170.
Right.
It starts.
In this petition before the tribunal, you had challenged that notice.
Yes.
Page 62 notice.
Article 226 of the Constitution, writ petition was filed, Lord. Ultimately, it was transferred upon coming into operation of 1997 Act.
The tribunal has proceeded on the premise of 14M.
Yes.
Without considering Bhumijivi, and says that it has to be considered public or private. Therefore.
Yes.
And yours was a private trust apparently.
Not exclusively for the Devotor, that is the religious.
Religious, but still it is of a private nature, not a
yes.
public, not,
No,
not
not
that
public.
everybody has. But you are relying on Bhumijivi.
And yes.
Very well. Let us hear Mr. De. Let us hear. Yes, Mr. De.
That if your lordship will see, my lord, his contention is, my lord, is this order is totally, my lord, passed on the basis of my learned friend challenge. He is not now wanted to go through the entire order, my lord, as because entire order is clearly stated what is the fact of this case. For that reason, my lord, he did not want to go into the merits of the case. But if your lordship will see, my lord, that first contention of the my learned friend was that whether we can change or overcome in West Bengal Estate Acquisition Act 1953, my lord, there is a provision of, my lord, Devotor property. My learned friend, according to him, my lord, that Devotor property was declared at that time by the West Bengal Estate Acquisition Act. Now, when we came, my lord, after West Bengal Land Reforms Act, previously, my lord, that ceiling area 25 acres, agriculture, 15 acres, non-agriculture, 5 acres, my lord, homestead. Now, when we came into the 1955 Act, that the West Bengal Land Reforms Act, my lord, it was, my lord, reduced the provision. Previously, now, my lord, only 7 hectares is the total highest limit, my lord, and 7 hectares. Highest limit, my lord, 7 hectares.
Standard.
Standard hectare. And, my lord, in the West Bengal Estate Acquisition Act, my lord, there is no any provision about the inquiry or other things, my lord, in Devotor property.
That was about the first notice.
Yes, my
but
lord.
the second notice was.
Now, my lord, I am coming. Now, my lord, if your lordship will see 14T6. Power has given to 14T6. The revenue.
Yes.
This part was not in the West Bengal Estate Acquisition Act.
No.
Now we introduce a new act, that is the West Bengal Land Reforms Act, and here introduced well 14T6. Now what is 14T6? The revenue officer on his own motion or upon any information may, after giving the person interested an opportunity of being heard, inquire and decide any question as to whether any trust, endowment, or institution is a public or private nature or of exclusively religious or charitable in nature, or both, and any question of title incidental thereto, as may be necessary to determine the extent of land which is to vest to the state under section 14S by examining the documents, if any, or by taking into account the following. My lord, previously, my lord, those 1, 2, Roman 1, 2, 3 was not there. But now my learned friend said that is not very necessary. But now, my lord, see what is our domain. The actual user of income or usufructs of the lands. We can go into that. Mode of cultivation, pattern or utilization of the land, and share of income or usufructs of the land appropriated or enjoyed, or the area of such land occupied or enjoyed by or on behalf of the manager Sebayet, my lord, here is coming manager, Sebayet, or any other person managing the trust, endowment, and institution. My lord, there is a power was given to the revenue officer to all those parts, see, my lord. Previously, those things was not taken, and he can't, my learned friend can't challenge or anything else, my lord. For that reason, my lord, reason order to that effect.
Mr. They one question to you.
Yes, my lord.
Here, subsection 6 of 14T, you are right, it has been introduced in 86. But this is relating, because the language is own motion or otherwise revenue officer having information, etc. Inquire and decide any question as to whether any trust, endowment, or institution is of public or private nature or of exclusively religious or charitable character or both, and any question of title is incidental thereto, then it is qualified.
Yes,
as may be necessary to determine the extent of land which is to vest in the state under section 14S. So this entire inquiry is centered around the inquiry as to whether this should vest under section 14S.
Yes, my lord.
Now to vest under section 14S, 14M5 becomes essential if it's a trust.
5 and 6.
5 and 6 definitely.
Yes, my lord, your lordship, I may come 14.
Because ultimately it boils down to relates back to 14M5.
Yes,
For
my
that, because 14M5 excludes private public trusts. That
Yes,
is
my
the purpose for that inquiry. This is to be done.
Yes, my
If
lord.
it is found it is a private trust,
Then
upon
it
this
is be included in the
14S
yes, my
comes
lord.
because 14M.
Yes, my lord.
Now, Mr. Ghosh, by citing Paschim Banga Bhumijivi, Mr. De, has hit at the root of 14M itself, 5. 14M5. So
Not
if
6.
now there is no distinction as per the judgment between private and public, in both cases, Rayat is the DT,
My lord,
then this inquiry will become redundant.
My lord, that judgment 14M
Does not direct say. Direct say.
It says that the 14M is ultra vires,
No.
and that is pending before the Honorable Supreme Court, my lord. So
That is pending for an eternity. That is the difficulty.
that is and my
Everybody is taking as of today, Mr.
lord, and my lord,
that Paschim Banga Bhumijivi still holds the field till it is set aside by the Supreme Court.
whatever may be that, my lord, that is not in the verbatim of the in the verbatim of the
judgment,
my lord, never said that 14 T5 and 6
not held
is
to the ultravirus specifically.
Yes, my lord. So, my lord, still such.
But what would be the
Yes, my
effect
lord,
of those paragraphs?
My lord, your lordship will till such the act is prevail. My lord, that judgment is not said that the act is not will not prevail. As because my lord, what act said? What 14S? My lord, 14M5, 14M5, my lord, the land will go automatically to the original layer. And now 14T6, my lord, notwithstanding anything contained in subsection 1, a trust or an institution of public nature exclusively for a charitable or a religious purpose, or both shall be deemed to be liar. My lord, if the charitable purpose, he will get the individual 7 actors.
Achha, what about the other question, Mr. De, regarding a second notice? Can you reopen that again?
My lord, if you are 14,
Because there was an order which has been placed,
my lord,
page
only
52
one
to
question,
54.
my lord, 14,
Yes, yes.
T9, my lord, I want to place then, my lord, only one thing.
Yes, yes, definitely. Mr. De, let us come back tomorrow.
Yes, my lord.
Let us come back tomorrow.
Yes, ma'am. We must.
Wait, let us pass the order in this first. Hard in part for further hearing tomorrow. এটা hearing এর উপর দিকে দিয়ে দেবেন একটু পাঠ হারে দিয়ে দেবেন যাতে হয়ে যায় হয়ে এসছে
Yes, my lord. We are not taking much time.
No, none of you are taking much time.
Yesterday, your lordship heard the matter, item number 25.
That has not been marked pattered.
No, my lord,
Now we'll not make it pattered retrospectively. Yes.
Item 24, my lord. My friend and I both are in difficulty, my lord, tomorrow.
Tomorrow?
My lord, can it stand over, my lord, to Tuesday, my lord, subject to the court's convenience?
24 টা একটা order record করুন 24 টা বোর্ডে কোথায়
We are for the appellants, my lord.
The matter is taken out of turn on the mentioning of learned counsel for the appellant. Full stop. Learned counsel for the appellant submits that the matter be adjourned till
Tuesday, my lord.
Till August 19, 2025. Full stop. Since learned counsel for both the parties are present, comma,
my lord, the respondent is not there. So my advocate on record and myself, my lord, both of us, my lord, are in
No,
difficulty.
then you cannot. Keep somebody tomorrow. Ask for it.
I'm so grateful.
Ask some of any of your friends. Tell it to
Very well, my lord. I'll request my lord, someone to take my name and remind
Yes.
Unfortunately, item
No, when your name was not recorded. Order has been uploaded. What can we do now?
Milord, unfortunately, item number 26, I pray for the same, but Milord turned down their prayer. I am also going, Milord.
You prayed for?
Prayed for time flow at one day, at least not.
When it is called on tomorrow, ask any of your friends
Milord,
to ask.
Milord.
Unless it is very seriously opposed to, generally don't
Milord.
refuse adjournments. If
Milord.
nobody is there, we may dismiss for default after 2 or 3 days. But if adjournment is short and there is no serious opposition and on serious grounds, we generally grant adjournment.